please. The court all rise, please. And order in the court.
Please be seated. Daryl, is this on? Thank you. I appreciate it. Good morning, ladies and gentlemen. Thank you all for being here. Let me begin by saying, ladies and gentlemen, that this is a tragic situation. And I certainly am sympathetic to the defense's case. No one here can justify a 14-year-old child being charged, tried, convicted, and executed in some 80 days. That a witness who discovered the victim's body sat on the coroner's inquest and the grand jury possibly, and that the trial lasted only one day. The lawyer didn't ask any questions on cross-examination, which is stipulated to by the state. They called no witnesses, and they offered little or no defense in this case. And also poignantly, filed no appeal. In essence, not much was done for this child when his life laid in the balance. But I want everyone to understand that we're not here today to establish the guilt or innocence of George Stinney in this case. He may very well have committed this crime. It is to determine whether or not he received a fair trial. Ladies and gentlemen, our legislature and courts, in their wisdom and evolving sense of decency, has provided safeguards to make sure this would never happen again. And I want everyone to be confident in the justice system as we see it today. We have come so far as a society, and in South Carolina in particular. So I really hope that at this hearing, we focus on the good that we can do in furtherance of our duty of ensuring that justice is served in this courtroom and all courtrooms throughout the country. At this time, I'm going to go ahead and hear an opening statement briefly, if we could, from defense counsel. This is your motion. And then Solicitor Finney, I'd like to hear from you, sir.
Thank you, Your Honor. Your Honor, I'd like to introduce the defense team. Ray Chandler, who's seated to my left, Matt Burgess, to his left, and Miller Shealy, seated to his left. Your Honor, as you quite pointedly pointed out to everybody here, this is a situation where we have a juvenile, and he was 14 years old at the time that he was executed by the state of South Carolina. Everybody recognized he was the youngest person to have been executed in the state of South Carolina in the 20th and I guess the 21st century, because we don't execute juveniles anymore. The law has advanced to that point where we don't even consider that a 14-year-old could be executed in this country. So you have very well pointed out the issues, and I won't belabor you on that. But what I would like to do is to read to you a couple of things that we discovered in the state archives that were written to then Governor Olin Johnson. And Olin Johnson was asked after George Stinney Jr. was convicted of this crime. Apparently, as you know, 1944 was a watershed year for this country. I mean, that was D-Day, the year of D-Day. We were in the midst of World War II. So this case was probably not getting a whole lot of press based on what was going on in Europe, based on what was going on in the Far East with Japan. And the United States had to, and I'm sure that most of the newspaper focus was on that, but we found hundreds of letters, and all the letters were not favorable to George Stinney Jr., but most of them were. And one of the letters was written by H.L. Bailey, he was in the U.S. Army stationed in Europe, and I'm quoting from him, and he said, "I'm a white Southern boy. I've been in the Army long enough to know what the Negro boys are losing their lives for this country, and I surely think they should have the same treatment as the whites are getting," he wrote. Okay? If not, what in the world are we fighting for? And throughout this country's history, Your Honor, we have sent men and women to battle to fight for the freedoms that you just spoke about, to make sure that due process is carried out in a way that when we look back in history, that we can say these things were done the proper way. and not an improper way. And I think that you hit the nail on the head with that, and so does Mr. Bailey when he wrote that letter. And then there's another interesting letter from a Sunday school teacher from Sumter at the same time, and she was writing to Governor Johnson herself, and her name was C.S. Prescott of Sumter, and she told the judge that, told the governor this: just as sure as this child is electrocuted, this deed will be looked back upon with the shame and remorse in later years by the citizens of South Carolina, she wrote. And the finger of scorn will be pointed at us by other states. And, Your Honor, we believe that that is why this case will not, for lack of a better word, die. That this case continues to garner such public outrage. And this is not to diminish in any way the fact that 2 young girls were brutally murdered on March 23rd or March 24th. We really don't know what day they were murdered, but the bodies were found on March 24th, 1944. It's not to diminish that fact. And we know that there are family out there that are hurting, but what we want is the truth to come out. And I think that says it, Ms. Prescott's letter says it best, that we can look back on this and say, at some point in time, was this due process? Do we have a case here where that the court can give a remedy? And we're asking you today to look at that and to give a remedy not only for George Stinney Jr., but for Betty June Binnicker and Mary Thames. Thank you, Your Honor.
Thank you, sir. Solicitor?
Please, the court, Your Honor.
Yes, sir.
Good morning. Our system of justice is described as the best ever devised by the mind of men. And while it is not perfect, it seeks to settle controversies among citizens and mete out justice to the injured and to the accused. I have no doubt that this proceeding will accomplish that result. I first, Your Honor, want to commend this group of lawyers working for George Stinney for their dedicated efforts and research in preparing this motion and bringing it to this court for review. I also want to thank this court for accepting what I know will be a challenging and probably unappreciated task. We pray you will be given strength, wisdom, and courage in deciding this matter. I was elected solicitor 3 years ago on the promise that I would bring fairness and equality in the prosecution of the cases in this circuit. Our job in the solicitor's office is not to look for guilt, but to seek the truth. In a case like this, our job also is not to simply question the past, but also to learn from it. The Stinney family and the families of the 2 victims and the Clarendon County community as a whole have suffered untold sorrow over this matter. And while we don't have all the answers to what happened in 1944 at the trial, we can take comfort in the fact that, as you pointed out, in 2014, this result would not have happened. We now have legal procedures for review that keep the criminal and the victims apprised of what was going on and keep them in the forefront of the results. The solicitor's office maintains that the record in this case has been missing for 70 years, not because of a miscarriage of justice, but because of the natural result of the passage of 70 years of time. We contend at the close of the defense supporting the motion for the new trial, this honorable court will not have heard substantial and conclusive facts on which to grant the relief sought. While we, along with others, have questions about the 1944 trial and its outcome, this court should follow the legal analysis to one reasonable and just conclusion: that the evidence here is too speculative and the record too uncertain for the motion to succeed. We thank the court for the opportunity to open our case.
Thank you, sir. Mr. Shealy, I understand you're going to address standing and timeliness, sir?
Yes, Your Honor.
Thank you.
May it please the court, my name is Miller Shealy. I'm here in association with counsel to present the issues today concerning, as Your Honor has mentioned, standing and timeliness and the jurisdictional issues that surround that. We don't minimize the difficulty of the issues before the court, either legal or factual. We initially filed a motion for a new trial under the standard rules. One of the problems with this case, and if I may start off this way, one of the problems with this case is, yes, it's 70 years old. And as Your Honor and Solicitor Finney and my co-counsel have already pointed out, 70 years ago, most of the statutory and rule requirements that would have governed this case, and for that matter any criminal case, did not exist. The criminal procedure revolution that happened mostly in the 1960s had not happened. Basically what Mr. Stinney had a clear constitution, what George Stinney Jr. had a clear constitutional right to back in the 1940s was appointment of counsel in the capital case. And that was about it. Nevertheless, even at the time under state law, and Your Honors mentioned this, there were certain procedural safeguards. There was still a due process clause both in the United States Constitution and in the state constitution. And more importantly, there has existed at English and American common law for centuries certain procedural safeguards which preceded even our due process clause, our modern post-conviction relief statute, and even may outdate the habeas corpus procedures themselves. And that is coram nobis. And I want to talk a bit about what that is. I have had experience with it as an assistant AG in the past and as an assistant U.S. attorney when I worked there. You don't hear the words coram nobis very much anymore. They're Latin. They basically have to do with something that is before the court, something that is present before the court. This is at least a 500-year-old remedy. In that respect, it predates our entire Constitution by many centuries. It is a 500-year-old common law remedy that was developed by the English courts at common law to come to the rescue of defendants who had no other hope. And it could be used in civil or criminal cases. In civil cases today, it is largely a matter of, it is in the past because we have abolished it. We have new rules of civil procedure, but it has not been abolished in context of the criminal law. No state court has so held. The Fourth Circuit has not so held, and that's why we're here today. Basically, what coram nobis allows the court to do, this 500-year-old writ, is it allows the court to address errors in the record before it. What that presupposes is that even though a case is passed, even though it's many years past, and this is so in U.S. versus Morgan in the 1950s and other cases, it gives a court the power, and today this is sitting here, believe it or not, the same General Sessions Court, the same office, though we are all different, and only a few people in this courtroom were here in 1944, and certainly not in this physical courtroom, but this court, this General Sessions Court, as it sits today, is the same one that convicted and condemned George Stinney Jr. That's what the law says, even though the judges and all the parties are different. Coram nobis is a writ that allows a court, because the court as an office still has that record before it, to correct those errors. And those errors can be one of two types. They can be factual errors, and you will hear testimony and other evidence very shortly about those factual errors that go to the heart of this matter, and we believe conclusively will show that George Stinney Jr. was innocent, and that's the error in the judgment 70 years ago. Next, the court will also hear other kinds of errors, legal errors, and while there's some debate about this in the law, to be candid with the court, it is very clear from older cases and from learned treatises that coram nobis exists to do justice in cases where there were legal improprieties, where there were judicial improprieties, and the court will hear evidence of those as well today and perhaps tomorrow. I would also like to add, Your Honor, with respect to some of the issues, particularly about standing, as you have mentioned, and timeliness. With respect to the standing issue in particular, this is one reason we have brought this for writ of coram nobis. The state post-conviction relief statute, which is clearly, we concede, the main engine and the main vehicle for challenging convictions of persons who are currently incarcerated. Therein lies the problem. In the context of that statute, it speaks over and over of applicants. The Rule 71.1 of procedure that governs that speaks of applicants and the forms they have to fill out. While it doesn't say that someone who's deceased has no rights, or certain survivors under the survivorship statute might not assert their rights, I'm unaware of any case under the post-conviction relief statutes that gives family members survivorship rights, and the reference to applicants in the way it does seems to foreclose in any way George Stinney Jr. using that statute today, although if he were alive and could, it would be no question that I think he'd be entitled to relief on numerous bases. The habeas corpus procedure is both statutory and constitutional, and I address this because this goes to standing, because habeas corpus is the last remedy. It's only available when there's no other remedy available. The habeas corpus is the only other remedy which still exists. Even though our post-conviction relief statute has largely taken its place, the court has never read the habeas statute, either in the habeas provisions in the statute or the Constitution, out of the law. The term habeas corpus in Latin, without being macabre, literally means to bring forth the body. It is an order from a court to a warden, a prison official, or someone who has custody of the defendant to bring that defendant to court and answer why they should remain in custody. That's been so since the Civil War, since ex parte McCardle and ex parte Milligan in those days. The roots of habeas corpus prevent us from bringing a habeas corpus action because George Stinney Jr. is deceased. This is the term for 500 years, is that coram nobis is only available when a great injustice is done, factually or legally. It is the only available common law writ to get before the court at all. And the writ has latitude. It is elastic. Its boundaries are not precise, and they were not 500 years ago, and they are not today, because it is here. It is this writ, this is part of the genius of the common law, this is when justice fails, when a person, a defendant, a situation falls through the cracks in the law. When the law does not have the provision available to protect a person. Coram nobis is an equitable style remedy. It was in civil proceedings. It actually is even in the context of criminal proceedings, which makes it a bit odd. The cases clearly hold it's available in criminal proceedings, but it is equitable in nature. And that's where we really get to the heart of what we think is the standing and the timeliness issue. First, there are, and we've cited in my memorandum, there are some cases where widows and family members have stood before the court, both civilly and criminally, and pursued writs of coram nobis years after the conviction or the error took place in civil court, and they were denied their proper rights under the law. Your Honor, today, believe it or not, of all of George Stinney Jr.'s siblings, they're all alive but him. Both of his sisters are in the courtroom today. Charles Stinney will be here by virtue of a video deposition. He's alive but too sick to travel. If these people can't stand in the shoes using a coram nobis writ of a deceased 14-year-old, then nobody can. And we submit that this is a right clearly that George Stinney would have. The only way to pursue it is through his family members, and they can stand in his shoes. They can do this with coram nobis. They can't with PCR. They can't with habeas. The standing and the timeliness issue dovetail. It dovetailed because this is the only way to get before the court, even after this amount of time. One also important point with both of these issues with respect to the standing and the timeliness, because this is a remedy in an equitable style, if you will. The reason we have this problem is not because of George Stinney Jr. and his family, and you're going to hear the bad details of that shortly. It's because of the wrongdoing of the state, and by the state I mean 70 years ago, not anyone in the courtroom today at all. But the state is still here, and it's the dirty hands of the state that basically cause any standing problems and any jurisdictional problems for George Stinney Jr. to be here. The purpose of the writ of coram nobis is to do justice where justice can't be done in any other way. And if the party against whom we seek justice is the very party that has denied him standing and that has created the timeliness problem, that party should not be able to avail itself today of those technical claims of standing and timeliness. You will hear testimony that George Stinney Jr.'s family had to leave shortly after this crime because they were threatened. And that's why we asked the court to hold the record open and to hear that testimony. They could not be here. They could not come back. They don't live here to this day. And only through the very diligent efforts of these attorneys, my co-counsel, have these facts been made available to bring to the court and present to the court today. There is a real issue about, George Stinney Jr., as the court has mentioned, The crime occurred in late March, and by June the 16th, he was executed. There is no record. There's probably no record because there was no appeal. There was no cross-examination. That's what we know. This case was handled so poorly. His family was treated so poorly in the circumstances of March to June 1944 that his rights were snuffed out then. And it was only later, when the state changed, the political system changed, and the criminal procedure revolution we have today, that we are able to come before the court and even bring his rights in his case to the court in some way where he can get justice. There are other issues here. We have addressed them in our memorandum, and I think I have spoken to most of those. I would just add that there is another issue here as well. The state of South Carolina continues to maintain that George Stinney Jr. is guilty. It continues to maintain that he deserved the death penalty. The state is an organ, the state is an entity. It still maintains that. His family lives with that. They live with those disabilities. They live with those problems. That is part of their story. And more importantly, or just as importantly, is part of the story of the people of the state of South Carolina. This is something that needs to be expunged. It needs to be addressed. It needs to be removed or dealt with in our state's history. We can't correct what happened 70 years ago. But if there's any way today we can say that George Stinney Jr. was not guilty, that he was treated unjustly, we can at least make some step toward dealing with the fact that only South Carolina has the record of executing someone 14 years old in the 20th century. Maybe we can at least recognize that there was a mistake made through this writ of coram nobis and deal with that legally in a formal way, and at least that stain will be removed. That's all I have if there are no other questions.
Okay.
Thank you.
Thank you. We'll go ahead and let the solicitor respond.
Please, Court, Your Honor.
Yes, sir.
Your Honor, I would join in my colleague's request to keep the record open on this matter. Our office has just been served with the notice of the coram nobis, and we have not fully researched all the details that we think might be appropriate for the court to consider. However, we do want to put on the record that we object to having the defense be able to have two bites of the apple. The motion filed by the defense several months ago was a 29B motion. We think that that motion, based on after discovered evidence, is the one that was proceeding to the court until last week when the coram nobis issue was brought up. We believe that the defense should be required to elect. Are they going to make this a 29B or a coram nobis? We do not believe under the law they are able to do both. In the brief submitted by Mr. Shealy on page 4, a quote from Amjur says that if an issue in the case concerning which relief is sought by the defendant could have been raised by a remedy other than coram nobis, the issue cannot be reviewed in a coram nobis proceeding. There are legislative histories showing that because of the enactment of statutes such as 29B relief, coram nobis may not apply anymore even though it was a common law remedy. We would ask the court to review and look at the information that's been submitted by Mr. Shealy and take into account that the state believes that coram nobis, while it may be possible to argue, does not apply in this case because it is based on the fact that there is a record for which the court can review. In this case, the record is not complete and it is certainly not clear. My colleagues like to make mention of the fact that there were no cross-examinations of witnesses. No evidence introduced, and all of the records that we've been able to maintain that opinion from come from newspaper accounts, which we have, by agreement today, said are not reliable enough for the court to make a decision on. So quite frankly, this court has to look at a record which is almost devoid, except for some original documents that have been submitted and stipulated to. We are almost void of what actually went on that afternoon during the trial of Mr. Stinney.
And it was my understanding the state had stipulated that no questions were asked on cross-examination and no witnesses were put up during the 2-hour trial of the case. That's what was forwarded to my office, was a stipulation signed by your office and the defense.
Your Honor, we would stand by that stipulation.
So you do agree that there was no cross-examination and no witnesses put forward on
We
behalf of the
stand by that
defense?
stipulation.
Okay.
Your Honor, and further, there was no evidence to corroborate the innocence of Mr. Stinney from any of the reports that we have accomplished here in coming before the court today. Therefore, we should start with the premise that he was given a trial, he was given a lawyer, and at that trial, a confession made by him was introduced into evidence. The dirt on the hands of the state, I'm not aware of, even the state 70 years ago. I have, based on my research, found that the trial judge, Judge Stoll, was very well respected, served a long time in many capacities. The solicitor, likewise, was well respected. 12 jurors who did not have any connection to the indictment process or to any other process heard the case, and a verdict was returned. We would say, Your Honor, that even though the standing of the Stinney family may be comfortable with you, and you may find that they do have standing to present a 29B motion or a quorum nobis argument, that the timeliness works against them. The state of South Carolina has been here 70 years standing by the results that took place in that courtroom that day. Only now, in 2014, and technically in 2013, has a motion been filed, long after most of the witnesses who could have been competent to testify about those issues come back to court and said what they saw, what they heard, what they know that happened. The timeliness factor here is critical because the state of South Carolina cannot proceed to a new trial based on the fact that 70 years have been allowed to pass by and that we don't have a complete record to go by. I certainly could stand here now and tell you that I am shocked and dismayed that an electrocution took place. George Stinney did not deserve that, and he should not have been put in that position. But I am now looking through the lenses of a lawyer who's been trained under the procedure of 1960s and 1970s and onward. Back in 1944, we should have known better, but we didn't. The fact of the matter is it happened, and it occurred because of a legal system of justice that was in place, and that we, for all we know, based on the record, that it worked properly. Thank you.
I think, Mr. Finney, that you have touched on some of the issues that I have with this case, with there being a missing record, no witnesses that are living that can tell us what we have. I've looked at it, and I don't see that there would be any evidence that Frank McLeod, the solicitor at the time, did anything other than what he was supposed to do and sworn to do. As a judge, I find it very hard to believe that another judge sitting in this capacity who had a long learned record of sitting on the bench would do anything improper. I think that my focus is more on what the defense attorney did or did not do, possibly due to a lack of experience, and certainly given the political climate and certainly the cultural climate during the time. My big concern, again, as we talked about in looking at this case, is the standing issue. It's what, in fact, I can do. What can I rectify? And even if we did retry Mr. Stinney, what would be the result? Again, none of us have the power to bring that 14-year-old child back. So that's where we go to the heart of these standing issues and timeliness as well. This was filed in 2013. Some of the affidavits that were produced to me were provided in 2010, 2009. And again, unfortunately, we have witnesses. We have lawyers who actually tried the cases who have passed away, witnesses that testified in the case. I'm sure all of us would like to have the Deputy Sheriff, Mr. Newman, on the stand to hear his testimony as to what he says was told to him by George Stinney. Again, we don't have the opportunity to have that based on the timeliness. Again, I certainly understand the tenor of South Carolina in 1944, but we did have the civil rights era, and as things changed and progressed and we evolved as a society, some of the questions I have is if we couldn't do it in 1944, why not later? Why not in the 60s? Why not in the 70s? Why not as we go through time? And that's one of the concerns that I had as far as timeliness of this case. Again, we're all new here. I'm a new judge. You all are new people representing the state and the defense, and we even have a new person. You're representing the family as opposed to George Stinney Jr. I think those are the questions that as legal scholars we need to address and look at as well, in addition to the facts and what was presented. So I appreciate y'all's information, certainly on standing and timeliness. I may leave it open somewhat at the end of this hearing to further brief it, but that's something we can address after I've heard the testimony. But I appreciate your comments at this time about it. And let's go ahead, and if y'all are ready to go and appropriate, we can go ahead and put up a first witness if that's what y'all would like to do. Okay.
And Your Honor, we would call Catherine Stinney to stand.
Place your left hand on the Bible. Raise your right hand. State your name, please.
Name is Catherine Stinney Jr.
You solemnly swear or affirm your testimony to the court is the truth, the whole truth, nothing but the truth, so help you God. Thank you. Catherine, Mr. Booth. Please state your full name and spell your last name for the record.
My name is Catherine Stinney Robinson, Robinson.
Thank you. And Ms. Robinson, I apologize for not giving you your last name. I just called you as Catherine Stinney, but I wanted everybody to know the association you have.
Right.
And what's the association you do have with George Stinney Jr.?
He was my brother.
Okay. And Catherine, and I hate to ask the lady this, but, and you're probably going to fuss at me for doing this, but can you tell us your age?
I'm 79.
79 years old.
Yes.
And so how much younger would you be than George if he was alive today?
It was about 5 years.
5 years. So he would be 84? Is that correct?
84.
Yeah, 83, 84?
84.
That time frame? Okay. So what was your date of birth?
7/24/34.
7/24/34. So if I was to tell you that George was born on October 21st, 1929, does that give you an idea of the difference in your ages?
About 4 years.
Okay. All right. So can you, Catherine, can you tell us a little bit about yourself and what you've been doing, as the judge stated earlier, what have you been doing for the last 70 years?
High school, graduated from high school, college. I have a master's degree in human development.
And where did you go to college?
Morris College,
Okay.
New Jersey State, and Montclair State.
Okay. And what is your degrees in?
Human development.
Okay. And what did you do with those degrees?
I taught school for 39.5 years.
And where did you teach school at?
Passaic, Newark, Passaic, New Jersey.
Okay. And so obviously when you graduated, I guess, from school, you moved out of state.
When I graduated from Morris College, I lived in Newark. Then I moved to Passaic, and I went to Fairleigh Dickinson University.
Okay. And do you have any children?
I have one daughter.
Okay. And Catherine, you traveled here today?
Since yesterday, we got here last
You
night.
were on the road and you came down for this hearing?
Yes,
And we have established that you were George's sister, is that correct?
he's my brother.
Okay. And I guess you've heard all the statements that have been made here today. What would you like to see done today?
I'd like to see them find him innocent.
Now, you understand the judge can't find him innocent. The judge
Right.
may have asked for requesting a new trial.
And
And so is that what you're asking for?
whatever it takes to show that he was innocent.
And let's go back, and so you are convinced that he's innocent.
I'm sure of it.
Okay, let's go back to, and tell the court what you remember and how you remember those events as they happened back in 1944. Do you remember, for example, the day before George was arrested?
It's just like any other normal day. You don't think about anything that will happen.
Before you start there, Captain, let me ask you, how do you remember those events?
It
Why are
was
they so vivid in your mind?
it's very outstanding. It's something shocking I was expecting.
Okay. Is it every day your brother gets arrested?
No.
Okay. And so tell us about Alcolu back in that time frame. What kind of community was it?
My father took us to movies. He took us to see shows, a circus, all kinds of things that young people would do.
Okay.
And he was always there for us, and he took us to all these to give us those experiences.
Okay. And but what kind? How about tell me about Alcolu itself? Where'd your dad work?
My father worked at a sawmill,
Okay.
and we belonged to a Baptist church. We all attend school there
All
in
right, so-
Alcolu.
So you attended school at the church?
No, in Alcolu schools,
In Alcolu School?
Yeah.
And then you went to church also, did you go to Green Hill Baptist?
Green
Church?
Hill Baptist Church,
Okay, and that's located in Alcolu?
Alcolu.
Okay. And so, and you remember all of those things, is that correct?
Very good memories.
Okay. And you remember the day before George was arrested? Can you tell us what you remember about that day?
It was just like any other normal day. You go about doing your daily chores, and the next day, everything just went haywire.
Okay. All right. Now, do you recall what George's chores were?
Well, George did several things, but one was taking care of the cow, taking the cow out to graze.
Right. And what was your cow's name?
Lizzie.
Lizzie. You remember?
I think it was
that?
Lizzie.
Huh?
I think it was Lizzie.
Okay, Lizzie. Okay. And so that was one of George's duties?
That was one of his chores.
Okay.
His
I say chores. Okay.
chores.
And so one of his chores was to do that.
to take that.
Did, I know you said your father took you to movies, he did things with you guys.
Yes.
I'm assuming he worked hard.
He worked at the sawmill.
And did your mother work also?
My mother was a cook at the elementary school.
Okay.
She cooked there for a while.
Okay. So whenever your parents weren't there, who did the babysitting for your parents whenever y'all were out of school?
Well, my mother was always there.
Okay.
We didn't have a babysitter.
All right. So tell me about the day that George and tell me about Amy and George's relationship. Your sister Amy.
They were tight. Wherever George went, she was right with him, like a shadow. She always went with him. Whatever he did, she just wanted to be with him, you know.
And so what's the difference in George's age and your age and Amy's age?
About 3 years each between George and me and Amy and myself.
Okay. And so do you recall, I think this would have been a Friday, March 23rd, is the day that the Binnicker and the Thames girl went missing. Do you recall that day?
Well, just like any other day, you know, we saw some girls in the community riding their bicycles, and they asked if we knew where they could find some maypops.
Did they ask you that, or is that something that you...
No, we were just in the yard because it was gated. You know, it had a fence around it. We saw the girls riding, and they were looking for maypops.
Well, explain to the court, you said George's job was to graze the cow.
Right.
And then Amy was his shadow.
Right.
And I guess you were in the yard, and you saw these girls that day?
I saw the girls
But you don't
riding on
remember-
their bicycles,
Okay.
or pushing the bicycles.
Okay. But do you know who the girls were?
No, I had never
Have
seen
you
them
ever-
before.
Have you ever met the Binnicker child?
Never saw the girls before that day.
Was it unusual for white girls to be in that area?
They were just children riding. I didn't think about whether they were white or whatever. I just saw the white girls riding. That's it. Pushing the bicycle.
Okay. Do you know whether or not they stopped and spoke to Amy and George?
They might have, because my sister Amy and George were maybe at the railroad sitting down while the cow was grazing. And see, the cow would graze there for a while, and then they would bring the cow back.
And did, at some point in time, did the girls leave?
I don't remember they left there and went on about their business.
Okay. Tell us about what you remember George and Amy doing after that.
George sent Amy ahead to turn the water on.
All right, tell us about how the water happened and all that.
Yeah, it's a spigot in the yard with a big tub that you turn the water on and fill it up. So he would always send her ahead, and she would run and turn the water on. By the time he got there with the cow, the water was about half full in the tub.
So we grazed the cow, then we watered the cow, then...
And put the cow in the
Right.
shed
And so put the cow up and
for the night. Right.
Okay. Now, do you recall a period of time that you were gone that day, that George was babysitting Amy? Do you recall that?
No, if they were there, I was in the house.
Okay. So you were in the house, and tell the court where the house was in relation to where the cows grazed.
Oh, that was a distance across the tracks, not too far from the house.
So if you're standing there in that witness chair, would it be, and I'm just using this as an approximation because I know it's been a long time ago,
Right.
Is it fair to say it toward the end of the courtroom? Or is it further?
A little further than that.
Okay. Would it be twice the size to the other side of the court? I mean,
Yeah, because the railroad track ran between there, so that's where they would sit and watch the cow graze and then bring the cow home.
could you see George and Amy from your house?
If I went looking for them, I would have to go to the front because I was usually in the house doing something.
Okay. So you do recall seeing the girls, but you never saw. Is there any point in time that you didn't? That George left the home that you understand that day?
No.
Okay. Now, do you remember or recall the next day, which would have been the 24th, and I think this would have been the day they found the two girls' bodies. Do you remember that day?
I don't remember that day.
Okay. And can you tell us why you don't remember that day?
Trying to think. See, the girls went up past our house.
Right.
To wherever they were going, and George came back. I don't remember nothing about the girls the next day because it was business as usual for us.
Right, but do you remember that the girls were missing and a search party was looking for them?
No.
You don't remember that at all?
I don't remember that.
Okay. Do you remember when the next day when your brother George was taken into custody?
Okay.
Do you remember that day?
Yes.
Okay. Tell the court what you remember about that day. First of all, were you home when he was taken into custody?
I was not home.
Okay.
My mother's not home. My father's not home. Just Amy, George, Charles, and myself.
Okay. And so where were you at whenever George was taken into custody?
I was at the beauty parlor. Charles took me to the beauty parlor.
Okay. So
That was his job.
okay. All right. So you weren't there when he was taken into custody. But let me ask you this question. When George came in the day before that, though, did you notice anything unusual about George?
Just George.
Okay. I mean,
Nothing different.
If he would have come in and he had, for example, bloody clothes on, would you have remembered that?
I would remember that.
Okay. Did you recall back in those days how many sets of clothes George would have had?
He would, I guess, a change in clothes. You know,
Okay.
you don't have to watch a set and wear a set.
Okay. So would you have, or somebody in the family, would you think somebody would have noticed that George had bloody clothes on, that would have occurred?
Someone would have noticed.
All right. Tell us how big your house was.
It was 3 rooms, like a 3-room flat.
Okay.
A living room, bedroom, kitchen.
Okay.
We had beds in both 2 rooms.
And so you had 3 rooms, and did the kids sleep in a room together?
The kids slept in the middle room,
Okay.
and my parents slept in the front of the house, the front room.
How many kids were in the house at that time? Do you remember?
4 of us.
4 of you? Johnny, your older brother, was living there, is that correct?
No, he
not
was
living there?
visiting. He was not living with us.
Okay. So it was yourself and Amy
Yes.
and George and Charles.
Right.
Okay. So that would have been the 4 kids, and you guys slept in the middle room of a 3-room house.
Yeah, had 2 beds.
All right. So very tight quarters. Would that be a fair assumption?
Yeah, very so.
Okay. And so when's the first time you understood that George was detained by the police officers?
My brother Charles escorted me to the beauty parlor. When we came back, George was not there.
Okay.
We didn't know
And
where he was.
you don't know where he was?
Didn't know where he
Did
was.
you talk to Amy about it?
She wouldn't have known either, except she knew that some men took him.
Okay. And so you discussed that with Amy, and then when's the first time you understood that he was being accused of killing,
It was
Thames
sometime
girl and
after
Binnicker
that.
girl?
It
I'm
was,
sorry?
it was sometime after that.
Okay. And do you recall what you guys did in regards to, did you stay in Alcolu?
No, my father made the decision to take us out of there, to take us to our grandmother's house.
Do you
Living,
know why he made that decision?
didn't discuss that with me.
Okay. He didn't discuss it with you? And I don't want you to say anything that you heard, but you didn't hear anything obviously about
No.
why. Okay,
No.
so
We
you
just
don't know
leave.
why he made that decision. Can you tell the court, was it the middle of the night that you guys left? What
It was
happened?
kind of because we, in order to go to my grandmother's house, you had to leave a certain time to catch the train. So we stayed in there until it was time to go out and catch the train to Sumter and then to Pinewood. We were going to our grandmother's.
Okay. And do you know the distance between Alcolu and Pinewood?
No.
Okay. Do you recall that train trip?
I recall being very nervous, just cold and shaking because I didn't know what was going on. All I knew is George was not with us.
Right. Did you ever see George again?
Never saw him again.
And let me ask you this question. Did your parents go and discuss, prior to George being convicted, did you ever see a lawyer come to the house?
No,
Did you call your parents ever saying, we got to go see our lawyer for
No.
George? Did the police come back and say to y'all, did they ever ask y'all any questions?
no,
Okay. Did at any point in time, did anybody from the state of South Carolina come to you and say, you know,
no one,
Catherine, what do you know about this case?
no one.
Okay. And is today the first time you're telling this story?
First time.
Okay. Tell us why today is the first time you're telling this story.
Because it keeps coming up and I would like to have it solved.
I understand it keeps coming up, but why didn't you tell this story, as the judge has said, in 1950? Has anything changed from 1944 to 1950 in regards to race relations in South Carolina?
I don't think so.
Okay. How about from 1955 or 54 to 1964 when we had the Voting Rights Act? Did anything change?
No.
Okay. When did you get the right to vote?
When I became of age.
Okay, when you came of age.
Right.
And when was that?
Guess when I was 18.
When you were 18. Do you know when the Civil Rights or the Voting Rights Act came into existence?
I don't recall this minute. I don't recall.
You don't recall, but you remember you at some point in time you got the right to vote.
You had the right to vote.
Now, I guess my question to you would have been, is years have passed, and the judge is interested to know why 2013, why 2014, that we're asking her to go back and relook at this case when you could have asked this in the 60s or the 70s or the 80s or the 90s or the 2000s.
Sometimes you don't know which road to take or which step to take in order to rectify this.
All right. And let me ask you this question. Did you have did your mother and father have the resources to hire an attorney for an appeal?
No,
Okay. Did anybody ever come to you and say, we're willing to help your family with an appeal?
no,
Okay. Did you go to see lawyers and they tell you that there was nothing that could be done? Or did your parents do that? Did they ask of anybody?
I've heard of a lawyer that was representing him, but really didn't do anything to help him.
Okay. And that would have been a lawyer trial, is that right?
Right.
Okay. So did your parents have any knowledge or any information about the legal system?
No,
Okay. And you went on and moved on with your life, and this story has been repeatedly come up over the years.
right.
And one of the things I think that the reason it's come up over the years is every time there's a death penalty case in this country, George Stinney Jr. is brought up as the youngest person executed in the 20th century.
Right.
And so from time to time, have you gotten calls from the press talking about this case?
We've talked to quite a few people. We've had people who came to our house and videotaped certain statements, but that's about it.
Okay. Did you know the legal process?
No,
Okay. Did you know how to get into, to go and talk to an attorney? Did you know how to handle any of those things?
we just didn't do it.
Okay. And Catherine, let me ask you this question. Are you paying this law firm to do anything for you today?
No, I'm not.
Okay. And we doing this on a pro bono basis?
Yes,
So in essence, until someone was willing to step forward to help your family, you had no way of knowing how to do this?
not the first step.
Catherine, let me check with co-counsel. That may be all the questions I have for you. Catherine, I appreciate, Mr. Finney is going to ask you some questions, and then I'll have the opportunity to ask you some questions after that, okay?
All right.
Thank you.
Please, court.
Yes, sir.
Good morning, Ms. Robinson.
Good morning.
My name is Chip Finney, and I'm the solicitor here in Suffolk County.
How are you?
I'm very glad to meet you.
Very nice to meet you too.
We've never spoken, is that right?
What is your name?
Chip Finney.
Oh, Chip.
We've never spoken, have we?
Never.
I think the lawyer, Mr. McKenzie, asked the question and you answered about why you never did anything. It's just that you just kind of put it aside.
Kind of put it aside.
Try to put it away from what you were doing in your life. Let me ask you a couple of questions about your background, please, ma'am, if you don't mind.
All right.
First of all, you said you were born in 1934.
Thank you, good.
So in 1954, you would have been 20 years old.
Yes.
Between the time that you left Alcolu with your family and the time that you turned 20, did you live in Sumter that whole time?
I'm sure I did.
All right. And so you graduated from high school here?
High school and Morris College.
And so you left high school and went straight on into Morris College?
Yeah, for 2 years, and I went to Georgia for 2 years, and I came back,
All right.
went back to school.
At the time that you graduated from high school, which would have been around 1952, was your mom and dad still alive?
Yes,
Okay. And they were living in Sumter?
yes.
All right. And after, when you turned 20 in 1954, were you still at Morris College?
I'm trying to think, yes. I think so.
You graduated high school in 52?
52,
And then you went to Morris for 2 years?
yes.
53, 54. So
But they
in
went-
1954, you would have probably been coming out of Morris?
But I didn't. I went to live in Columbus, Georgia.
All right.
For
But
2
before you moved to Columbus, Georgia, were you living in Sumter?
Yes,
Going to Morris College?
for 2 years.
With your mother and father? Living in their home?
They were living in their home.
All right. Ms. Robinson, did your mother and father ever tell you that George had done something bad and that's why he wasn't at the house?
No,
Did your mother and father tell you that you and your brothers and sisters needed to do something to help the memory of George, to straighten out what had happened to George?
they didn't get in, not in so many words.
All right. Can you tell the judge, who passed first, your mom or your dad?
My dad,
Dad passed first. He lived in Sumter at the time,
he lived in Sumter.
and you were gone to Georgia by that time? You had already left Sumter when your dad passed?
Here for 2 years.
All right. And was your mom still here?
In Sumter.
And did she pass after your dad? How many years?
I don't recall this minute.
All right. Have you and your family members during this time, the 50s, the 60s, the 70s, did you all ever have a discussion about getting a lawyer and doing anything about the George Stinney case?
No, it's life as usual.
All right, life as usual. Now, when you started your family with your daughter, was she born in New Jersey?
She was born in Passaic.
New Jersey.
Yes,
And you were teaching school there?
yes,
All right. And you got your master's degree
Yes.
in New Jersey?
Yes.
All right. If you don't mind, let me ask you a few questions about 1944.
Okay.
Do you remember going to school with George and Amy and Charles?
Yes.
Did all of you all attend the same school?
Well, we had an elementary school with a few rooms, and then you moved to the other school.
All right. In 1944, were you in the same class as George or Amy?
No.
Or Charles?
No.
So all of you had different rooms to go to,
Right.
different teachers were instructing you?
Right.
All right. You testified that you were not home when George was taken by the authorities.
No.
You were at the beauty shop.
Right.
Did you say, I couldn't hear, that your mom and dad were not home either?
They were not home.
So you were with Charles at the beauty store. Mom and dad weren't with you. And so George was home by himself or maybe with
George and Amy.
Just those two?
Just those two.
All right. Do you know what day it was that he was arrested?
No.
You know what day the girls' bodies were found?
No.
As it concerns George and the task of handling the cow, you say George would take the cow out of the shed and take him to graze.
Right.
Where was the shed in relation to your house?
In the back.
Right behind the house?
Behind the house.
Okay. Did you all have chickens
Chickens.
and other farm animals?
Chickens and vegetables.
All right. And the cow stayed in the shed right behind the house?
Yes, behind the house, a little in the back.
And he would have to be taken across the yard,
Through the yard, out of the gate, and down the street.
okay, and down the street, and you had to cross the railroad tracks to get to the field where he grazed?
It was right alongside there, the
Alright.
field was at.
Now, Ms. Robinson, from 1944 to today, this is the first time you've talked about this case.
Yes.
Have you ever written a statement called an affidavit for anybody where you signed it and said, I swear to tell the truth and this is my statement?
No.
You've never done that before?
Never did that.
All right. Is there any reason why, after all this time, and people were asking questions, you said people have been to your house, you've given interviews on the radio before?
Not the radio, but I had people come to the house, and they took photos and videos, and you're hoping and praying that this is what they're going to do with it to help you out, but you don't hear from them anymore.
Did you recollect of your own free will that you saw these two little girls riding a bicycle that day in Alcolu? Or was that because of conversation that you had with Amy and other people?
No, I saw the girls pushing the bike. They weren't riding. I don't know if there were two bikes or one.
All right.
But they were pushing the bikes. They weren't riding.
Do you remember whether you went to school the day you saw the girls pushing the bike, or was it a non-school day?
I don't recall.
All right. And is it your testimony that in all the time you lived in Alcolu, that was the only time you saw these two little girls pushing their bike in that area?
That's the only time.
Your house in Alcolu at the time where you lived with your family, how far was it to the Green Hill Church?
It was in walking distance. At that age, you don't know, can't think about miles or whatever.
Yes, ma'am.
It's in walking distance.
And I understand that by the time you were 5 or 6 or 7, you had left and moved to Sumter. In
Not-
1944, when this occurred, you say your family was asked to leave town. You got on the train shortly after George was taken away from the house.
That evening,
Do you remember how old you were that evening when you left on the train?
maybe 7, 8.
You were born in 34. This happened in 44. Was that to be about 9 or 10 years old?
Maybe 9. I was going into 3rd or 4th grade.
Okay, so about 9 or 10 years old at the time.
Yes.
give us a little bit of understanding how far it was from your house to Green Hill. I know a lot of people walked back then,
Yeah.
especially the kids.
Because we walked.
And you walked to church, right, on Sunday?
Yes.
Would it take
Maybe 10 minutes.
10 minutes walking?
Yes.
Do you know what a half a mile is, or a quarter of a mile? Would you say it was a half a mile to the church, or a quarter of a mile? Can you give me a distance?
I could see it in my mind's eyes, but
Yes, ma'am.
walk up across a railroad track and up the road. Didn't have streets. Up the road to the church.
The same road, the same railroad track, you had to cross the
Cross
track?
that track to get to the church. Right.
Did you all have neighbors on your street? Did you
Yes.
have a neighbor to the left and a
The
neighbor to
neighbor
the
to the
right?
left, the neighbor was on the right, across the street.
All right. And these neighbors, did they have children your age?
The lady next door to us had some like teenage girls.
All right. Your testimony is that you were at the house when you saw the girls ride by that day,
Pushing the bikes.
pushing the bike. And that was the only day you ever saw those girls?
Never saw those girls before or after that.
And you don't know of any reason why they were there that day?
They said they were looking for maypops.
So they talked to you.
They said they were looking for maypops.
Now, ma'am, I need the answer to the question.
Okay.
Did they talk to you that day?
No, those girls didn't talk to me.
So they didn't ask you for maypops?
No, they didn't.
Who did they ask for maypops?
They said they were looking for maypops. I just heard that. They were asking someone in the neighborhood.
They didn't tell you that?
They didn't tell me that.
You didn't talk to them?
I didn't talk to them. I just heard it.
Did you see the girls talk to Amy or George?
No,
You just heard,
that's what they were looking for.
somewhere along the line, you heard that the girls talked to somebody.
To
that asked
Amy
for
and George.
maypops. That's in your mind.
No. Somewhere along the way, they talked to Amy and George.
Now you know that? They did talk to Amy and George?
Yeah, because Amy and George was sitting on the railroad tracks.
With the cow?
Cow was grazing.
Did you see the girls stop and talk to Amy and George?
No.
I thank you for answering my question.
Okay.
Just a few questions on follow-up. Ms. Robinson, you said that you went to school, and I think there's two kinds of school, right? Two different levels of school, like for elementary and then for...
High school?
Right. And so was George in high school?
No.
Or you don't remember?
No.
He was in 7th grade, 8th grade? You recall?
I don't recall. He was in the elementary school there in Alcolu.
And Mr. Finney asked you about the school. How many people at your school that were going to school look like me?
None.
And so this was the days in 1944 where you heard the word Jim Crow, hadn't you?
Heard it.
Okay. And white people stayed to themselves and black people stayed to themselves. Y'all didn't hang out together, did you?
No.
Okay. And so for white girls to be in the area, and I'm assuming the area you lived in was a black area.
Right.
Okay. Was that, it may not have been an unusual event, but you remember that because they were there.
They were there.
Okay. And Mr. Finney has asked you about this time frame about, when, you turned this age in this period of time, but we have come a long way in our race relations in this country. Would you say that's a fair statement?
That's a fair statement.
Okay. Do you, as an African-American woman, feel like that you are, at your age, when as far as we have come in this country, do you still feel like that we have come so far that discrimination is not still out there?
It might be out there, but I have good friends like you. They're just people like you. So this lady.
So my question to you is that during these preceding 70 years, you've had people come talk to you about this case?
Yes.
Okay. Did your parents have a lot of money?
No.
Okay. And was anybody able to hire an attorney to come forward and help you guys with this case?
No.
Okay. And this is the first opportunity you've had to tell your story in a courtroom, is that correct?
Correct.
Okay. Court's indulged, Your Honor. That's all the questions we have, Your Honor.
Mrs. Robinson, I have a few questions for you, ma'am. Is it your testimony here today that you overheard these two girls asking your brother and sister if there were any Maypops in that area?
Unless my sister told me. Sometimes it comes
So it
back
might
to
have
me.
been that your sister Amy told you that that's what these girls had asked. Is that correct? So you
That's
don't
correct.
know of your own independent recollection whether or not these
They
girls
didn't speak
asked.
to me directly.
They didn't speak to you directly, and that's because you said you were closer to the house. Is that
Right,
correct?
right.
And you said your brother George and Amy were down by the tracks, the railroad tracks, grazing with the cow, correct?
Walking up to graze the cow.
So you couldn't have heard them, and you couldn't have heard from that distance, could you have, from the house to the
No,
tracks?
it was not in the house, in the yard.
Okay, but could you have heard based on the distance?
I could hear based on the distance of them passing the house.
So Ms. Robinson, did you actually hear them say that, or did your sister just tell you that?
No, I heard them say as they were going looking for Maypops, because my sister was almost up by the railroad track.
Okay.
Okay.
So ma'am, you've just told me two different things. Is it in fact that you did hear them, or that your sister may have told you? I know it's a long time back.
I know, but
And the reason why I ask you this, Ms. Robinson, because to my understanding, this is the first time that we have heard, or you have come forward stating that you actually saw these two girls looking for Maypops.
I just saw the girls passing. The father.
But isn't it true that this is the very first time that
Very
you have
first
come
time.
forward?
Right.
And you said you have given interviews such that people have come to your house. Have you ever told anyone this before?
No, just different things they would ask. People would come to take videos. And I thought it was for on our behalf, but they might have been used for school purposes or what, I don't know.
Ma'am, you were not originally on my witness list.
Okay.
I was just told this morning about you being here.
Okay.
When did you have an opportunity? Did you speak with your sister to know this was going forward, or did you see it in the press, or how was it that you came to be here?
My brother lives in New York, and he's mentioned he was interviewed. My sister's been interviewed, but no one interviewed me. So I'm here today because of that.
Okay. All right, ma'am. Anything further from anyone?
No, thank you. No, thank you.
All right, ma'am, you may step down. Thank you.
Thank you.
Want to take a break for lunch? Lunch? Okay. All right. Mr. McKenzie, I know we got a bit of a late start, but I think now is a very good time to go ahead and break for lunch. It's nearing 1 o'clock, if that's agreeable to everyone, and we don't have any witness issues. Is that correct, Mr. Finney?
It's agreeable, Your Honor.
Mr. McKenzie? All right. Ladies and gentlemen, we're going to go ahead and take a lunch break and be at recess until 1 p.m., where we're going to continue with the testimony in this case. Sir, 2 o'clock, I apologize. Thank you. That'd be quite quick, wouldn't it? I am known not to take a lunch break, but I, of course, need to make sure you all do. So we will all be back here at 2 o'clock, where we'll go ahead and continue with the testimony. Thank you. What? Thank you.
Make sure your law clerk scans you out and push the door.
Got it. Appreciate it. Yeah, we don't let me have her. Oh, good. Thank you. Is the defense ready to go forward?
Yes, ma'am, we are.
Okay, if you call your next witness.
Yes, ma'am, we would call Amy Ruffner to the stand.
Come on up, Ms. Ruffner, please.
Place your left hand on the Bible, raise your right hand. State your name, please.
My name is Amy L. Ruffner, Stinney.
Do you solemnly swear or affirm your testimony to the court shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, ma'am. Have a seat here, please.
This thing work?
It works. Please state your full name, spell your last name for the record.
My name is Amy L. Ruffner. My last name is Ruffner. My first name is Amiel period Ruffner.
Ms. Ruffner, before you were Ruffner, what was your name?
Amy L. Stinney.
Okay. And do you mind if I call you Amy?
Go ahead.
Okay. Amy, I can call you Ms. Ruffner if you like. You want to call Amy?
No, that's okay.
Okay. Amy, was George Stinney your brother?
Yes, it was.
Okay. And you were seated in the courtroom when your sister Catherine was testifying?
Yes, I was.
Okay. Let's go back to what you remember about South Carolina in 1944.
Nothing good.
Okay. And can you tell us what you mean by nothing good?
Well, okay. First, I was born in a place called Pinewood, South Carolina.
Okay.
My father, to my knowledge, was a sharecropper.
Okay.
And we lived in Pinewood, not too far from my grandmother.
Okay.
My father needed work, so he proceeded to go to Alcolu, which was close, to find work.
And is that because there was a lumber mill there?
Yes.
Okay. And when you guys got to Alcolu, what kind of housing did you live in?
Well, the first house we lived in was a big old airy house. And beside it was like a ditch where like the water was running. And it was okay, but it was kind of airy. You know, like big and, well, nothing was there. So we moved in, and I remember on the side it was like a fig tree on the side, but in order to get to it, it was a driveway that was there, and over here was like a footbridge we had to cross to get to the house. We stayed there for maybe a couple of months or whatever. And
Now, in Alcolu in 1944, was there a black area of town and a white area of town? Was it segregated?
yes,
Okay. And when you went to school, I think your sister testified that there wasn't anybody that looked like me at school. It was, you had all African Americans at one school
Yes,
and
it
all
was.
white people at another school.
I didn't know where this school was, but I know what school I went to, and all of us black.
Okay. And that's just the way it was back then.
Yes.
Okay. So did and your sister testified this too, but did the blacks and the whites intermingle in regards to, did y'all socialize with white folks, and did you play with the white kids? And you're shaking your head no, but you need to give me a response like yes.
Well, I put it like this, my mother and father was strict. We could not go anywhere out the yard unless they gave us permission.
Okay.
Only thing we did was went to school and to church and back home, did our homework, and we stayed basically around the house. It was a few friends that they had there. When they went, they would take us with them.
Okay. And so that's just the way it was.
Yep, living in those days with my parents, that's the way it was.
Okay. Amy, do you recall how old you were in 1944?
I was 8,
You were 8. But what year were you born?
1936, September the 21st.
Okay. All right. And so you heard your sister Catherine call you George's shadow.
That's what he called me.
Okay. So George called you that? And why would George call you his
Because every
shadow?
move he made, I was with him.
Okay. Did you look up to your brother George?
Yes, I did, because he was like my friend. We didn't know anybody there. So I took my brother, when he went someplace, I followed him. If he went outside the gate, which we had a place that had a gate around it, went there. We had one dog named Spot.
Okay.
And that was our companion, our playmate, or whatever. And we would go to the church up the hill. We went to Sunday school every Sunday morning. And we stayed at church. Sometimes they would have like things in the yard, like you cook and have food out there, whatever, you know. But it was nice. It was a good growing up. And then my daddy finally got a job at the sawmill. And we met other friends. But we still couldn't go to a place without permission.
Okay. And do you recall what kind of things you guys had, money, toys, back in those days?
Okay, I put it like this. Whatever they could afford, they bought. But I remember one Christmas, the people there could have been the white people with the money or whoever. They would come through the neighborhood with fruits and apple and the basket and thing and give us during the holidays.
Okay.
Well, they could have taken them other place too, but they did brought them there.
Okay, and so basically what you would get for Christmas, for example, you might get a toy and then,
Yeah.
and then some fruit and that sort of thing.
Yeah, and my mother loved fruit cake, and she always baked.
But you had plenty to eat, I understand.
We did.
And I think your dad did a garden and things like
Yes,
that.
he did.
And you had a cow named Lizzie.
Yes.
And we'll talk about her in a few minutes. But basically you had the essentials, but there wasn't anything extra?
No.
Okay. And so your family wasn't well off. Was that
Well, we made it.
you made it?
We made it.
Okay. And your dad was able to feed all the children and
Yes,
work
he
his job
was.
at the mill?
Yes, it was.
Okay. And I think you said he had to plant a garden, and that was, y'all ate out of the garden too?
He had a garden with just about anything you could name there, except it wasn't a big garden, but we had enough.
And you owned a cow?
Yes.
And did you own a vehicle?
You crazy.
I didn't think you did, but I wanted to ask that question. So you didn't own a vehicle at that time,
No.
so, but you owned a cow,
We had a cow.
and you had a dog named Spot.
We had a spot.
Okay.
But we went to church one night and we came back, somebody killed our dog and put him in front of our yard.
Okay. Well, I'm sorry about that.
Yeah, well, hey, that was how you live.
Yeah. And so, and you described for us basically it was a segregated town, and you know.
Well, at that time, I didn't see it.
Okay.
I really didn't see it. You know, until those girls came through. The first time I saw them was the girls came through. My mother had a job working with some people in their home, okay?
Let me ask you about. I'm gonna ask you about that. Okay. Okay. Let's go back to March 23rd. Okay. And explain to the judge why you, at 8 years old, would have such a vivid memory of these events. Why would you have such a good memory of this?
There was nothing else to do but go to school and read your books and think. And my mother and father were good Christian people, okay? And they brought us up to know the love of Jesus and to know right from wrong.
Right. But why do you remember the 23rd of March and the 24th of March?
Because I was with my brother.
Okay, but why does that stand out in your mind?
Because I was with him.
I understand that, but tell me, but what happened? What event happened that made you remember this incident?
When he came home from school, we came home from school together.
All right, is this on the 23rd?
Well, I couldn't tell you the exact date, but
Okay.
we came home from school. And my mother had come home because she had changed jobs and worked in the little school as the cook.
Right.
Okay. And my father worked at the sawmill.
Okay.
So we came on home and went in the house. All of us went in the house, and when my mother got home, she cooked.
Okay.
And we sat down and we ate. Then when it was time for my brother, his duty was to walk the cow.
Okay, that was one of his chores.
Right.
Okay. And so,
We took the car. I went with him. He always said, "Why you following me? You just like my shadow." I was. We went across the street to the railroad track, and we sat there with the cow grazing.
okay.
And they sit there talking about whatever. And there's a lady live across the track named Miss Daisy May. And she would always come to her porch and wave and say, "You guys all right?" Yes, we were fine. While we were sitting there, these two young ladies came up pushing a bicycle. And we looked around. It was strange to see them in the neighborhood because I never saw them there before. And they said, "Oh, excuse us. Could y'all tell us where we could find some May pops?" And we said no.
All right, let me ask you this. This is one of the things that the court brought up earlier with Catherine's testimony. You actually heard the girls ask about the flowers.
It wasn't no flowers. See, people getting that wrong. It was not flowers. It was maypops.
Okay. And tell us what the difference in a maypop and a flower is.
A maypop was a fruit.
I got you.
It grew like a lemon. And if you didn't get the right kind, it would tie your mouth up if you picked the wrong one.
So they were asking you for a fruit.
Yes.
Okay. And you were sitting there with George when this occurred.
Yes.
Now, did you later, Catherine said she was at the house, and did you later tell her about that?
Probably I did, but we went home. After that, when they left, they went on about their business, and they were pushing their bicycle and went in the direction of the sawmill. We went home.
All right. Let me ask you why why is this event important? Is it because these white girls were in the area? Is that?
Yeah, because we didn't see me there. We had a lady that lived in the area, and she sold eggs and things. And we would go up the hill where she lived near the church, and we would purchase eggs and things. She was a nice lady. We never had no problem with no one.
Right.
And she, as far as I know, she always lived up there. My mother would go up there. We would go up there and get eggs from her and bring them back to the house. We never had a problem.
Okay. And so, you distinctly remember that day with the girls pushing the bicycles?
Yes, I do.
Did you know either one of the girls?
Never saw them in my life.
And I believe I incorrectly pronounced the last name, and her name is Thames, which is one of the girls that was killed, but also the Binnicker girl. You didn't know either one of those
I don't
girls?
know none of them.
Okay.
We stayed in our section and they stayed in their section.
Okay. And so that was an unusual event, and
It was very unusual.
and so that stuck out in your mind.
It
that day.
did.
Okay. Now, tell us about what happened after the girls left with you and George. Were you and George still sitting there?
We sat there for a few minutes and they went on down the railroad track toward the sawmill. And eventually we got up and took the car back across the street, went in the backyard, turned the faucet on. The tub was there underneath the faucet. We filled it up with water, let the cow drink. Then after that, we took the cow down in the back and put the cow up.
Okay.
And then we proceeded to go in the house. My mother had food ready, so we sat and we ate.
Okay. And so you ate, and George ate supper? Is that
Yeah, we
basically
did,
it?
yeah.
Okay, so you had dinner already earlier that day.
No, we was in school that day.
Okay, I'm sorry. Okay, so so you were in school that day, and so you had supper.
Right.
Okay. And what happened after you had supper?
It was time to go to bed.
Okay.
But later on that night, I distinctly remember my father said people came through the area saying, "Oh, those two girls, they hadn't seen them. They were looking for, asking everybody, you see those two girls that were in this area, whatever?" And everybody said, no, there was a lot of people that got out and went help looking for those girls.
Okay. Who from your family went out?
My brother and my father.
When you say your brother, who went?
Yeah,
Who's your brother?
George.
So George actually was in the search party looking
Yes,
for the
he
girl?
went with my father looking.
Okay. And so your father actually helped look for these girls?
Yes, he did.
Okay. Did you or George discuss with anybody that y'all had seen the girls earlier that day? Well, you don't know what George said discussed, but do you know whether...
No, well, you know, because when they came through, my daddy said, come and go with me, the 2 girls are missing. And maybe he told my father he saw them, but they went on about their business near the sawmill.
Okay.
But see, other things I've heard since then, so I will not
And I know
discuss
you can't
that.
tell us what you heard.
That's right.
Okay, but just to stick to what you know.
Yes,
So
and I'm telling
you don't
what I
know whether
know.
George told your father that he's seen the
Right.
girls and y'all had seen the girls or anything? You don't know about that?
But see, one thing I'll say this much, and I want to clear the air. We are not allowed to go any place without my mother's permission. They were very strict with us. We could not go no place, nowhere.
Okay. So your mother kept a pretty tight rein on y'all?
She did.
Okay. Well, let me ask you this about George. What kind of person was he?
All he wanted to do, he was smart. All he wanted to do was be an artist and draw. He loved to see airplanes. And he always had a little pad, my mother bought him. And every time he saw an airplane fly over, he would try to draw that airplane, or either a car or whatever. He said he wanted to be an artist.
Okay. And so he was an artistic kind of person. Would you call him quiet or loud? Or?
He was quiet, but he was smart.
Okay. And now, the next day would have been, I think, a Saturday, or 24th,
Yes.
whatever the 24th would have been, okay? 1944. Do you recall the events that happened that day?
Yes, I do.
Okay. Tell us what happened.
One of my brothers came from my grandmother to spend the night with us.
And that was Johnny?
That was Johnny.
Okay.
And that day, my sister went to get her hair fixed. I think Charles took her. My brother Johnny, my brother George, and I were in the house. I came outside. My mother had ordered some chickens from Rhode Island Red.
Okay.
And the little bitties was flying all over and playing all over the yard.
Okay.
And I was out there in the yard with them. When I looked up, I saw these 2 black cars, funny looking old time cars, long and whatever, pull up. And these men got out.
What
I
kind of
didn't.
men were
They were white guys that.
they? They look like me?
Yep, just like you.
And
Mhm.
they look like the Slizzers, did they?
Look just like you.
Okay.
And I hid in the chicken coop
Okay.
because I didn't know what to do.
And so, I mean, was that unusual in your mind? Is that something that you
I've
didn't
never seen them in the era before. What was I supposed to do? Stand up there and greet them?
I mean, you've seen white men before, obviously, but you never seen
Yeah,
them.
no, I've seen them before, but not the one in uniform.
Right. And so what happened?
I got
What
in-
did you do?
I went in the chicken coop and I stayed there.
Okay. So you hid out in the chicken coop.
Yeah, I stayed right there. So when they went in the back door, through the house, and when I looked, they had both of my brothers.
Right.
And I said, George, y'all leaving me? Where y'all going? He said, go get Cat and Charles, get Ma. And they took my brothers away. And I never saw my brother alive again.
Let me ask you a question. You witnessed the police go in?
Yes, I did.
You witnessed police come out?
Yes.
What did they have with them when they came out?
Nothing but had my brothers in handcuffs and them little sticks, whatever they had.
Okay. Did you see them go into the house, bring clothing out, for example?
No, I did not.
Okay. And you would have remembered that?
Yes, I would
Okay.
have.
Now, had George had blood on his clothing the night before, would you have noticed that?
Yes, I would have.
And I talked to Catherine about the fact that you guys live in very close quarters. Did y'all pretty much know what each other were doing all the time?
Well, like I said, my mother, the way we lived, my mother had a section off for the boys.
Right.
You know, like you put a curtain there for the boys.
Right.
And then girls we section off.
Right.
Okay. And that's how we lived.
Okay. And so when Johnny came and he spent the night,
He was in the living room on the living room chair.
Okay. But you had a little curtain that divided the two. And,
Right.
You know, if I was to ask you how many sets of clothes George had, what would you?
I gonna answer that.
You don't know?
Why would I know? I didn't buy them.
Okay, I understand that, but I'm just asking you, did y'all, what did you have? Did you have like a school clothes?
I had school clothes.
Did you have work clothes?
No, I didn't work.
Play?
I had whatever I had it.
Okay, but y'all didn't have a whole lot of clothes?
No, we didn't have a whole lot. But see, it was a store up on the highway. It was an everything store.
Right.
It sold everything in that clothes store. And sometimes my mother, if she worked for people, they'd give her clothes and things for us. So we used what we had and what people gave us.
Okay.
You know.
So there wasn't a whole lot of clothing?
No, but she always kept us clean.
Do you believe that you would have remembered if there were bloody clothing and that?
I would have.
Okay. And you don't recall seeing that? Is that a no?
I didn't even see that.
And this lady right here who's speaking in his mouth, she's taking down every word she says.
Okay.
So, okay, if you would just yes or no and that sort of thing. So, okay, so she's having to say it, and it's difficult for her whenever you do this, and she's got to say that you
No,
shook her head.
we had enough. We had plenty of food.
Right.
We had clean clothes. It might not have been a lot, but we had them.
Okay. Now, after George and your brother Johnny were taken away, what happened next?
Well, we didn't see Johnny again for a good little while, and we didn't know what happened to him, because he had already signed up to go to the service. And they took George. And Johnny ended up in King Street, and he came back. They threw him out the car.
Well, tell me about that.
On the highway, because when he got in touch with his mother, my mother, he said they threw him out the car on the highway.
Okay.
And he walked, or wherever the close he was, to King Street. And it took my brother to Manning.
Okay.
Okay?
Right.
And I saw pictures with it, but, well, I don't know who did it. Because I got a Jet magazine not some years ago, and I still got it. But I know one thing. Those girls went on about their business, so I don't know what happened to them. And my brother only weighed 98 pounds, was 14 years old. And I feel like if he wanted to do anything to those girls, they would have beat him. 2 girls fighting him would have won.
All right, and I understand that's your opinion, but we'll talk about that later.
Right.
All right, now, let's get back to what you remember. So Johnny gets, according to you, gets thrown out of a vehicle by the police, and they take George and put him in custody. Is that correct?
Right.
Okay. When's the next time you saw George?
I never saw him again.
You never saw him again. Do you remember your parents going to see George before the trial? Is that a no?
That's a no.
Okay. Do you remember a Mr. Plowden coming to your home and speaking with you, your sister Catherine, or your brother Charles?
I don't think, no, unless he went to something, because we had moved, so I couldn't tell you. That was the truth.
Okay, so nobody ever tried to track you down and try to find you as a witness?
Oh.
Okay. Tell me about the night that you had to leave and go to Pinewood. You remember that event?
Yeah, my sister keeps saying that we were at the train, but I remember my mother had a friend named, we call him Pat.
Okay.
He was from India,
Okay.
and he had a car, and he came and got us and took us out of Dodge.
So why did he come get you?
Because he had heard my father had gone ahead to try to find some place for him to stay, and came back to get us.
Okay. But why did y'all have to get out of town that night?
Because we heard the mob was coming to take us out.
The family?
Yeah.
And was your parents concerned for the safety of you and your siblings?
Yes, they were.
Okay, I mean, they already had George, but were they concerned because this lynch mob, for lack of a better word, was coming to get you?
Not me, they were coming to get the family, period.
Okay.
And that was told to me, and that's what I understood, because my daddy just said, yo, we gotta leave, we gotta get out of here.
Was your dad scared?
Yes, he was. He left. He went and got him a place, and he sent Brother Bay back to pick us up, because he went to try to find help for us to get out.
Okay. And was your mother scared?
Of course. Why wouldn't you be?
Well, I asked you, Amy, and
Yes.
I'm asking you this because I wasn't there, and obviously I wasn't even born.
She was afraid.
Okay.
She was afraid for us, and we was afraid for her, and we were afraid for ourselves.
Okay. And was she upset?
Yes, she was crying.
She was crying. Okay. And so did you guys get out of town that night?
Yes, we did.
Okay. And you said I believe you said someone picked you up in his vehicle.
To my remembrance,
Okay. Well, who was this person who picked you up?
well, it was a guy from India. We called him Pat, but he was Brother Bay.
Okay. Was he Indian, white, or?
He was one of the foreigners that one of my mother friends had married.
Okay. All right. So he's just somebody who had a vehicle.
Yes.
Okay.
He had an old-fashioned vehicle too,
And I was going to ask you how you got to the train. Was there a train station in Alcolu?
somewhere.
Huh?
He was there someplace.
Okay, but he picked you up and carried you off to the train station and,
No, he took us to Pine Woods because he was in Pine Woods.
okay. And later on, I guess somebody went to Sumter.
Right.
Y'all may have taken the train from Pinewood to Sumter?
My father went to Sumter,
Okay.
and we stayed with my grandmother until he found lodging for us
Okay.
in
And,
Sumter.
and your grandmother's name was what?
Maggie Brown.
Okay, and so she had a different last name than Stinney. Is that correct?
My
Obviously.
mother was married to George Stinney,
I
and my
understand.
grandmother was named Maggie Brown.
I'm sorry, your grandmother's maiden name or name was Brown.
Yeah.
Okay, did y'all feel like that was a secure place for you to be, that no one could
Well,
find
I
you?
don't think nobody knew where we came from, so wherever we went to my grandmother's house.
Okay. Were your parents concerned that if you didn't get out of town, something was gonna happen? I know you talked about the lynching and all that.
Yeah,
but-
we were afraid.
Okay.
We were afraid.
Did anybody from the sheriff's department come and say to your parents or to you in your presence that, hey, we're gonna protect y'all, we're gonna take care of you and make sure, did that happen?
No, excuse me. The only thing I know, they had police there in uniform. I didn't know nothing about a sheriff or nothing. The only thing I saw was a car.
Right, and that's when George was picked up.
Yeah, when he was picked up, I saw two black, funny-looking cars.
And I believe we had talked about the fact that you don't remember talking to any attorneys prior to this event. Is that correct? Prior to George being convicted.
No,
Did you talk to any attorneys? Did your family talk to any attorneys after the fact? Is that a no?
they didn't talk to anyone. And
Did
they
your
all,
family have the money or the means to hire somebody to appeal George's conviction?
no.
Okay. Do you recall George's funeral?
Yes, I did.
Okay. And did you recall, was there an open casket?
It was slightly open.
Okay. Do you recall looking in there? Can you tell us what you saw?
He was burned.
You talking about George was burned?
Yes, he was burned.
Was he recognizable?
Not too much, not really.
And when George was buried, where was he buried?
And at Calvary.
Okay. And I think y'all chose to bury him in an unmarked grave, is that right? So yes?
Yes,
Okay. And can you tell the court why you chose to bury him in an unmarked grave?
because we was afraid that people would come and desecrate his grave.
And his grave's still unmarked today? Is that a yes?
Yes, it is.
Now, Ms. Stinney, much has been made about the fact that no one has done anything after this conviction. But let me ask you this question. When he was executed, what could your family do?
What else?
I mean, but what could you? I mean, his brother's dead, right? Is that right? I mean, did your parents talk about this? There's just absolutely nothing. I mean, he's dead. What do you do?
Was nothing we could do.
So, between his conviction in April and his execution in June, that would have been the time for someone to have done something. File an appeal, ask for the Supreme Court to stay it, do something in this case. Is that correct?
It should have been.
Okay. Do you understand that a lot of people wrote then Governor Olin Johnson letters asking for clemency for your brother?
Yes.
Okay. Are you aware of the fact that the governor had granted clemency to a 16-year-old white boy that same year? Are you familiar with that? And you're shaking your head yes. Can you say yes?
Yes.
Okay, you're familiar with that fact. And but your brother, who was 14 years old, was not granted clemency by the governor.
That's right.
Okay. Of course, I don't know. Amy, I didn't get any background on you to start with. You currently live where?
In Newark, New Jersey,
And are you retired?
since 1966.
And what did you do for a living?
Before I got married, I worked at the inspector at a place called Mansell Ceramics.
Okay.
I was the inspector for television and making sure the tubes didn't fit right.
Okay. And when did you leave South Carolina?
Oh, I don't know, it was in the 50s, somewhere around up in the 50s.
In the 50s?
Because what I did, I left and I went to Kentucky.
Okay.
And I stayed for a while and I came back. And my sister came up here and I came up and I didn't like it, to Newark, and I went back home. When I got back, most of my friends had disappeared. So I came back again.
Okay. And so how long have you lived in New Jersey?
Officially I came back in 62, 61 or 62.
And we haven't talked about your father and your mother's educational background. Do you remember what could your father read and write?
Somewhat.
Somewhat. So he had some education, but not a whole lot?
He had enough to do what he wanted to do.
Okay. Did he have, do you know how far he went in school?
I never asked.
Okay. How about your mama?
Not far.
Okay, your mama didn't have a whole lot of educational background?
Mm-mm.
And I think I recall you telling me that George actually wrote letters for her.
He did.
Okay, and did he write letters for your father too?
No.
Okay, but he wrote letters for your mother?
Yes.
Okay, and so between April when George was convicted and when he was executed in June, did your family, were they contacted by anyone from the state of South Carolina about an appeal in this case? Is that a no?
That's no.
Okay. Did Mr. Plowden come see you or your family and ask you about an appeal
No.
that you're aware of?
That I'm aware of. I didn't see him. For a fact, I don't know who he is.
You know he didn't?
No, I don't know him.
And what have you done in the years since George's execution? What have you done in the years since George's execution that's trying to get this case overturned?
Search for the truth.
Okay. And you've talked to various media outlets?
I talked to a lot of people, and I have a lot of material that was sent to me.
Okay. And but have you ever been able to have an attorney that came forward and said, we're willing to handle this case for you until now?
No, we never did. I wrote to various people. A lot of people went and they got material. I got it all home. And I think I gave you a copy of one. Somebody sent me a paper. They've been sent. I had these things. I didn't know what to do with them. I reached out to Oprah Winfrey to help. She said no. I reached out to other people. They said no. So I said okay. Then I took my eyes and I looked upon the Lord. And I asked him, I said, Father, I want to know what you can clear this up.
So you went to various people to try to get help and nobody would help you? Is that correct?
Yep, and then I met Mr. Frierson.
Okay. And that's George Frierson?
Yes.
And at some point in time, my law firm got involved in this?
Right.
Okay. When your parents, when George was electrocuted, What was the reaction of your parents? I know they were upset, but can you tell the court so you can describe to them how they reacted to that?
I don't object to that.
Okay. Sustained, it's not relevant in this
Okay.
case. I think we've established that he in fact was electrocuted. I think we need to move on to what we're
Okay.
here for.
All right, thank you. Your Honor, I believe that's all the questions I have on direct.
Steve, I got one more. Open door, John. I know, but that's okay.
All right, Amy, one of the things on George's educational background, he was in 7th grade. Do you
Getting
recall
ready to
that?
go to the 8th grade, yes.
They held him for a year?
Hmm?
I'm sorry, what did you say?
No, he was being promoted to the 8th grade. He was in the 7th.
He wasn't in the 7th?
He was in the 7th and getting ready to go to the 8th grade.
Okay. And he was 14 years old, right?
Yes,
Is that correct?
yes.
Okay. That's all the questions I have.
Solicitor?
Thank you. Please report.
Yes, sir.
Ms. Ruffner, good afternoon.
Good
How are
afternoon.
you today?
God is good.
All the time. Ms. Ruffner, you know what this is?
Yeah, well, I have my glasses on, I can see, but I don't.
Do you have your glasses in the courtroom?
I suppose so, I don't know. Yeah, I
Can
do.
someone assist her in getting her glasses, please?
Oh, Ickley. Thank you.
Water, if you like.
Thank you.
Can you identify that document?
Yeah, I wrote it. Why?
When did you write it?
Don't ask.
It's at the top corner on the right-hand side.
Oh, Mediterranean Night. How did you get this?
Your lawyer gave it to me.
What lawyer?
What is it? Mr. Steve McKenzie? What is the date on the paper?
This is May the 23rd, 2009.
Is that your handwriting? Where it says May 23rd, 2009? Is that your handwriting?
Could be. This is my name down here.
Do you remember giving an affidavit to somebody who was a notary public for the state of New Jersey in 2009?
No, I don't.
Do you see a signature on that paper?
I see a signature.
Is it your signature?
Yes, this is my signature. And this is my girlfriend that signed it.
Your girlfriend was the notary public?
Yes, she was.
Did you sign it?
Yes, I did.
Did you attest to the truthfulness of what was in the statement?
Well, did you read it?
I did read it. Did you read it?
Yes, I did. I
Is
wrote
it true?
Yes, it's true.
In 2009, you wrote that statement for who?
Writing it for myself.
For yourself.
I didn't have a lawyer.
And after you wrote it, what did you do with it?
Oh, probably put it. I don't know. You got it, so maybe you took it.
May I see the statement?
Sure.
In the statement, would you agree with me, it says to whom it may concern?
Yes.
And does it contain 2 typewritten paragraphs?
Yes, it does.
Did you type them?
No, I didn't.
Okay. Did you give the information to whoever typed it?
Maybe I did.
You don't remember?
Nope.
Okay. In the first paragraph, you talk about your family and Pinewood and moving and Catherine was in the 3rd grade. You remember all that? Do you remember saying this in the paper?
Sweetheart, let me say something. A lot of times, I got a lot of hurdles in my life. Maybe I did, maybe I don't.
Well, let me ask you this.
What?
If you can't remember what you wrote down in 2009, why should we believe that you can believe something that happened in 1944?
Because I was alive in 1944.
Okay. I think everybody needs to step down. If you want to give her a copy of her affidavit and allow her to review it.
I was alive.
Did you write that statement in 2009?
Maybe I wrote it
All right.
and someone typed it.
Solicitor,
Yes, ma'am.
give her an opportunity to review the statement, and then you can ask her any question you would like. Ma'am, go ahead and take an opportunity to review it.
You know what? I think I was getting ready to write a book.
You're getting ready to write a book.
Yeah, write a book, a little thing, a reminder of what happened. Put my thoughts down on paper.
Ma'am, his question is directed to, is that your statement?
Yes, it
Did you
is.
write it?
Yes.
And his question was, is it truthful?
Yes, it's truthful. This is truthful.
Okay. Solicitor.
Thank you. Would you read the last sentence on that page, Ms. Ruffin?
At home, I ran the water in the tub. The cow finished drinking water. My brother put the cow in the shed, and we went into the house to eat and start our schoolwork.
So on Friday night, you and your brothers and sisters finished your chores and went to do your schoolwork.
I didn't say my brothers and sisters. I said my brother and I.
That would be George and you.
That's right.
And you all had schoolwork for the next day?
We always did our schoolwork ahead of time. Because my mother said, you do it now, you won't have to worry about it later.
All right. So you all worked on schoolwork for Friday night.
Oh, yes, we always did.
Do you remember going out anywhere?
We didn't go anywhere. There was nowhere to go.
All right. And you testified that based on your recollection, George went with his father later that night to go searching for the girl.
Because they came through and asked the people in the neighborhood to help look for them.
Is that in the statement?
No, I didn't put that here.
Okay. Did you put in the statement that any of the other things about getting in the chicken coop when the men came with the
I didn't
funny
have to
call?
write that. I did that. I didn't have to write that down. I got in there.
Okay. You didn't put that in the statement.
Why would I? That's the part of life that I live.
And you're getting in the chicken coop so that...
I did not know the people, so I called myself hiding.
All right. And that wasn't important in 2009.
It
to
was
put in your
important to
statement.
me to hide from them because I didn't know who they were.
All right. And how long did you hide in the chicken coop?
Until they stayed until I saw them breaking my brother's house.
All right. So how long did you stay in the chicken coop?
I wouldn't know.
Do you remember living in Alcolu and playing and going around the town in
In
that
what town? There was no town there.
around the area where you lived?
We couldn't go no place without my mother say so, okay?
All right. And so you went to school
Yes, I did.
and you came home.
Yes, I did.
And your mother would be home.
Yes, I did.
And-
After she got off of work, she came home.
So sometimes she would not be home when you got there.
Of course, it all depends on that she had to clean the kitchen up in the school that she worked at.
And after you and your brother would do the chores, take care of the cow, you would come back home and stay at home, do your homework, and get ready for school the next day.
Of course. But see, you're missing the point. It was my brother, 2 brothers, and my sister. Okay? It was 4 of us there.
All right. And when you wrote that paper in 2009, did you talk to them, your brothers and sisters, about what you remember?
No, this is for me.
Okay.
For me,
Have you ever written any more papers?
maybe.
Did you give them to your lawyer?
What lawyer? No, I
That's-
didn't
that's not
because
your lawyer?
I didn't have a lawyer at that time,
Do
okay?
you have a lawyer now?
Yeah,
Did you give him any other
maybe
papers?
I did. Not other papers. Maybe I give him this one.
You don't remember if there were other papers that you
It
wrote?
was others I wrote, but I didn't give them to no one.
Okay. When it came time for you to go to the funeral, what did you ask your parents had happened to George?
Who said that?
I'm asking. You have a family, you're getting ready to go to a funeral for a family member. When did you ask your mom and dad?
I didn't ask them anything because I already knew what had happened. I didn't see my brother from the time they took him until they killed him, okay?
And during that time, you didn't know why they took him or what had happened?
I knew they took him. And then later on, everybody say they were accusing him of killing those girls. And I knew that was a lie.
And that's all you know?
That's all I know. And
You didn't ask your mother and father?
well, because we had friends coming over. And the pastor from the church that we went to something, he came over. He talked to us.
What about after the funeral? When it was just you and your mom and your dad?
What do you think happened after? We were devastated.
Yes, ma'am. And did you never ask, why did George get taken out of the family?
My mother wasn't home, so how would she know?
She wasn't home?
She was at school working, okay?
So from the day of the funeral to today, you've never had a conversation with your mom and dad about what happened to
I
George?
never asked because my mother and father is dead.
And from the time of your, I believe I was told by Catherine that your mother passed last. From the time that Catherine, your mother passing, and it was just the children living, from that time to now, you never hired a lawyer to look into this case. You never wrote the book to set the record straight. You just waited on some good lawyers to call you and say, we'd like to take the
I
case.
wrote a lot of papers, but I never gave them to a lawyer. They were for my benefit.
I thank you, ma'am. May I
I
have my
thank you
paper
too.
back?
Sure, you can have it back, but my name is on it.
Just one call here. Mr. Finney asked you about your mother passing away.
Yes.
Did your mother tell you anything on her deathbed?
No, she didn't talk to me. She talked to my girlfriend.
Okay, so you don't know what she said?
No, she wasn't dying at the time. She was in the little room. She had stayed with me. You know, she came during the weekend and stayed because she was kind of sick, so I let her stay there with me. And my girlfriend lived next door. Her name was Delaney Austin. And she came over and she talked to my mother. And she was telling me about, because
I
my,
object at this point.
well, I'm talking about something different. My older brother had died, Leroy. And they was talking about him because my cousin owned a funeral home, Fleming's in Manning, and she had got his body from New York. My mother was talking to her about him, and then she brought up George. She said the only thing she ever wanted was her son in class.
Number one.
And that was it.
Sustained, obviously. It's hearsay, it's not appropriate.
Thank you. All the questions I have.
Ma'am,
Yes, dear.
who is your lawyer representing you in this case?
Mackenzie, over there. I never had lawyers before.
Mr. McKenzie? All right, ma'am. And does he represent anyone else?
Not that I know.
Okay. Ma'am, additionally, is your elder brother, Johnny Green, still living?
Johnny died.
He's passed away?
Yeah,
How long ago did he pass?
about 2 years ago.
Okay.
Well, see, before he died, Johnny was in a, what you call it, a nursing home?
Right. Assisted living home or a nursing home?
A nursing home.
Okay. All right.
He had,
Did you ever speak with your brother when you got older about his detention and then release by the police?
well, Johnny,
Yes, ma'am.
you couldn't talk to him. He would only let you know. See, my brother was like this. Johnny loved people. When that happened to him, Johnny hated everything that walked. He did. He did. He hated everything that walked because he said it took my brother and they killed my brother.
What did Johnny go on to do after he grew up?
He worked for the school system as a driver. They go pick up different things and would take back to the school, you know. He worked around the school, but he had a good job. He
Where
did
did he
good.
live?
In Brooklyn.
In Brooklyn?
Mm-hmm.
Okay. Ma'am, did you ever consider before either this affidavit in 2009, which I understand you state that you wrote because you thought about writing a book, but had you ever considered before now coming forward?
Well, at that time, you know, when you, my husband died, I was expecting, like I said, I had kids, and my husband died in 2001. Some guys came to my house, and my son allowed them to stay upstairs. And they called to my son to get him out the house, and they did. My husband's a longshoreman, And he was on his way to work that morning. He had to be to work. He was a heavy lift driver. And as he opened the door to walk out, the police had the guns in his face. And not for him, but looking for the guy that was there. And my husband had a heart attack. He didn't ever recover.
Ma'am? I'm sorry. I
He
couldn't-
never recovered.
Okay.
So he died in 2001 when the towers fell in the air. He died.
Okay. My question to you is, did you ever consider bringing this case when there were still potentially some
Well,
witnesses?
just, you know, like I say, when you have help and can talk to people that try to lead and guide you, it's good. But when you try to do something by yourself, it's hard.
I understand that, ma'am, but if you'll let me finish my question.
Okay.
The question is, did you consider bringing this case or seeking someone out when these people and potential witnesses in the trial of this case were still living? Because certainly that would make this process easier. Obviously, you are one of the few people, and you weren't present at the trial of the case.
You know.
So again, did you consider it back, late 60s, 70s, 80s,
Well, I
90s?
reach out to different people, and I got a lot of things, material that they sent me from Charleston, from a cop from upstate New York. He went down and searched for the truth, and he sent me papers, and other people. I got a lot of papers on me that people sent me over the years, and I try to show the people, and I give my son something. And then I met Mr. Franson, and I showed him things, and reached out to him for help, because I tried.
Okay, ma'am.
I really tried.
I appreciate it. Does anyone have any further questions of this witness?
I have one question.
Go ahead, Mr. McKenzie.
Ms. Ruffin,
Yes.
after your brother was electrocuted by the state of South Carolina, what remedy could your family have asked for from the state of South Carolina that you were aware of?
Like such as?
I mean, could they bring your brother back to life?
No.
So in your mind, that was it. Is that correct? Is that the mind of your family? Is that the mind of your father and mother?
No, my mother and father, they grieved for my brother. What could they do? They didn't have no money.
They had no money.
They
Okay,
didn't have nothing.
but in your mind, I mean, he's dead. What else can we do? Is that right?
We can clear his name.
I'm sorry?
I would love for his name to be cleared.
I understand that now, but as far as procedure, you're not a lawyer. You don't know the ins and outs.
I don't
of
know
course.
the ins and outs of it, so what could I do?
But they killed your brother, and I think they killed your brother on June 16th. On June 17th, what remedy was available to bring your brother back to life?
Nothing.
That's all the questions I have.
Anything further? You may step down.
Thank you.
Who is your next witness?
Your Honor, that would be the video testimony of Bishop Charles Stinney, who is the brother.
How long is that video?
I think it's 45 minutes. Roughly 45 minutes.
Okay, let's go ahead and take a very brief recess, if we don't mind. Ladies and gentlemen, by the clock, I would like to return back into the courtroom at 3:10, where we can go ahead and begin the video. All right, we'll be at ease until then. Thank you all. Please be seated. All right, are we all queued up for this deposition?
We are, Your Honor, and we would call as the next witness by video deposition, the Bishop Charles Stinney.
Okay.
And as we had told you earlier, James, the two people traveling today, but we had DVD and the solicitor was available for cross-examination at that time, so, and we were offered now.
Okay, is that correct, solicitor?
Yes.
Thank you. Thank you. All right.
Thank you, Your Honor.
It's Tuesday, 13th. This is the opening of the deposition of Charles Stinney in the matter of State of South Carolina versus George Stinney Jr. The deposition is being held at the offices of Stinney, Brooklyn, located at 16 Court Street, Suite 907, Brooklyn, New York, 11241. Court reporter is Roseanne Laveau with Diamond. I'm the legal videographer, Zoltan German, also with Diamond. Would counsel please introduce themselves and the parties they represent?
My name is Ray E. Chandler, and I represent the late George Stinney Jr., along with Matthew Burgess, one of our lawyers who is with me now. On the telephone is Mr. Steve McKenzie from our firm, and the Third Circuit solicitor, Mr. Ernest Finney.
Would the court reporter please swear in the witness, and we may begin.
Sir, could you raise your right hand for me? And do you affirm that you will tell the whole truth and nothing but the truth today in this deposition?
Affirm.
Okay.
It's just right after 12, but we've been together for about an hour and a half. How are you feeling, Bishop Stinney? And we understand that we're doing this up here because of some recent health issues you've had would make it difficult for you to journey down to South Carolina. Am I correct?
That's true.
Okay. Give me your full name, please.
Charles Stinney.
And you are a resident of Brooklyn, New York, is that correct?
That's right.
Okay. And you are a widower.
That's right.
And you are the brother of my client's estate, George Stinney Jr., is that right?
That's right.
We were talking earlier, you were telling me about your life in Alcolu, South Carolina. What did your daddy do that took you to Alcolu?
He was working at lumber yard.
Is that the Alderman yard? Alderman Lumber Company?
I don't remember the name right now.
Okay. As a result of his working there, was a house available to your family?
Yeah, they had houses and we would rent from the company.
And in addition, there was a store there for you to buy from, is that right?
That's right.
And like some of us who were raised in industry, we called it the company store.
The company store, that's right.
So you had the store there, you had your housing there.
That's right.
You had some half-brothers, one of whom lived in Pinewood with your mother's mother, is that right?
That's right.
But when you guys were living in Alcolu, there were basically 4 of you, is that right?
That's right.
2 boys, George and yourself, and 2 girls, Catherine and Amy Lou.
Right.
Okay. And at the time that we're getting ready to talk about in 1944, George, your oldest brother, and Amy Lou was the youngest.
Right, that's right.
George would have been in the 7th grade, possibly the 8th, and Amy Lou was just in the 1st, is that right?
Right.
Okay. And it was in March of 1944.
Right.
And during that time, you lived in what we would call a segregated neighborhood, didn't you?
That's right.
Okay. And the railroad tracks separated where the white people who worked for Alderman Lumber and the black people who worked for Alderman Lumber, is that right?
Well, the railroad, we had, in that particular area, on the side of the rail, it was both black and white. But there's another area on the other side with the rail and so forth.
So back then in South Carolina, although the men worked together, their families were segregated, is that right?
Yes, right, that's right.
And it was kind of the understanding that you folk did not mix together, is that correct?
Right.
And that's just the way it was.
Right.
You had your own church?
Right,
Correct?
that's right.
You went to your own school?
Right.
Okay. So then, after you guys got off from school, what would you do normally?
We would be around the house, maybe playing some activity outside, and then they're going to do our schoolwork and so forth.
What type of flooring was in that house?
It's a wooden floor, as I can remember, quite some time ago. It was a wooden floor.
Was it 3 or 4 rooms for all 6 of you?
It was the kitchen, it was bedroom and living room, and the kitchen and a bedroom and the living room. The boys live in the living room, family living in the middle room between the kitchen.
So with 6 of you in there, it must have been pretty crowded.
Pretty crowded.
You probably didn't have very much privacy, did you?
No, we didn't.
And we talk about that day in March on the 24th. Do you recall very vividly, I'm sure, exactly what happened in your family? So the normal day would have been you'd come back from school, right?
Right, that's right.
And the cow that your dad kept cows and pigs and chickens, right?
Right.
And he farmed vegetables.
Right.
And that was kind of how you got along, wasn't it?
Right.
You got milk from the cow.
Right.
And your daddy had the vegetables.
Right.
You bought your stuff from the store.
Right.
And so this day, you recall George had a chore, and what was his chore as the oldest in the family?
I don't understand.
He had to, something that, who took care of the cow after school?
It was George, he was take care of the cow.
And how would he take care of the cow?
Well, after he got out of school, he would get the cow installed and so forth and take her out to graze.
Okay, and so cow would go out to graze.
Right.
And how far about from the house was that?
It wasn't wasn't too far.
Okay, well, if you stood at the house, like say you were telling me that y'all didn't misbehave much because your daddy knew everything that was going on, right?
Right.
And so if you were near the house, were you able to look out to the area where the cow grazed?
Right, we can see it because it's right in the same area.
And so if you went to look for George, or you went to look for Amy, you went to look for Catherine, there would be a small area that they would be in.
Right.
Is that right?
Right.
Were your mother and dad pretty good disciplinarians? They kept y'all in line?
That's right.
And you told me that your brother George might have been the smartest of the four of you.
He was pretty smart.
Okay. He was a good writer?
Yeah.
Good writer?
Good writer.
And he helped y'all with your homework?
He helped a lot with homework.
And you told me that George was, although he was 14, he was not really developed. Is that right?
Well, he was still kind of small and something.
Right. He was a small child.
Right.
And I think you said we were all pretty small then.
Right.
Basically, it was four children.
Right.
You know, running from about 6 to 14.
Right.
Okay. And your mom and dad, you said your daddy knew everything that happened, so if anybody misbehaved, the word would have gotten out. By the time he got home, you just had to go tell him.
That's right.
And you did. Is that right?
That's right.
And I think you indicated to me that George was pretty well behaved.
Right.
And that he was kind of acted responsible for the younger children.
Right, that's true.
And that none of y'all really enjoyed taking the cow out, did you?
Well, occasionally, George was available sometimes, I would do it or something, but he's not available.
And so this day, as you recall, George took the cow.
Right.
And your recollection, you told me in the car, was as clear as day about this. Is that right?
Right.
That next 72 hours was something you'll never forget.
That's true.
So where were you when George started to go with the cow to graze?
Me and my mother went to the company store. I went to do some shopping with her.
And you were going to help her carry the stuff back?
Right.
Because you had to walk?
Right.
Okay. And that store was about how far from where you lived?
Maybe a half a mile or something.
You had to walk a half a mile and shop and then tote the stuff back.
Right.
It would have taken you, you said, an hour or so to accomplish that. Is that right?
That's true.
Okay. Now, Catherine was not home then.
Catherine, I can't remember where she was at that time.
But Amy Lou was.
Right.
Now, when we talked in the car, you said that your mother would not let Amy Lou stay around by herself. Is that right?
No, because otherwise she George would take care of her and be there with her.
You would let your mom, because he was the oldest.
Right.
His job was to take care of Amy Lou.
Right.
While your mama went shopping.
Right.
Okay. And so that day, the 24th, your recollection was, where did Amy Lou go?
Well, she went with him to take care of the cow. And
the cow had to graze.
Right.
Y'all milked it at night?
Not at night, in the morning.
In the morning?
Right.
You can tell I wasn't raised on a farm. And so you take the cow out to graze. So your mama had gone to the store. Amy Lou went with George.
Right.
Now, when you got back from the store, were you helping your mother carry the stuff in?
Yeah, we whatever we had, we help her take it in.
Okay.
Right.
And so when you got back, when was the next time you saw George?
Well, they was she had been home by the time we got there.
Okay. Were they back there when you got home?
Far as I can remember.
Okay. And when they came in, were they together?
Yes.
Okay. So Amy Lou didn't come in, and then a later time George came in.
No, they come back together.
They came back together,
Right.
and I assume that Lizzie made it back with them.
Right.
Right. So George would have then put the cow up.
Right.
Right. And then come back in.
Right.
Okay. Now you told me that later that afternoon, that evening, there was a party, as you recall.
Right.
A neighbor party where
Right.
people would get together at their house.
That's right.
Right. Do you recall going to that outing?
We all went.
Okay.
My whole family went over that night.
Okay. And so George was there as well.
That's right.
Okay. And when was it that you first learned that evening that there were 2 young white women missing?
After the party that night, after we went back home, and somebody come to it and tell them that they was missing.
Okay.
So all the neighbors and my father and all the rest in the community went out looking for him.
Okay. And so your dad was part of that
Right.
group. And at some point, it was learned that these 2 girls had spoken with Amy and George.
Early, and there was after some fall or something, I think it was, and they said they didn't know nobody not there, so they went on their way, kept on going.
So to make sure I got this right, while Amy and George were out with the cow, these 2 girls came up looking for some flowers to pick. And they did not, the flowers were not in that area.
Right, that's what it is.
And so Amy and George had told you that the 2 girls left.
Left, they went on their way.
Okay. And shortly after that, Amy and George brought the cow back.
Right.
Okay. So after you went to the party, everybody was at the party, did y'all just come home for the evening?
We come home in the evening.
Okay. Now, I want to ask you about how many outfits of clothes you guys had back then to wear.
Not many, because at that time they just didn't have too many clothes. So.
And when George came back, if he had had blood on him, you would have noticed it.
Right.
Okay. When Amy came back, did she seem upset at all?
No.
Having a sister that was 4 years younger than I was, you recall that if anything had happened out of line, Amy would have told it.
Right.
She would have been the first to tell Mama.
That's right. That's right.
Okay. And sometimes you don't wish that was happening, but it's a reality.
That's right.
She would tell it, right, on Mama.
Right.
Your Mama switched you on.
Well, she probably did more than our father did.
And so, other than the fact that they had seen those 2 girls, from the time you saw George come back with Amy and with Lizzie, through the time that he went to the party, right?
Right.
And you guys learned later that these girls were missing. Did George's outlook or attitude change at all? Did he act any other than he would every day?
No, it still seemed the same.
And so, were you there when they took George away?
No, I wasn't there. My father, Catherine had to go to the hairdresser, so he told me to go along with her.
So Catherine went to the hairdresser.
Right.
And you went to be with Catherine.
Right.
It's kind of like George with Amy.
Right.
Right. You kept up with Catherine and,
Right.
and George kept up with Amy.
That's right.
Okay. So she's at the hairdresser, you're with her.
Right.
You come back, did you find that not only George was gone, but your other brother was
Right.
gone? Okay. And how did your mama act in fact?
Well, she wasn't home either. She was in Sumter.
Okay.
And somebody must have told her. And when she come back, then she was driving back, and then she was very upset and calling his heart and everything because she was very upset.
She was hollering and crying.
Right.
And was your mother your father or any of the members of your family able to go see your 14-year-old brother between that time that he was taken away and the time that he went to trial?
No, no.
How long was it before your second brother was let go and come back?
Well, I don't remember because I don't think he come back at the same time because when we had to leave that same night, I don't remember being with us. I think he must let him out, but it put him on someplace else. So,
was he living in Pinewood?
Not him. He was living with us.
Okay,
right,
all right. So, but your recollection was that your other brother, not George, was released and came home.
No, I don't remember him coming back home.
I got you. But he was released
Right.
at that point. So when the men came, they took two.
Right.
Okay. And what was your other brother's name?
Johnny.
Johnny Green.
Right.
Okay. He was your half brother.
Right.
Okay, I got it. So Johnny and George got taken away, and Johnny came back.
Right.
Did you ever have a chance to speak with your older brother, George Stinney, again from that time?
No, never. I never seen him and never talked with him again.
But your parents went to see him
Right.
in Columbia.
Right.
And a few months after that, after his trial, he was found guilty, right?
Right.
And your mama went to see him.
Right.
And when she came back, was she still very upset?
Well, she seemed, when she told me, she seemed calm. I guess she just had to just calm herself down from, but when she went to see him, she, let her know he wasn't guilty.
Told your mama he didn't do it?
Right.
And did they have any money to hire anybody?
No, we didn't have no money for attorney.
Well, when I was visiting with you earlier, you told me that very soon after this, some alderman managers came to your house and told you all you had to go home.
Right.
You had to leave.
Right. And same night they had to leave.
So the same night that after they found the girls, they told you you had to leave.
Right. So my parents had to leave that same night, and although we had to get up, pack up everything, and take the train, go to my grandma.
So was that kind of a hurried, y'all left in a hurry?
We had to go that, we had to leave that same night.
Wouldn't let you stay at all?
No.
And your grandmother was over in Pinewood?
Pinewood.
Okay. How did your dad act about this?
Well, being a man, he didn't show an emotion like my mother did, but he kind of kept me, but it was kind of hurting.
You were afraid, weren't you?
Yeah, we didn't know what.
You were concerned for your safety?
Yes.
And you remember that night now, don't you?
Right.
Very clearly.
Right.
And so when you went to your grandmother's, all of you, how long did you stay with her?
We stayed there because we never come back down. We didn't get back to Alcolu. My father, he went to until he rented something and he tried to find a job there, and then we were able to but I never did go back. Father went and he picked up stuff from Alcolu, but I never did go back.
And you were telling me that no police officer came and looked through the house.
Oh, yeah, after they did come and look, at that time my mother had already come back, and they come looking for evidence and something, for our clothes and so forth.
So at the point, and I misunderstood you when we were talking,
right.
At the point before the police, the men from the mill came and told y'all to leave,
right.
some policemen or people had come and searched your house.
They didn't search the house, but when they come, when they arrest him, and my father wasn't there, but at my time my mother come, that's when they come looking in the closet, trying to, looking for clothes and things, but they didn't find it.
They were looking for
right.
people's clothes.
Yeah, looking for some evidence.
Right. Did they take any clothes out?
They was looking to it, but it was not that I remember they took.
Nothing that they took? Okay. Did you have a chance to talk to them, or being 12, you just got out of the way?
No, they didn't say nothing to me.
Okay. Steve? You wanna ask any questions?
You said the events that you're talking about, they're still fresh in your memory?
Yes, it is. Still fresh.
Okay. And I think that Ray asked you earlier about the clothing that you guys had, and can you tell us again about the clothing?
Well, they was looking for clothing and so forth, but trying to find some evidence, but it wasn't the clothing. It wasn't found. It wasn't no clothes on it. What my father was working and everything. It wasn't no clothes showing up.
Let me ask this question: did you have a set of clothes that you either played or worked in, and then you had a set of clothes that you went to Sunday school in or Sunday or church in?
I didn't understand clearly.
Steve, you kind of got an echo. Would you say it again? I'm going to let Matt translate.
I just said that, about the clothing issue, and did they have a set of clothes that they worked and played in, and did they have a set of clothes that they went to Sunday school in?
Yes. They have clothing for when they go to church, and then they had regular clothes that for every day.
And I think Ray was asking earlier about the seeing George that day, and that he was with his sister Amy Lou. And that I think that the bishop said that the entire time that could he see Amy Lou and George from the house?
I didn't understand.
Say that last part again, Steve.
Could he see Amy Lou and George from the house with Lizzie, the cow, that day?
When Amy Lou and George went to go let the cow graze, could you see them from the house?
You can see them from the house, but at the time we wasn't there because we went to this store.
He wasn't there, okay.
Right.
You said you could see them from the house, but he and his mother went to the store.
Okay, got it.
Steve, let me interrupt you here. When we were talking in the car, you said that there was a tower built up by the Alderman Company so that somebody could watch the lumber yard and keep people from stealing or coming and going.
Right. There was a tower that had a watchman that he could look all around the lumber yard, look in the area where we was, and he could see everything. Anything go wrong, he could be able to see.
And could you see your house and where the cow grazed from that watchtower?
He certainly could.
Ray, the one thing else I think that needs to be covered is the fact that he and his family ever have an opportunity, did anyone ever come to them and talk to them about testifying and giving them information back in 1944?
Did anybody come to talk to your family, you, Amy Lou, your mother, to figure out where George had been or not been? Were any of you ever talked to?
No.
And Ray, also, why has it taken so long for him to come forward with this information? Can you cover that with him?
Can you say?
I'm sorry, can you repeat that, Steve?
Yeah, it was so long to come through with his information, maybe ready to cover that with him.
Why is taking so long for him to come forward with this information?
The question is why didn't you come forward early with that information?
At that time, we didn't have no one that we could actually talk to about that. And when I was in the service, and by the time I left the service and come back, I didn't go back down there anyway. My parents were still there, but I just didn't go back.
Well, was there an element of fear from the time that these people came to your house and told you to get out in the night? Was there something as a young child, 12 years old and older, that you were afraid of what might happen to you?
I just didn't feel comfortable down there.
Okay.
So I just left.
Solicitor, you have any questions?
Yes, just a few. Good afternoon, Bishop.
Good afternoon.
Bishop, I'm the prosecutor now in Clarendon County, and I have a responsibility to ask you a few questions to just check what you have told your lawyers today. My understanding is that this crime happened on a Friday afternoon, and they found the bodies on Saturday morning. Do you remember whether you went to school that day, that Friday or not?
All of us went to school that Friday.
Say that again?
We went to school. We all went to school that Friday.
Do you remember what time school would have been?
I don't remember at the time what time school out, but it was a certain time. Everybody got at the same time.
All right. Now, my understanding is you did not go to school with any white students. There were just black students in the school.
Yes, only the blacks and others had the different school.
Right. Did you go to the same school? Was it a one-room schoolhouse or was it a big schoolhouse?
I didn't quite understand.
Was it a one-room schoolhouse or was it a big schoolhouse?
Well, it was it's about three. We had one was kind of separated, and with others that had two rooms.
Would you have been in the same room with George when you all went to school that year, or were you in different classrooms?
George was in another room, and I was in a different one. It's according to grade.
You said according to grade.
He was in a higher grade.
George was in a higher grade than I was.
All right. Bishop, let me ask you this. After, I understand you all had to leave, probably as soon as Saturday night, you all had to leave your house to go to your grandmother's house.
That's right. I had to leave the same night.
Do you have a recollection of your family reaching out to any community people or preachers or anything during that time to get help?
No, not at the time. We did. First, I know my family, and I don't know if anybody reach out.
Do you remember ever hearing that your family went to any community leaders in the white community to get help, to get to get an understanding or any investigation or a lawyer or anything?
No, not that I know of.
All right. Let me ask you one more question.
Is that his question?
After George was killed, was there a funeral?
Yes, it was.
Where was the funeral?
In Pinewood, South Carolina.
All right. And Did you attend the funeral?
Yes, I did.
And was he buried in Alcolu?
In Pinewood, yes, he was buried in Pinewood.
And after the funeral, did you and your family members leave South Carolina? Or did you stay in another city in South Carolina?
We stayed in another city. We moved to Sumter, and we stayed until my father passed in Sumter, and then my mother, she passed up here in New York.
How many years after the funeral was it before your father passed?
Oh, he lived quite a few years after that, because he lost.
So you all went to school in Sumter for quite a few years?
That's right.
Did you graduate high school?
No, I didn't. No, went to ninth. I only went to ninth, and then after that I went into service and met my career.
And you were quite sure that no police officers or investigators came to your house either that Friday night or that Saturday after the body to look for evidence or to ask questions of what you all had been doing for the past few days?
Nobody questioned us on anything.
All right, sir. I very much appreciate you answering my questions, and I extend my sincere condolences to you and the family.
Thank you very much.
Brett, I do have one follow-up question from Chip's questions.
He said, Ray, I have one follow-up question from Chip's question.
Sure, that's fine, Steve.
All right, if the bishop could tell us, was he around or any family member around to attend George's trial?
Were any of your family members around to attend this trial?
Well, nobody attended trial for us that I know
Does he know whether any member of the African American community was allowed to attend the trial?
of. If any, nobody attended that I know
I think that's all the questions I have.
Thank you, guys. I'm through.
Are we concluded?
We're concluded.
We are off the record at 12:40 p.m. on November 5th, 2013. This concludes today's deposition of Charles Stinney. Thank you very much.
of. Thank you, Tim.
Thank you.
Thank you.
May God bless you.
Your Honor,
You can go ahead and stop it, Gerald, thank you. Okay. Sir? All right.
If the court please, I would apologize to the court and the audience. That sounded like mission control. In the beginning of the deposition in Brooklyn, the telephone went off, and they had to put a cell phone in for these guys to hear, and that was what we now learned was the static. I apologize, that was awful.
That's fine, and there's a reverberation going around right now as we speak. So anyway, I see our technical people are working on it, so I appreciate that. Okay? Who is your next witness?
We have a deposition witness. We need about 5 minutes with the solicitor. If we have 3 pages we need to reconcile. It'll probably save us about 10 minutes of testimony.
Okay, and who is that next witness that you're going to put up?
Can we do it right now and we'll be ready to go?
You may, sir, but who is the next witness?
Dr. Stevens is the
Thank you, solicitor. I appreciate it. We'll go ahead and we'll take about 10 minutes or so. We'll come back just a couple minutes after 4 o'clock, all right, and continue. Thank you. When do you want to see the person who's phone? Tell her bring her back right now.
Yeah, we can see.
Sure, if they want to. That's fine. Yeah, that's not a problem. It's so funny. I had to look at him to finally see she was twirling.
Ding, ding.
I know. That's where it picks up.
These right here. I mean, you can hear these guys.
He was worse than were you scared?
He had a problem with dialogue, so I had to say, he had a problem with that.
Spray
He had a problem with the dialogue.
It's not what I'm saying, other than words.
That was a mess. That's the worst deposition I've ever paid for. Well, not only that, but it's called now leading witness symptoms. Man, oh man, did you get a that was
I thought you guys were doing that. That was all I kept saying. Oh, okay, I'm sorry.
Well, that's probably trivia. It's not.
I said possibility, he said accept. Okay. I was saying, as far as the probability
Now, we got, yeah, so you take, we need to pick some, 30 inches. See, I'm saying I did it all right, so as soon as these little girls is ready, you think we could possibly make it all right. Take it out of the way. Take out the I'm not there. I want to take out the You say you're going to quit. Let him answer the question.
I'll probably see you tomorrow.
Okay. Except for the fact it didn't happen. You don't know how to name it. All right. I'm asking questions to the doctor. There we go. So we leave it 14 through 20. Yeah. Take the rest of that? Yeah. Okay. All right. Continuity. 40 on 40. What I got now, 39 now. I'm trying to get some continuity. Do you accept the amendment? I'll accept it. One, two, and girls will pick the power down. They need 10. Everything after 10. And then we start again on line 14 and 50. And we finish. And do 3 down. And I have a candidate. But you're moving.
think I mean, I don't know anything about this judge. I took her kind of aggressiveness towards all the suspect issues affirmatively, positively, like she's gonna, she would. Well, I think her skepticism about the quorum nobis issue is. We looked at the quorum nobis, and I remember it being an issue of the judge that heard the trial had to still be around. And I think the professor is getting this and saying it's absurd. And it's an interesting argument. So I think it's going to I suspect it's going to turn on his purpose.
Well, I suspect it's going to turn on that. And what I'm thinking about, we filed a 29B, and that's problematic. We didn't have the PCR. What she's saying in Baptist Chambers, this is your PCR, so they report after PCR.
That's right.
It goes right back to your conclusion that PCR was what it was. And so, but it was just a court.
Thank you, y'all. Please be seated.
My understanding is that Mr. Burgess is going to read. Is that correct?
Yes, Judge.
All right. You want to come up and take the witness stand?
This time, Your Honor, defense calls Peter J. Stevens, M.D., who's having been first duly sworn and examined, will testify as follows. Good afternoon, Dr. Stevens. We appreciate your coming down from Mount Ayr to be with us here in Nashville. Would you state your full name, please, and spell?
Yes, sir. It is Peter John Stevens, Peter John Stevens.
Dr. Stevens, what is your present address?
It is 100 Club Drive, Suite 135, Burnsville, North Carolina, 28714.
You don't seem to have a normal South Carolina accent. Where do you come from originally?
Originally, until I finished high school, I was brought up and raised in the United Kingdom, mostly in and around London. At the age of 16, I moved to Montreal, Canada, and spent the next 10 years there going to college and medical school.
Hold on just a second while the judge gets the... All right, sir, would you give us your college and medical training background, and then I'll ask you a little bit about some of your experience.
Yes, in 1957, I entered the Faculty of Science at McGill, McGill University in Montreal, Canada, and graduated with a degree of Bachelor of Science in May of 1961. In the fall of 1961, I entered the medical faculty of the same university and graduated from McGill in May of 1965 with the degree of Doctor of Medicine. After that, I did a year of rotating internship in all of the clinical specialties at McGill Hospital, McGill Teaching Hospital in Montreal, after which I did 2 years of pathology residency at the Medical College of Virginia and 2 additional years of pathology residency at the University of Western Ontario in London, Canada.
After that, did you enter into the practice of pathology?
Yes, I did.
Okay, and how long have you been a practicing pathologist?
From 1970, when I passed my board certification examinations, through 1977, I practiced in Battle Creek, Michigan. From 1977 through 2001, I practiced in the state of Iowa and Davenport, Iowa, and in Cedar Rapids, Iowa. And then I tried to retire.
Yes, sir. Now, you're still working as a consulting pathologist, is that correct?
Yes, I am.
We use the term forensic pathology. How long have you been involved in the field of forensic pathology, doctor?
Well, I had been involved in the field of forensic pathology really throughout my training because the Medical College Virginia autopsy room was shared between the university and the medical examiner's office of the state of Virginia at the time. I'm sorry, the Commonwealth of Virginia at that time. And my chief in Canada was also a forensic pathologist and worked for the Ontario government. So right through my training, I received a lot of forensic pathology exposure. When I went into practice, right from day one, the practices I worked through all through my career were involved in acting as consultant to the medical examiners of various countries in and around the Midwest. In 1984, I decided that I would like to get myself board certified in forensic pathology because relatively few people have done that, and certainly none in the immediate area that I was practicing in. So I took the examination for certification in forensic pathology in 1984 and passed, and have been board certified in forensic pathology since then.
Have you participated since 1984 as a teacher or instructor in seminars or classes?
Yes, I have, both for medical technologists and law enforcement personnel, and also for attorneys.
Okay. How many times have you testified in criminal trials, approximately?
I have a very hard time estimating that, but I would say somewhere between 200 and 400.
And have you also testified for the defense in cases?
Yes, I have.
Okay. When you are called upon as a consultant, do you consult these days both for law enforcement and for the defense?
Typically these days it's virtually 100% for the defense, the reason being that law enforcement now have the county attorneys and county solicitors and DAs, whatever you'd like to call them, in various jurisdictions have their own consultants in the form of county medical examiners or the state medical examiners. So they don't need to go out of that orbit to consult with me, so that the defense attorneys, on the other hand, have nobody in that position, and so they do call me.
And you're obviously been qualified as an expert witness in forensic pathology at least 200 and possibly 400 times?
Yes, including in the state of South Carolina.
And that's probably my question. I have no other questions. Solicitor, do you have some questions for the doctor?
Please, if you don't mind. Dr. Stevens, it's nice to talk with you. Have you done any studying in the field of forensic pathology as would associate with what we consider cold cases or situations where you have not had a chance to actually examine the body?
Excuse me, it's nice to talk to you, sir. Yes, in most of the cases in which I work for the defense, for example, I have not had a chance to examine the body because the body has usually been autopsied by somebody else and has then been long dead and buried by the time the defense attorney gets around to calling me. So in that sense, virtually all of the cases I've done for the last 12 years have been cold cases with one autopsy examination accepted. Otherwise, in terms of what is a cold case, that's way old like this. I have only handled one, which was an exhumation autopsy in a body that had been underground for 35 years.
All right, sir. Now let me ask you this. The body of your experience, how much would it have involved autopsy operations?
I've done about 3,000 autopsies during my lifetime. I don't keep detailed records, but my best estimate is somewhere between 2,500 and 3,000.
And were most of those done in Canada?
No. Only the Canadian ones would be a small minimum, probably a couple of hundred. Most of them were done either in Richmond when I was training down there or in the various counties of the Midwest where I've been acted as a consultant to the medical examiners in those counties.
All right. I don't think I have any other questions about your qualifications. Thank you very much, and I have no objection.
Move he be admitted as an expert, Your Honor. Thank you, sir.
The forensic pathology, okay?
Thank you. I'm going to move right to this case, and this is the state of South Carolina versus George Stinney Jr. And as you know, it's a 1944 case. The first thing we want to talk about is the report of Dr. A.C. Bazard. And we had discussed when we were preparing for this testimony that you do not feel like this should be designated as an autopsy. Can you explain that, please?
An autopsy report typically runs several pages. You can argue about how long and how many pages it should be, but as long as the facts are there and are documented, then you know in some cases as little as 1 or 2 pages will work. In more complicated cases, such as the present one, typically they'll run 4 to 6 pages. So in that sense, the length and the detail of these so-called autopsy reports is significant. The main reason why I don't consider these to represent true autopsy reports is that there is no record in the report that was filed by Drs. Bazard and Baker to suggest that a dissection had been done of the inside of the skull or of the inside of the rest of the body. There is essentially no way in which you can tell whether anybody picked up a knife and actually made some dissections and examined the internal surfaces of the body, which form a critical part of the most modern autopsies. What this would be considered today, and we still do this kind of autopsy today in cases that don't involve assaults like this one, but what we do today is what's called an external examination, and that is basically an examination of the external surfaces of the body, looking for bruises or fractures or anything obvious or additional holes like gunshot wounds that ought not to be there. and if the body looks otherwise healthy and normal, they will be signed out by the medical examiner on the basis of the external examination and without doing a full formal autopsy looking at the inside of the body.
And can you answer me more slowly? In this situation then, we will call it, if you will, an external examination, and we will focus first on Betty June Binnicker. This examination was done by Dr. A.C. Bizard, who is a family practitioner in Manning and Clarendon County. Do you feel that there was an ambit of thoroughness about the external examination that he did?
It's very difficult for me to comment on the quality of the external examination that's done by a non-forensic pathologist or a non-general pathologist even, because some general pathologists or hospital pathologists know a fair amount of forensic pathology and do a detailed external examination. But this would appear to be the record of a typical family doctor who is unused to doing autopsies, that is unused to examining bodies after death and is untrained in trauma pathology. That said, it's not a bad examination for somebody with that kind of limited education, training, and experience.
When you do an external examination, it is critical to report, identify the bruising, abrasions, and all of the things that you see on the skin, the hair, the hands, and that's what you're really looking for. That's the total focus of this exam, is that correct?
That is correct. And also, such bruises and defects and tears would be ordinarily documented as to their length and configuration, at least in the written report, supplemented by either sketches or photographs.
And in this report, as we had discussed, it indicates that the hymen of both of these girls, Betty June included, we're talking about, was intact. Is that right?
That's correct.
Okay. Now we will get to some testimony about these in just a few minutes, but I'd like to get your opinion as to looking at this document, be it many, many years old, telling us, in your opinion, what happened to Betty June Binnicker and Mary Emma Thames that caused their death.
Well, both of these children clearly died as a result of blunt force injury to the head, which is the term that we would use nowadays and probably was used in some quarters even back in 1944. The written report of Drs. Bizard and Baker certainly documents ample reason to believe that this is what happened. There is extensive bruising around the top of the head in both. There is laceration and crushed bones are recorded. So clearly the cause of death in both cases is a blunt force injury to the head. In such situations, the differential diagnosis always involves natural death, which this obviously isn't because it's not natural death, accident, suicide, and homicide. Well, accident typically requires some demonstration of some mechanism by which the accident could have occurred, and these are unusual injuries to be sustained in an accident, so I think you could exclude accidental. You can certainly exclude suicide because it would be virtually impossible for somebody to self-inflict these injuries, so we're left with the manner of death as being clearly homicidal.
The indication that Dr. Bizard had as to the weapon that would inflict such damage, can you talk to us about your opinion of that observation and give us, in your experience, how these injuries could have been inflicted?
Well, I recognize that, as I mentioned, Dr. Bizard's limited education, training, and experience in forensic pathology. Nowadays, we would require considerably more information to be able to make a determination on what weapon might have been used to inflict these injuries. For example, we would certainly want measurements done of the defects and of the tears. We would also ideally want either good sketches or photographs, and in this day and age, virtually every autopsy of a case like this involves photographs of the fractures and the tears in the scalp, and also any bleeding or bruising surrounding those tears and fractures. So I cannot state to any reasonable degree of medical certainty what the weapon that was used was. However, Dr. Bizard expresses in the opinion that it was a, quote, small round head about the size of a hammer. Well, I'm going to assume that anybody, any adult living in South Carolina at the time would have known roughly what the size of a hammer was. And so if you felt that this was consistent with a hammer, I would say that that's about as close as you can get.
And what about the conclusion by the police that George Stinney Jr. confessed to killing these children with a railroad spike of various descriptions?
I think it would be very unusual for a railroad spike to inflict these kind of injuries. The railroad spikes that I'm familiar with usually have a rectangular cross-section throughout most of the spike, and the expanded end of the railroad spike, the head of the spike if you will, is not small, and I don't think it would be confused by Dr. Bizard or anybody else with the head of a hammer. Furthermore, it would not give you a, quote, punched out lesion, which is what he describes. It would give you much more crushing around the edge of the lesion. And I don't think it would be easily mistaken for a hammer blow. So I'm comfortable in going with Dr. Bizard's opinion that this is a hammer.
Well then, your testimony would be, am I not correct, that you would rule out a description that would include a railroad spike of any nature?
I think a railroad spike can be systematically excluded in this, yes, by virtue of the reason I've given you, and in addition to which a railroad spike could be used to inflict injury in a couple of different ways. Firstly, the smaller end, the tapered end of the railroad spike, could be held in the hand, and then the larger end brought down with violence on the side of the head or on the top of the head. This would give a totally different configuration to the fractures than a punched out fracture. The only way that a punched out fracture could be given would be to grasp the length of the spike in one hand and then bring down the pointed end of the spike, which, as I've said, doesn't fit because it's rectangular. But the only way that you could create a punched out lesion with a railroad spike is by grasping the railroad spike itself and bringing it down near vertically on the skull, and that would give a punched out lesion. But it should be rectangular rather than round. I think that's a case of something that could be demonstrated better with a railroad spike in one's hand than without.
Yes, sir. There was another description of a murder weapon as a piece of blunt iron or an iron rod. Do you find the findings of Dr. Bizard consistent with an iron rod or a piece of blunt iron?
I would have to see the piece of blunt iron and the iron rod. Some iron rods I could conceive of it happening, but again, it would have to be held clenched around the hand and then the circular end of the rod, so to speak, brought down on the head, and that doesn't strike me as being an intuitive way of inflicting damage with a rod.
All right. If you would continue then.
There is nothing in the external examination report to suggest that defensive wounds of any kind were present, although that's assuming that Dr. Bizard would have recognized a defensive type wound. But the lack of bruises elsewhere on the body suggests that these people were not defending themselves at all, and there's basically only one explanation for that, and that is that they were incapacitated in some way, shape, or form, such as by drugs or alcohol or retardation, and I don't see that that's in the material that I've been given. Absent those kind of explanations, I would expect to see some kind of defensive wounds and bruises, especially if the victims were evenly matched with the assailant. So the absence of such wounds suggests to me that the assailant was a larger assailant with overpowering size and force.
Okay, thank you, sir. So let's talk about the scene where they were found. Can you give us some observations in your mind about the lack of photography, the nature and description of the scene?
Well, firstly, the scene investigation is of paramount importance to any forensic pathologist, and that the circumstances and the location in which the body is found and in which the body has died, was killed, those two are not always the same, are critically important. Nowadays, and even back in the period of this trial, photography was used extensively. Nowadays, we routinely use color photography. In those days, black and white photography was widely used, and when done properly is just as good. The absence of photographs of the scene is concerning to me because it means that I cannot really make any comments about the scene other than what's possible. The absence of photographs of the body is even more concerning to me because there is no documentation that might give us further information on the nature of these wounds. We don't have a sketch and we don't even have a black and white photograph. And in those days, black and white cameras were pretty sophisticated.
Well, we have a description and evidence that was newly discovered from one Francis Bacon, who was about 15 years old at the time, Batson, who was about 15 years old at the time. His affidavit indicates that he was one of 4 people who found these bodies early in the morning after they went missing. He says that the bodies were found in a ditch area. They were in about 3 inches of water, laying on their backs, and a bicycle on top of them. He indicates that he did not recall a significant amount of blood anywhere around the area. I would ask you whether or not you would comment on whether you would expect this type of attack, this type of injury inflicted upon the skull and the scalp area to produce a significant amount of bleeding.
I would. Scalp lacerations are classically and characteristically very, very bloody. The soft tissues of the scalp, there's a lot of blood vessels in the scalp, which is one of the reasons, frankly, why on a cold day like today, people wear hats, because the hat keeps the heat from leaving these blood vessels through the skin and getting out into the open air, so that the scalp soft tissues are extremely vascular, as we say vascular as the technical term for it, which means there's just a lot of blood vessels, both arteries and veins, running all around the soft tissues of the scalp beneath the hair. When there is laceration, or especially if there is enough laceration to cause fragmentation of the underlying bone, these are going to bleed profusely. And so it would be inconceivable that there was no blood around if this area was the scene of death. Somewhere where these two children were killed, there was clearly blood that may have been cleaned up, or it may just not have been found and missed.
Well, what about then if the assailant was close enough to produce multiple blows on both these children's skulls? The probability that his clothing would have blood on it.
It would have been unusual, to say the least, if there had been no sign of blood anywhere on the clothing of an assailant wielding either a hammer or any other weapon, short of like an 8-foot pole, that to get up close and personal, to give this kind of an injury with blunt force, this type of blunt force injury with a defined object, would be, without getting any blood on you, would be almost inconceivable, because there is classically a lot of what is known to the blood specialist as cast-off blood that would be expected to land somewhere on his clothes.
Let's skip over to page 22, line 10. Let's talk about the testimony at trial of Dr. Baker regarding the possibility of sexual assault, and a statement given by police to the governor of South Carolina attributing in the governor's letter you have reviewed that there was sexual assault on Ms. Binnicker. Based upon Dr. Bazard's examination, do you have an opinion as to whether or not there was sexual assault or significant evidence of an attempt at sexual assault?
Yeah, I don't see any evidence of sexual assault or of attempted sexual assault. The only thing that would remotely suggest that possibility, and forensic pathologists typically need to evaluate possible suggestions and possibilities, is the report of a, quote, slight bruise, close quotes, present on the right side of the genitalia. Both hymens were intact in both children. No other bruises were present on Betty June's body, and this is far from enough. This is far from enough evidence to imply that any kind of sexual assault or attempted assault occurred, especially in a girl who we can presume did a fair amount of bicycle riding. This could have been chafing or the effects of a fall onto the saddle. There's a number of possible explanations.
The next testimony regarding the alleged confessions that would have been addressed at the trial was that Dr. Baker testified that one of the reasons he could not determine sexual assault was that the children had been submerged in water overnight. Would you comment on that testimony?
Well, yeah, this gets us into the area of post-mortem changes in bodies. And I think that we all understand that bodies undergo considerable change after death. And neither Dr. Bazard nor Dr. Baker, as far as I know, have had any specific education, training, or experience in evaluating these changes. The statement that simply because the body was in water, and I understand that the body wasn't totally immersed in water, it was basically in a shallow depth of water, I don't think would have any influence on the ability to determine whether or not there was sexual assault there.
Then the controlling issue would have been both girls' hymen intact and no significant or substantial bruising in that area?
In the absence of an internal dissection, yes, that would be the presence of intact hymens with no bruising immediately around the hymen, and would be strongly suggestive that no sexual assault had ever taken place.
Let's skip over then, am I correct, Solicitor, to page 26, line 10? That's correct. Then your opinion is also based on the fact that Dr. Bazard's medical report, his external examination, did not indicate any evidence of defensive wounds.
No, it didn't. There was no record in either body of any bruising being on any of the extremities, and typically that the arms and the legs and the hands and the feet are where you will find defensive wounds. If a victim is lying on the ground on their back, they can kick and they will kick, and the kicking may cause bruises on the legs. More commonly, everybody is standing up or in a more or less upright position, and the bruising is going to be on the arms and the hands. But the absence of any bruising elsewhere on the body suggests to me that this was a very targeted assault on the head.
The accounts of the confessions, the alleged confessions, and the account of the coroner's, at the coroner's inquest indicated that a young man, 5 feet 1, 95 pounds, dragged at least Miss Binnicker, in one account, some distance. Whether it had been 10 yards or 50 yards, we don't know. In your examination of this external evaluation by Dr. Bazard, was there any evidence that Betty June Binnicker had been dragged at all?
No, there was not.
Was there any evidence that the young Thames girl had been dragged at all?
The only thing there is that there is a reference to, quote, brush wound, close quotes, which I assume is a scrape on the forehead. That by itself is not evidence of a dragging situation. In evaluating dragging, what's important as much as anything is the examination of the surface on which they were believed to have been dragged. Were they dragged across grass? Were they dragged across concrete? Or were they dragged across just plain soil? And so I don't see any evidence to make me believe from these external examinations that there was any evidence of dragging.
The description that was given by the authorities was there were briars and bushes and brush around this ditch.
Unfortunately, another defect of the external examination is that Drs. Bazard and Baker did not discuss what kind of clothing they took off these two children, and there is no dissection or no record that briars were caught in the hair or anything like that. So that is, I think, is negative evidence of dragging or them being found.
I was about to ask you that, excuse me. I was about to ask you about the hair because it would seem in this situation that the dragging would not have been by the head or the hair, or the doctors would have seen the lack of hair or hair pulled out.
That's one part of it. The other part is the dragging of these two bodies would be most conveniently done by picking them up, by lifting them by the feet and dragging them. If you were evenly matched, you know it's equally possible that they could have been picked up by the arms and dragged some, but then there should be some scuff marks on the feet, and maybe the feet were examined and maybe they weren't. But there is no record of any scuff marks on the feet. And again, if they had been picked up by the arms and dragged by the feet, that would not explain any abrasion. It would not relate to any abrasion on the forehead, but it would be expected to leave gouge marks in the soil or the grass on which they were dragged, assuming that they were not dragged across concrete.
Yes, sir. So to conclude your testimony on our portion, you've written an opinion that excludes within a reasonable degree of medical certainty a railroad spike of any description. Is that correct?
Correct.
Okay. And you also exclude the hypothesis that these children were dragged anywhere.
Yes, I do.
And you exclude the hypothesis that either one of these girls was sexually assaulted or that there was any attempt to sexually assault them. Is that correct?
Yes, that is correct.
Thank you. I have nothing else.
Dr. Stevens, let me ask you a few questions, please, sir.
Sure, sir.
All right. What is the nature of your connection with Mr. Chandler and his law firm? Are you being paid?
No. As a matter of fact, I have offered to do this pro bono, and about 40% of my practice right now ends up being pro bono, either voluntarily or involuntarily. And this I made voluntarily pro bono. I've had previous dealings with Mr. Chandler over the last 12 years, and I can't remember which case was when, but I think he's called me on 2, maybe 3 cases max. I believe it's more likely 2, one of which was an adult and another of which was an infant, and neither of them did I do even so much as a deposition in them. I think I basically gave them a verbal report over the phone and maybe your written report. I don't have any recollection of that.
Well, let me just, as a follow-up, ask you, have you ever testified for Mr. Chandler or his law firm before in court?
No, I have not.
All right. Let me take you to the report of Dr. Bazard. And because the trial that we are talking about only has to do with Ms. Binnicker, I'm going to limit my questions to that issue.
Right.
Ms. Binnicker was the older of the 2 young ladies, and I think we can assume that she was the bigger of the 2 young ladies. Are you able to testify and give an opinion as to whether or not she was struck in the front or the back of her skull, and whether or not she was more likely facing or not facing her attacker?
That's a very good question, and I cannot. I think that to me, the lack of an attempt at self-defense indicates that she was not expecting whatever happened to her. So the attack was probably from the rear, but I can't be totally sure of that.
And if she was attacked from the rear and not expecting it, would that strengthen the reason why you did not find or read about physicals on her body?
That's correct.
It says here on the report that some of these have cracked the skull, while 2 have punched definitive holes in the skull. The back of the skull is nothing but a mass of crushed bones.
That's correct.
So that the attack was significant, and it was at least described here as at least 7 blows on the head.
That's correct. But having said that, that is Dr. Bizard's opinion, and it is very difficult at times to determine how many blows occurred. And I think that even today, a lot of pathologists tend to go a little bit overboard in evaluating their ability to tell how many blows happened. So with that proviso, that 7 blows, since we don't have any photographs available, that cannot be documented and confirmed.
All right. Because of the type of description of the skull being a mass of crushed bones, would you agree that it would not be ordinarily easy or even probable that you could determine what type of instrument caused that type of trauma?
As far as the back is concerned, yes, but some of them are reported to be punched, definite holes in the skull, and it was in his opinion that they appeared to have been made by a blunt instrument with a small, round head about the size of a hammer. That could very well, that is the best evidence we have as to the size of the weapon that inflicted these injuries. Once you get the fragmentation that's reported in the back of the skull, that makes things much more complicated because either multiple blows with that same instrument in the same area could have caused the fragmentation of the bone, or also could have fall on the back of the head. If the assault had come from the front, a fall on the back of the head would have also caused similar fragmentation if the fall was onto a hard surface such as concrete or even a railroad tie.
All right. Now let's talk about the railroad tie. If you had not seen a piece of evidence used by the solicitor in prosecuting this case, and there have been various descriptions, iron rod, iron pipe, you are not able to determine to a reasonable degree of medical certainty what instrument was used to cause the injuries to the girls.
Yes, my basis for excluding the railroad spike is firstly, I understand that there are railroad spikes of varying size and configuration, and that said, the main reason is Dr. Bizard's impression that this was a hammer.
All right, sir, but let me go back a little bit with you. Dr. Bizard saw the bodies of these little girls probably a day or so after they were discovered in the ditch.
That's correct.
And I don't know if you know this, but he was actually, it does say on his letterhead at the top of his report that his office was in Manning. But there's nothing in the report referring to his being told that a spike was found or used on these girls. Is that correct?
I don't know that for sure, but I can certainly believe it because typically even today pathologists doing autopsies on victims of all kinds are not given some of the definitive evidence that they need until they ask for it. And I don't think, and it probably wouldn't have occurred to Dr. Bizard to have asked the law enforcement personnel at the scene whether there was anything else that they found that could have possibly done it.
Page 36 at the bottom. And what I'm asking you, sir, in your medical experience, without knowing what precise instrument was used by the killer, can you say that an iron rod or an iron pipe of some configuration other than a hammer could have caused these injuries?
Yes, an object with a cylindrical or a round cross-section about the size of a hammer could have caused these injuries, certainly.
All right, sir. Let me ask you another question. You said that it's possible that the evidence showed that the girls may have been overpowered by a larger subject.
Yes, sir.
One of the possibilities, and I'm asking you, is it not also a possibility, based on the conversation I think we just had, is that these girls weren't expecting this attack, and that they therefore, that the element of surprise would have aided the person who was doing the attack. If the element of surprise aided the person who was doing the attack, then it could have been done by somebody of like size to the little girl.
I need to object to the form of the question. The standard of testimony is not possibility, it's probability.
I will accept that amendment. Doctor?
I will accept that anything is possible. But as far as probability is concerned, if you've got two people in the area and one has snuck up behind and assaulted, that will alter the behavior of the other person in the area. And
well, doctor, you're assuming that they're together. What if the two little girls were picking flowers and they had drifted apart from each other?
well, as I said, anything is possible.
Page 40, line 14. I'm asking questions to see if the doctor would agree that if the girls were snuck up on and the girls were not protecting each other at the time of the attack, whether or not there could have been injured in the manner to which Dr. Bazard expressed.
Hypothetically, if that happened, yes, anything is possible.
All right.
It would depend on how far apart they drifted, so hypothetically anything is possible given a changing set of circumstances.
Very good. I thank you for your answer, sir. Obviously, you have said that if you had had sketches, if you had had photographs, or if you had had measurements taken, it would have assisted you in analyzing the injuries that were sustained.
Yes, and it would have raised my level of certainty of my understanding of it too.
All right. The fact that those items are missing from the investigation file leads you to have less evidence or less information to work with in coming to your conclusions and opinions.
I'm sorry, sir. Could you repeat that? I think I get the drift, but I'm not quite sure.
The fact that there are no sketches, photographs, or measurements, it actually hinders you from having a clear picture of the situation involving the external examination of the girls because the details of where things were and how things looked were not given by sketches, measurements, or photographs.
That's correct, or were adequately that could be partially offset if the actual description, the written description, the text description of Dr. Bazard and Dr. Baker was more detailed.
Yes.
But it wasn't. If they had said, for example, that there was a small round hole measuring 1 inch in diameter over the right eyebrow, that would have given me a little bit more clarification.
All right, I understand. Doctor, do you know whether or not the girls were found clothed or unclothed?
No, I don't.
Do you know whether the girls were examined clothed or unclothed in the hospital examination room?
No, I don't. No, I don't.
Would you agree with me, Dr. Stevens, that a sexual assault can occur and there not be any bruising or penetration of the hymen area?
Yes, I would.
All right. And doctor, if you had photographs, sketches, or measurements, would you be able to offer an opinion as to whether the person who did this might be right-handed or left-handed, or any other specific details about the attacker might be clearer because of those types of items being provided to you?
It's possible, but it's not as easy as people think it is, and sometimes it depends on an element of luck.
All right. Doctor, I think that's all I have. Thank you.
Just one more. Do any of the questions regarding the hymen, the bruising, etc., change your opinion today based on what you have seen and the accounts of this that you have read? Change your opinion that there was an absence of sexual assault?
No, nothing.
Okay, thank you very much.
Mr. Dancer. All right, thank you. Solicitor, it's my understanding that you have a witness that you would like to call out of order because they are unavailable tomorrow, and you're certainly free to do that with the defense's consent.
I appreciate the defense allowing this. Mr. Paul Fan, please.
Come on forward, Mr. Fan, to be sworn, sir. Right here.
Stick your right hand on the Bible with your right. Left hand with your right hand. Left hand on the Bible with your right. Back up. State your name, please. You solemnly swear all affirming testimony to the court shall be the truth, the whole truth, nothing but the truth, except you know. Thank you, sir. Have a seat.
Left-handed, that's fine.
Okay, that's all right.
Please state your full name and spell your last name for the record.
My name is Paul Fan. I spell it F-A-N-N.
Mr. Fan, can I get you something to drink? Would you like some water?
No, sir. Well, a little bit wouldn't hurt. It's getting dry.
Tell us where you live, Mr. Fan.
I live in Hartsville, South Carolina.
How long have you lived there?
This is my second term around. I moved there in 1960. I moved away in 1970, and I moved back in 1983, and I guess I'm here for the long haul.
All right. Are you, by profession, what do you do?
I've been in marketing and managed marketing and sales management for a great part of my life.
And did you complete high school?
Yes, sir.
Where?
In Manning, South Carolina.
All right. And where were you born?
To be truthful with you, I was born at home 2 miles out from Alcolu.
All right. And your family was in the retail grocery business, I believe.
Yes, sir.
All right. And what was the name of the company?
P.A. Fan Groceries.
All right. And that was your dad's business?
That was my dad's business.
All right. What year were you born?
I was born in 1935, in May of 1935.
So in 1945, you would have been about 10 years old?
Yes, sir.
All right. And do you have a clear recollection of your 9th year, your 10th year of living in the Alcolu area?
I have a clear recollection of a lot of things, but for some things, let's face it, it fades.
I understand. Did you, when you were 9 or 10 years old, did you work for your father's business?
Yes, sir. During those times, people didn't have refrigerators and freezers as we have today. And we used to have a pickup truck and we delivered ice.
All right.
Throughout the community of Alcolu.
Did you deliver ice to black families as well as white families?
We delivered ice to black families as well as white families. We had no division in that respect. Right. I'm thankful my father taught me we're all created equal.
You've been in the courtroom most of the day?
I'm sorry?
You have been in the courtroom most of the day?
Since 2 o'clock.
All right. Do you recognize the ladies who testified from the Stinney families as people you may have known back then?
To be truthful with you, I could not hear her. That's why they gave me a hearing aid later. I did not catch her name.
All right. Were you familiar with the Stinney family?
Not really.
All right. You don't know
I knew where they lived.
All right. And where did they live?
Right off of Hotel Street in Alcolu, right behind at that time, the black elementary school.
All right. And
not directly behind, but within probably 100 yards or less.
All right. Now, did you know a young man by the name of George Stinney in 1944?
I did not know him personally.
All right. And of course, I think there's already been testimony that the black kids and the white kids did not go to school together.
Yes, sir. It wasn't our fault.
All right. Let me ask you this. Do you have a recollection of the events that occurred when the 2 little girls went missing and the community was out searching for them?
Yes, sir.
All right. And for example, as a 9-year-old or a 10-year-old, would you have been out on the search party?
We were all out looking. I can't remember all of the phases. As I remember it, they divided people up into groups and covered the area and scoured the area.
All right. Now, do you remember a time?
I was part of one of those groups.
All right. Do you remember a time where there was a gathering of people outside the Stinney home, and you were there witnessing what was going on at the Stinney home?
Yes, sir. Exactly what time it was, where, I can't remember all that, but I can remember there was a crowd of people all surrounding the home.
All right. And was this home in Alcolu, South Carolina?
It was in Alcolu. It was right back.
Who were you there with?
My father was there, but I was there, but it was a lot of other people there too. Probably, when you're young, a small crowd of people is like a big crowd. All right. So I would say it's probably 50 to 100 people at least.
All right. And was it daytime or nighttime when you were there?
It was in the daytime.
All right. Can you give us an idea of what you saw with your own eyes that afternoon when you were at the Stinney home?
As you know, that's been 70 years ago.
Yes, sir.
And so you remember highlights. But the highlights that I remembered is when some guy came out of the house, whether it was the front yard or the front or the back. I don't remember that, but he came out of the house and say with a big ball of clothes in his hands and said we found the clothes that he had on.
Hold on.
Okay.
Would you say that he said something?
Okay.
Would you describe?
Thank you. It's sustained, it's hearsay,
All right.
obviously.
Mine's not
Mr.
hearsay.
Fan,
Okay.
Mr. Fan, you can't say what you heard somebody else say. You can only say what you saw.
Well,
First of all, let me ask another question and we can probably handle it.
Okay.
The man that you saw come out of the house, was he black or white?
He was white.
Was he in uniform of some kind?
I don't remember.
All right. And you say in his arms there were certain items?
He had an armful of clothes.
All right. Could you tell anything particular about the clothes? Were they men's clothes, women's clothes?
Objection.
I cannot answer.
All right. And as he came out of the house, can you tell us what he did with the clothes?
He went out and put them in a car,
What kind of car?
a police car,
All right.
assumably. If I said yes or no, I'd be guessing.
All right.
I'm not going to do
Some
that.
type of car.
He put a car. He was either a policeman or he was attached to the police people.
All right. After that occurred, did you actually see anything else at the Stinney house that day?
And I can't remember either before or just after, but in that similar type, I remember that they came out with the young man.
Had you ever seen the young man before?
I was not familiar with him.
All right. And the young man you believe to be George Stinney?
Yes, sir.
What did they do with George Stinney when they brought him out?
They took him out and put him in the car.
Was it the same car that the clothes had been put in? Or a different car, if you remember?
I can't remember.
All right. After the police drove off, the cars drove off, did you stay around any, or were you?
We went home.
All right. Do you remember anything about the trial of Mr. Stinney that occurred later on?
I didn't go to the trial.
All right. Now, we've discussed that you would have been about 10 years old. You were in school?
Yes, sir.
John? For the record, we have been given a map of Alcolu, South Carolina that was dated July 31st, 1939, and it has a marking on it that says that it was revised in January of 1941, and we'd like to use this as an exhibit for some of the identification of some of the areas at Alcolu in 1944 when Mr. Fan lived there.
It's subject to our objection, Your Honor. I don't know if we've seen this.
We have seen the map, Your Honor, but we have some questions about the, exactly, and this may be able to be covered by Mr. Sand in regards to his testimony about some things that are missing on the map.
Okay.
Okay, so the subject right are,
We'll go ahead and let him, you can ask us questions and we'll go ahead and.
All right. Let's put it right over there by him. So the judge can see it.
Your Honor, may we stand and look at this?
You may.
Thank you.
What'd she say?
Mr. Fan, stand up, please, sir.
Thank you.
Mr. Fan, have you seen this map before?
Yes, sir.
And it was in my office, we talked about it?
Last Friday.
All right, sir. And does it purport to say on the map that it was actually revised in January of 1941?
Yes, sir.
All right. This is a detailed map, an overview of Alcolu, South Carolina. Does it look familiar to you, sir?
Yes, sir. Some parts were a little changed, but for all practical purposes, as you and I agreed, it was.
All right, sir. Now, I believe on this side of the map, you will see a note that says that U.S. Highway 521
Yes, sir.
is running down the left side of this map.
Right.
Where was your father's store located?
Okay. It would be located about along here because this is an extension of 521 towards Manning.
Yes, sir.
Right here is where it crosses the railroad. This is where it goes towards Trinity Church. Right across here is where George Jones grocery store was. This is the road right here that goes out into the country. It's called the Spigner Farm Road.
And is it marked Spigner Farm Road on this?
Right there.
All right, sir. Now, this area in here in the map, in the center of the map, would this be the Alderman Lumber Mill area?
Yes, sir.
All right, and there's something on the map that says it's a log pond.
That says the log pond. I can't remember though whether that was here when I was there or not.
All right.
That part, because I didn't work for the Alderman Lumber Company, I think is what it was called. I was not privileged of going back in here unless you were an employee.
All right.
So for that reason, I wouldn't.
This map says that Hotel Street.
That's Hotel Street. Right
Dead
here,
ended.
Right here's where the baseball field used to be.
All right.
Right here's where the Alcolu Baptist Church is.
All right, sir.
Right here.
And Hotel Street dead end into
into
521?
Yes, sir.
Going away from 521 on Hotel Street.
This right here is the railroad.
Yes, sir.
This is the first road that goes back, and it goes back into, I'm going to use lack of any other words, subdivision or quarters, as they used to call it.
All right, sir.
All back up in here where there's multitudes of houses.
All right, sir. And did you service those houses with ice?
We sure did.
All right.
Even all the houses along the front of here.
All right, sir.
We delivered ice to a lot of people.
All right, sir.
Might even some of the people may be still here right here today.
All right.
I was little, but I could pick up a 50-pound block of ice and walk with it.
All right, very good. Did
I've
you
got weaker
happen?
in the years.
Did you happen to know the Binnicker family or the Thames family?
The Thames family right here lived right here.
And can you tell the judge what number is on that house?
I can't read it. 30. Is that 35?
35.
Right in the corner.
That would be the Thames house or the Binnicker
That
house?
would be the Thames house.
The Thames house. And where was the
Binnicker
Binnicker?
family? I'm forgetting. They live next door or right across the street from.
All right.
Could I ask one of the people that?
No, you'd have to just,
Well, he was either right here or right next door.
all right.
I'm sorry, I can't remember.
That's fine. Now, can you tell us the area of town that Green Hill Baptist Church?
Yes, sir. There's two ways of getting there from here. Where is the Green Hill Church?
It does not appear on this map.
It's over further. It's over further.
You'd have to say if you can recognize it from the
You
area.
recognize it because the road comes up here and comes out this way and comes around.
The road that you're talking about, is it a dirt road?
It's a dirt road.
All right. To your knowledge, did it have a name on it?
Wait, hold on just a moment. I'm going up too far away.
It may be easier, Mr. Finney, if you allow Mr. Fan to give him a little space and walk around so he can really get up next to it and look at it.
I'm sorry. You come around this way.
There you go.
I'm old, but I'm still walking.
This is Hotel Street
That's Hotel
and
Street.
521 here.
Just a moment. What did that say? Green here, is it chemical or something? What's it?
That's a chemical house of some kind.
Okay. The road where the Green Hill Church was, the Green Hill Church would be up in this area.
That would be on the right side, the far right side of that map?
Right.
All right, sir.
All right. This road comes on out, and the Robinson farm was over on this side.
All right, sir.
Mrs. Robinson's, the lady, she was here.
Mr. Fan, hold that position right there. Let me show you another map. This is a Clarendon County highway map. It does not have a date on it.
Look at it.
I think I was provided it by the defense. That's Hotel Street right there. Yes, sir. Yes, sir. I was wondering if you saw a dirt road indicated on this map that would lead to the church.
I'm trying to find it.
It says,
We don't know.
It says Green Hill Church. That's what I thought. That's the Green Hill Church road. Here's the road right here. There's the Green Hill Church. Right here. That's watch stay still.
All right.
Don't be nervous.
Want me to hold it?
This right here.
Yes, sir.
Right here off to the left is where the incident.
all right, let me do this. Have you been able to pick the Green Hill Church
Yes, sir.
on this map?
Yes, sir.
And on the smaller map, would you be able to say that it is where you indicated on the bigger map, on the right side of the bigger map?
I object.
Approximately.
I object to that.
Basis,
Hold on.
I object to that.
basis.
And there's a different scale on those two maps.
I understand that. What we're going to do is mark this second map for identification purposes, and I think, is the first map been identified as well? That one needs to be marked for ID purposes. It's not necessarily in evidence, nor is this one, but just for me to be able to locate what Mr. Fan is going to testify to. Thank you. Thank you, Ms. Rice.
We're going to estimate.
You can't talk.
I haven't marked them because there's no docket number,
Okay.
so I just have the number.
We're going to have to just do it, A and B with a number is how we're going to have to do it, okay? Yes. Do you have a way to?
We have an Elmo.
Very good. That was my next question.
If you could sit down, sir. I'm going to ask you some questions on that screen right there.
You got enough information on that?
Just hold that right there.
Hold that.
Yeah. We're going to put a map up here. We need you to look at it and point
Oh, that's good.
point out.
Okay.
Document. Okay. Yes.
Okay, can I turn it?
Turn it the other way, please, so 521 is down and to the...
Thank you.
There, on the other side.
Mr. Fan,
I've lost it.
all right, I'm going to use the pointer, Mr. Fan, and see if I can orient it. If you can see right here, this
Where did I point it?
is 521. Do you see the pointer? This is 521.
Okay.
This is the
Right.
railroad track.
Yep.
This is Hotel Street running into 521 right here. If you were to leave 521 on Hotel Street and going back into that subdivision area,
Where's the black school on the right? How far down is that? Can you
it says
tell?
right there where the pointer is school.
No, that's not the black school was on the right on Hotel Street.
Can I?
Go down past,
Actually, Ms. Chandler, you should be able to see wherever he's pointing to should come up on your screen, just like it does mine.
Where I'm pointing comes up on your screen? No.
Let's zoom in on this area. We need this area right here zoomed in.
How about that?
Mr. Fan, this is the
Okay, here we
railroad
go.
track.
Okay, I got it.
All right.
Okay.
Mr. Fan, I tell you what, it's only going to work, he's got to
If you
go.
would like to step him around so you can actually point instead of you orienting him and guessing. Mr. Fan, if you'll just step around and off the main screen.
Come with me, Mr. Fan.
If you would point to, you should be able to look off the screen in front of you to be able to point.
Okay.
Mr. Fan,
Yes, sir.
you're going to have to point right here, but it shows up on the map
All
when you
right.
point.
Okay. I'm getting there. Okay. This is the,
Look at the map so you can see it better, I think.
I got it right here.
All right, good.
Right here is Green Hill Church.
All right, and
This road of question that we're talking about, the dirt road, you go right through here because when I used to deliver papers, that was the way I went through to get over to Hotel Street.
all right,
So when just before you get to Green Hill Church, there was a ditch that went to my left looking at the, right down there.
all right, sir.
And that was a point of interest of where the incident happened.
All right, and how do you know that that's the point of entrance as far as
Because I
the ditch?
remember it.
All right.
But they wouldn't let people, us, especially us young fellows, they wouldn't let us down there. So we stood on this dirt road and looked over the fence. And why do I remember it so deeply? I can still roll up my arm sleeves because when I was riding through there one day, I fell in the sandbog and fell on a barbed wire fence and stuck a hole in my arm, and it's still there.
All right. What did you observe in that field across from Green Hill Church?
Crowds of people, and they were getting the bodies out of
The bodies of who?
of two girls.
All right. And
Out of the ditch.
Are those the same two girls that we're here talking about today that were connected to the boy, George Stinney?
Yes, sir.
All right. And which came first? Did you see them taking the bodies out of the field first, or were you at George Stinney's house first?
We were here. We were taking the bodies out of the fields.
You weren't doing it.
No, sir.
Who was doing it?
Men.
Men?
Can't answer.
Okay. Do you know what the bodies were on?
I can't remember. I remember they took them out on cots, but other than that, I can't. I remember seeing the cots. We were not even close to the situation.
All right.
They wouldn't let us get close.
Can you tell the judge how much time went by from the time you saw the cots being carried out of the field to the time you saw the cars at George Stinney's house?
No, sir. There's 70 years past since then.
Okay, very good. Can you tell me this? From where you have the Green Hill Church, where did George Stinney live?
If you follow this road on through, you don't go all the way. This road right here came into the edge of the quarters, quote
Yes, sir.
unquote, and he lived right off to the left, just left of that road.
All right. Before you got to the paved road, Hotel
Oh,
Street?
yes.
To
At
the
least-
left?
At least a couple of 100 yards.
To the
100
left.
to the left.
All right. How far would it have been for George Stinney from where his house was to walk to Green Hill Church?
I live in the town, so I'll say half a block.
Half a block. And how far was it from Green Hill Church to the field where you saw the bodies being carried out?
Probably a full block.
A full block. Very good.
Okay.
Mr. Fan?
It was before you get to this. What was happening there was just on this side of the church, and where he lived was down this road right here, and then off to the left right there in that little community.
All right. For the judge's information, does Green Hill Church still exist? Is it still there?
I haven't been there in years, so I can't answer, but
All
I
right.
think it is.
All right. To your recollection, did Green Hill Church face the dirt road that you're talking about, that you were
Yes, sir,
traveling?
it was up on a hill.
The church was up on a hill.
Uh-huh.
But did the church face the road?
It faced that curve right there.
All right. It faced the curve.
Uh-huh.
All right, very good.
When you were coming from the community this way, you were looking at the church.
All right, up on
As
the
I
hill.
remember it. It's probably been 30 or 40 years since I've been through there.
All right.
So you can ask a question that I had to dig deep on.
Very good. I'm going to ask you to go back to the seat. You may have to answer some questions from these other lawyers.
All right.
Thank you, sir.
Thank you.
Just a moment, Your Honor. Good afternoon, sir.
Good afternoon to you.
Where is Archdale? Where is it that you live exactly in the state?
In Hartsville.
You live in, I'm sorry.
Hartsville.
In Darlington County, where I'm from.
That's right. What part of Darlington County you live?
You live outside of Hartsville or inside?
I live behind the 13th green at the Hartsville Country Club.
Good for you.
I don't know. I don't get to play much anymore. My wife died 4.5 years ago, and I gave up the ghost. I play about 3 times a year. I used to play 3 or 4 times a week.
I wish I had her.
She was a club champion 3 times.
Was she?
Not me, she.
Was she? I'm going to ask you some questions.
Okay.
You delivered ice when you were 9 years old?
Yes, sir. No, I didn't deliver the ice. I helped get it off the truck where we had to pick it, cut it in. You buy ice from the Manning ice plant. It came in 300-pound brackets, 3 100-pound pieces put together, frozen. And after we put it on the back of the truck, somebody decided, do you want 100 pounds or 50 pounds or 25 pounds? And you had ice picks and you cut it that size and you grab it with the tongs and away we go. But you learn to know who buys 25 pounds and who buys 50 pounds and who will take 100. Very few people could afford 100 pounds back then.
Yes, sir. I'm not going to ask you what time it is. Would you help me with a question, just an answer just as briefly as you can?
Yes, sir.
And if you need to explain, I'll be delighted to give you time to explain.
Thank you, sir.
Right? You were about 9 years old in 1944.
Well, I was born in 1935 in May, and this happened in 44.
Yes, sir.
I'd be 9 years old.
Yes, sir. And you helped your daddy.
Yes, sir. I worked for my dad,
Yeah.
but I didn't drive the truck.
Yes, sir. And so where you went with your daddy.
No, sir. He stayed at home. He ran the grocery store, but he had people that worked for him.
Okay. And so how far away did you live from the Green Hill Baptist Church?
Less than a mile. I don't think it's a mile.
How'd you get there?
How did I get there? On my bicycle.
Okay. You rode your bicycle?
Yes, sir.
Okay. Now you say that around the Stinney house that day when you were there were almost 100 people?
Hey, back then 10 people looked like 50, you know. I don't know. All I knew there was a crowd of people.
Big crowd of people.
In my mind, in my eyes.
White people.
I can't remember that part. I didn't count to see how many whites and how many blacks.
You remember blacks?
I'm sure there was some there.
You sure? Do you remember?
In my mind. I'm thankful my father did not divide. He taught everybody alike and taught us to do the same thing.
So 70 years ago, if I lived at a certain place and went to church every Sunday and I walked, would you not think that I would be a good judge of how far I've lived from that church?
That was not the church I went to.
Sir?
That's not the church that I went to.
No, sir. I'm talking about if the Stinney children walked from their house every Sunday to the church, the Green Hill Church, and they walked back, they would probably give you a good estimate of how far it was from one place to the other. Don't you think?
Back in those days, I'd say no.
But better than your 70-some year past memory.
Today, I could still remember, yes, because but I didn't go to church there. But I knew where it was. I passed by where it was a many a time.
Yes, sir. Yes, sir. And you told us everything you can remember?
Yes, sir.
I don't have any more questions.
Okay.
Anything
Thank
further?
you, sir.
Solicitor?
I would ask that the witness be excused. He's got business appointments tomorrow.
Any objection from the defense?
No objection, Your Honor.
Mr.
Thank you,
Fan,
sir.
you are excused. Thank you, sir.
Thank you so much. Have a good day.
Can I see the attorneys for a moment? Ladies and gentlemen, I think we're going to go ahead and conclude for the evening. We are going to begin at 10 a.m. tomorrow morning with further testimony. I expect the attorneys here at about 9:15 or 9 o'clock to identify some exhibits and put some agreements on the record. Ladies and gentlemen, I appreciate it. I want to thank you all. Good night. And we look forward to starting promptly tomorrow morning at 10 a.m.
Thank you.
Yeah, sure. Right here.
Forgive me for continuing to stay.
all rise, please.
Thank you, all. Please be seated and good morning. Good morning. All right. Good morning, Joe. How are you? All right. Mr. Chandler, are you ready to go? Let's go.
The PowerPoint has not been copied.
Okay. Okay, thank you.
Your Honor, for the record, Mr. Chandler is in the courtroom. It was my understanding that the court having to meet here on a Clarendon case, I wasn't sure where the original file was going to be. Our office filed a response to the defendant's motion for a new trial. We submitted it electronically to your office and to Mr. Chandler's office, but the original has now been clocked in Clarendon County and brought to me to be joined with the original file. And I wanted you to have a certified copy as well as Mr. Chandler.
All right. Thank you, Mr. Finney, and I do have a copy of it. I did receive it.
That's the judge's certified.
Thank you.
Your Honor, also,
yes, sir.
We have a witness scheduled for testimony later in the day, and we have two color photographs of Ms. Binnicker that have been marked as State's Exhibits 3 and 4. We just wanted you to know that they've been shown to the defense.
Okay, and there's no objection? Is that correct, Mr. Chandler?
Yes.
Very good.
Photographs.
Thank you.
Yes, Judge. No objection.
Okay.
We also, Your Honor, would intend to move into evidence the map, State's Exhibit number 2, which is what we call the small map, that was used yesterday to identify the Green Hill Church. The larger map, which is State's Exhibit number 1, we would like to give back to the owner, who's going to testify shortly this morning. And
can you take it to a print shop and get a print done?
We can do that.
All right.
And it's already been marked, so we'll mark it with the sticker on and give the original back to the owner.
Thank you. Yes,
Thank
sir.
you.
We can switch it out as long as it's an exact copy.
Thank you.
Thank you. And then as soon as Tina prints the case law, I need that too. They are entered in evidence, yes, ma'am. And Joe, have you figured out how you're numbering these? Okay.
Special term 1944.
Okay. Okay. That's fine. That's fine.
Your Honor,
Yes, sir.
we would ask that this witness be allowed to testify from here so that it will broadcast throughout. She can't testify from over there with the PowerPoint, and it broadcasts otherwise.
Okay, it's my understanding that the PowerPoint she intends on using doesn't have any pictures or diagrams that she necessarily needs to point to. Is there any reason why that PowerPoint can't be put out, obviously, on the screens? But it would seem to me that she would have a problem testifying from the witness stand. She can have a copy of it herself in front of her, and there should be a screen that there is on the witness stand, so that shouldn't be a problem. She shouldn't need to stand there.
So you don't want this put out on the screen?
I said
can't
it was
do from
fine.
there.
She could put it on the screen. I have no problem with that. That just requires someone to be able to use it as a PowerPoint through their computer. You may want to talk to your IT people, but they can go through it as a PowerPoint. It doesn't need to be placed on the Elmo.
I think she's going to need to put a computer to the witness chair. And is she able to do that? Because we were struggling with
Burgess,
that
come
for
help
an hour.
him.
We were struggling with that from 9 to 10, but they said that couldn't happen. But if this can, we can do it perfectly.
What you said is correct.
There shouldn't be any reason why it can't, from a computer, go to on PowerPoint and
Right,
screen.
somebody would just have to physically go to the next one from
Exactly.
there, and then she can testify from the stand.
Which I hope they know how to do.
Will it go on the screen
It
from
will go on
there?
the screen,
There's a
someone
screen
can
up there.
physically stand here and click the sides.
I'm pulling the PowerPoint, Your Honor, I want to get this testimony. I don't know how it works with her testimony.
Mr. Chandler, you're making it more difficult than it really is. Mr. Burgess, I assure you, can come up and just forward each screen.
That's fine, thank
It's
you.
one of the nice things we have with technology. The problem is sometimes we don't know how to use it. But I will say that this new courthouse is absolutely gorgeous. I haven't been in Sumter since I first came on the bench 8 years ago, and this new courthouse really is wonderful and certainly state-of-the-art. We may just need to educate our lawyers on how to use it. So, and I will say sometimes our younger people have the benefit of having grown up with all this technology that maybe some of us haven't. So I am confident that Mr. Burgess can take care of this and help us along. And I'm also certain that this doctor can also tell you when to forward the screen in her testimony. Okay?
We went to make
It's
copies,
fine.
we went to make copies for you, Judge, and the copy machine broke. They're going to have to go take it and go somewhere else with it.
Please stand. State your name, please.
Amanda Salas, MD, SALAS.
Do you solemnly swear or affirm the testimony you give this court to be the truth, whole truth, and nothing but the truth, so help you God?
I so affirm.
Thank you. Have a seat,
May
please.
we move on and qualify her while they're waiting for that?
Yes.
Just state your name and spell your last for the record.
Dr. Amanda Salas, AMANDA, last name Salas, SALAS.
Dr. Salas, good morning.
Good morning.
Dr. Salas, you were contacted by my firm and asked to testify here today in the Stinney case. Before we begin, I would like for you to give us your educational background and qualifications to determine if the court will allow you to testify in this area.
I'm a medical doctor. I attended school at USC in Columbia, South Carolina. I graduated in 2003. I went on to complete a psychiatry residency, which I entered at the Medical College of Georgia in 2003. I moved on into a child and adolescent psychiatry fellowship program in 2006, which was completed in 2008. I worked for 1 year, and then I went back into fellowship training from 2009 until 2010 at the University of South Carolina in Columbia, and I completed a fellowship in forensic psychiatry. In all those years, I have become board certified as a general adult psychiatrist, a child and adolescent psychiatrist, and a forensic psychiatrist.
Have you testified in General Sessions Court and been qualified as a witness in doing so?
Yes, I have.
Approximately how many times?
In General Sessions Court, I've provided testimony, I would estimate maybe around 15 times.
And in other courts in this state, how many times have you been qualified to testify as an expert?
I've been qualified to testify as an expert in probate court. I've lost track of it. I would estimate somewhere between 100 and 200 times.
In the nature of your testimony, has it been the General Sessions type of testimony? Has that been for the state, most of it?
I have provided testimony when I worked with the Department of Mental Health while I was in my fellowship training. I've also provided testimony where I've been retained by the defense.
What is the area of your testimony been in?
I've provided expert testimony pertaining to competency to stand trial issues, competency to be executed issues, as well as testimony related to the reliability of confessions or statements given in the context of sexual abuse cases.
We would offer her as an expert.
All right. Mr. Finney?
May it please the court, may I examine?
Yes, sir.
Dr. Salas, good morning.
Good morning.
As part of your training, Dr. Salas, did you take special courses in child psychology and the workings of the child's mind?
The setup of doing child psychiatry, which is what I am board certified in, It's not only related to taking classes and doing studies that are part of your course instruction, but we also had direct clinical experience that was the bulk of where our training lied in terms of taking book knowledge and how it applies to the clinical scenarios.
And were you working with children, live children, at this time with the clinical studies?
With clinical studies, yes, the children that we treated were alive, yes.
And were these children from various backgrounds? Some were charged with crime, some were victims of crime, some different backgrounds?
Which training are you referring to? All of
Any
it?
training that
Yes.
you may have had?
Yes.
Okay. In the example you talked about a minute ago, I believe you said as part of your training and studies, you've testified and analyzed children's statements.
Yes, sir, that's correct.
Have you ever testified in a case where you didn't have the child that was the subject of the examination available to talk to?
Yes, I have. Oftentimes, when you are retained for the defense and the defense is representing the accused, you do not have access to the victim who would not be able to participate in an interview with me.
And your qualifications to testify and offer expert testimony for the defense would be for a defendant who you have spoken with, as opposed to the child who might have been the victim that you didn't speak to.
Oftentimes, the review of the statements that are given does not require an interview of the accused, and so that doesn't come into play.
Have you ever testified in a case like this where you are testifying on behalf of the defense in support of George Stinney and you didn't have an opportunity to speak to George Stinney or read a statement that George Stinney wrote?
I would like to clarify that I'm not testifying on behalf of George Stinney. I'm testifying to the material that I have reviewed. I have been retained by the defense. This is the first time that I've had a cold case where I don't have access to people who are still alive, but it is not the first time where I've had to rely on information that pertains to a statement that was given without the ability to interview the person who gave the statement.
All right, thank you. May I have one moment?
May.
Thank the court for allowing the time. We do not object to this witness testifying as an expert.
Okay, thank you.
My conundrum continues, Your Honor. We're now trying to go elsewhere to get the copies of the PowerPoint. How many copies do we need at this point?
I think we're fine. What's on the screen currently is the documents that Dr. Salas reviewed in an effort to reach her conclusion. So I don't think there's a problem with the first one. So let's go ahead and go forward and ask her.
Dr. Salas, before being retained by our firm discussing this case, did you have experience with the George Stinney case?
I did, yes, sir.
Would you tell us what that is?
When I was in my residency program fellowship for forensic psychiatry, part of the training requirements are that you complete a grand rounds presentation on an area of study that you have conducted. And the area of study that I conducted pertained to the changing legal standards of the protections that were offered to children over the last century. And specifically, I had studied the George Stinney case and compared it to Robert Conyers, who is also from Clarendon County, and the differences in the protections that the legal field may have had to offer at one point in time compared to another point in time. At the time, in 2010, when I made this presentation, one of the topics of discussion was the move to have adolescents who have committed a capital crime where they could not get a sentence of death, and life without parole was the legal standard that evolved at that time.
So you have a familiarity with the facts and circumstances surrounding this case?
Yes.
Okay. We're talking now about your professional investigation of this case. Would you advise the court what you have done in order to further your knowledge of this case, in order to render an opinion as to the reliability of a confession allegedly made by George Stinney Jr.?
The sources of information that I have relied on are the lists that appear on the screen before you, so I will go through it. It actually is way more extensive than the sources of information that I had when I did my presentation. And I find that these are more direct sources of information. But I did conduct a review of the records that were made available to me to include the affidavits and the statements as listed for Wilford Johnny Hunter, Amy Ruffner, Catherine Robinson, Bishop Charles Stinney, Reverend Francis Batson. I also reviewed the medical report that was signed by Dr. A.C. Bazard and the letter that Governor Johnston had responded to Mr. Ford and the comments that Mr. Ford sent in response to Governor Johnston's letter. I also had ability to review the notes that were handwritten by the Detective Newman, the notes that were handwritten by the prosecutor, Mr. McLeod. I had opportunity to see the visual pictures of George Stinney and review a picture of Betty June Binnicker with her bicycle. I also had opportunity to review the legal motions that had the stipulation of facts included in them. I had opportunity to provide and conduct interviews with Johnny Hunter, who was made available to me via telephone interview, as well as an interview of Amy Ruffner and Catherine Robinson, sisters of George Stinney.
Thank you. Based upon those interviews and the review of the documents that you have outlined here, do you feel that you can form an opinion as to the reliability of the confession in this case?
My opinion is based on my cognitive beliefs. It's not an opinion based on a feeling, but after going through the methodology that would be standard in the field for conducting an assessment of reliability, I do have an opinion that is a professional opinion related to the reliability of this case.
Why would an otherwise innocent person, in your professional opinion, your research background and training, admit to something that they didn't do?
It's very common that people will give statements for a variety of reasons and confess and give an I did it and hear the narratives as pertaining to that, and yet they are not the person who perpetrated the event related to the statement that they have given. There are a lot of psychological factors that may come into play. Those have been documented in the records and in the literature since as the 1860s was as far back as I could find a reference for, that psychological factors did come into play and should be evaluated when someone does an assessment of the reliability or the validity of a statement that has been given. I can't say what motivates one person over another with 100% accuracy, but certainly what we do is look at the psychological factors, which is where my limit of expertise lies in giving an opinion as to whether something is more or less likely to result in a false confession.
And in this case, what would those factors be?
If you would advance to slide number 6, please. The one that, slide number 5, I'm sorry. The one that is titled, How Reliable is the Confession? And may I get a cup of water, please?
Yes.
Thank you.
I got it, Mr. Chairman.
I believe you had asked me about how do I conduct the methodology for evaluating the reliability of a confession or the reliability of a statement. Is that correct? Okay. On the screen you can see 4 components that one would look towards in looking at how reliable is a confession. The first 2 are usually more objective in being able to have something that's defined in black and white, which is, does the confession fit the evidence that is available? Does the confession have internal consistency? The psychological factors that are very prominent come into these last 2, which is what was the characterization of the interrogator-suspect interaction, and what is the psychological makeup of the confessor?
Why would someone then, would you go through each of those areas and discuss how they relate in your mind to this case?
Absolutely. Advance to slide next, please. The breakdown of the 4 questions is as follows. First, we're looking at whether or not the confession fits the evidence that is available. When I went through the materials that I had available to review, which I must say is limited in terms of not having the same volume and breadth of material that perhaps might be available with a case that is currently available and not a cold case. What I reviewed indicated that there was a size and power mismatch between the accused and the victims. Even if you don't account for the physical size, you have one person against 2 people, and that's a mismatch in terms of how do you account for one being able to overcome 2. I had to acknowledge that that was a factor that came into my mind when I reviewed the documentation of facts. I also had the ability to, as I said, conduct interviews, and I found that both Amy and Catherine, George's sisters, serve as alibis for where he would have been in the time that this was alleged to have happened. I understand that there's a broad time frame, but Amy was able to indicate and state exactly what was going on when she and George walked the cow Lizzie, when they returned to the home, and Catherine was able to verify that they were all in the home and in proximity with what their normal daily activities were after school while for the remainder of the afternoon.
Did you interview them separately?
I did interview them separately. When I conducted the interviews, it was limited to me and the person who I was interviewing, and nobody else was available in the room.
Continue, please.
Additional evidence that I found in the record was that there were several descriptions of what the alleged weapon was. I'm still not exactly clear what the weapon is, but it has been described as a variety of being a spike or an iron instrument of some sort. And there was a misfit or a disconnect between the description that we had in the record and what evolved or came forth in the medical examiner's report. And so that was part of the consideration as well. The other things that I made note of was the lack of material that was available, and there was no additional physical evidence that I obtained in the interviews of the sisters specifically, in which George, upon return from having walked Lizzie that afternoon, he did not have markings that were alarming to them. They did not see his appearance as any different than what he would have looked like other than any other day of the week when he would take Lizzie out to graze. He didn't have any physical symptoms of having been involved in a conflict or anything. The other thing that I made note of is the fact that the identification of the murder weapon is something that is fluid, it's shifting, it's changing. I don't know what the murder weapon is. I don't know where the murder weapon is. It's not been documented as having been identified and agreed upon with consistency. That is something that in the available records, specifically from the Detective Newman's notes, from the solicitor, I believe his name was Mr. McLeod, his notes, and another, perhaps indictment, described it in different context.
Well, specifically, can you address initially from the investigator's notes what it was described as versus what was in the trial record?
Let me reference. I'm trying to read this handwriting from Mr. Newman's notes. A piece of iron about 15 inches long.
And in the solicitor's record?
I have spike written down twice.
And you indicated you reviewed Dr. Bozard's medical
Yes, but
information.
if I could, I would also like to note that it's in the record that Detective Newman does not reference a spike in his notes, and the solicitor, Mr. McLeod, does not reference a piece of iron about 15 inches long.
Continue then on your outlook, your opinion on the lack of reliability from the scientific background that you've studied.
In addition to looking for witnesses that could serve as alibis and finding that information, which just kind of came to me, if we could go back, sorry. Thank you. I did not find any statements from other witnesses who could identify and say, I saw George Stinney in proximity with these girls outside of the statement that Amy had made, that they had this interaction. So there's not another party that has come forth that has said, I saw him with the two victims in this context. So the context that puts George Stinney in proximity to the two victims is information that Amy is able to verify at this point in time. And there is a lack of witnesses that have put him in proximity with them. In regards to the medical record from Dr. Bozard, the letter from Governor Johnston indicates that he had a personal conversation with Detective Newman, and that Detective Newman had identified the motivation as a sexually motivated crime. However, when you review the records from Dr. Bozard, as well as for both of what would constitute the autopsy reports, there was not a documented medical history that suggested that this was something that had a penetrating sex motivation and that the hymens were still intact. There was some bruising that was noted on Betty June Binnicker's genitalia, but there was an alternate explanation that was very reasonable and likely to explain that, which is her riding the bicycle. So the other thing I look towards, because sometimes you won't find a physical exam finding when you have a sexual abuse crime, I had to put into context more information and go see if I could find out what George Stinney's interest may have been to identify him at a stage of sexual development and interest. And the interviews that I conducted with his sisters are that he actually had no expressed interest in following a female population. He didn't have interest in terms of going and looking for girlfriends or even expressing an interest in the opposite sex. In fact, the interests that he had were probably, one would describe them as less mature than that of would be expected of a 14-year-old who you would expect to have raging testosterone through their body. His were more into playing marbles, reading books, making whistles. He enjoyed art, and those were the things that he enjoyed. He would draw planes that would fly overhead, which was not congruent with what one would expect to find in somebody who has a vested sexualized interest in the opposite gender to be sexually motivated.
So tell me then what your findings were and your basis professionally for determining how someone of his age would give a confession to something that he didn't do.
So you want me to move from this to how would George give a confession for something that he wouldn't do?
Unless you're not through with what you're...
I'm not through.
Okay. Then roll on,
I
please.
apologize. Hence the slides, because as you can tell, this is rather detailed and lengthy. After you move past trying to resolve the question of does the confession fit the evidence that is made available, if we could advance to the next slide, what we're looking for is whether or not the confession is internally consistent. Internal consistency refers to whether or not a person is giving the same statement over and over again. So if I have ridden my bicycle down to the store to buy milk and eggs for my mother, and that's what I tell you, and I told you I rode my pink bike with a bell on it, and then the next day I come and I say, well, I took my sister's bike, I went to a different store for a different purpose. The story, even though it originates for me, is not the same, and thus it is not internally consistent because the facts that I have provided are very different. And so that's what I'm referring to when I look for internal consistency. One of the concerns that I have is that the murder weapon, as described by Detective Newman's notes and Solicitor McLeod, and the indictment is fluid over time, and I'm not even certain exactly how it would have been described in the interrogation period of giving and eliciting the confession, because that unfortunately is not transcribed or recorded in any way for me to be able to review. But what I do see is that it has shifted in the reports that surround the confession. I would have expected that at the time Detective Newman had made his notes, I understand that he was there at the scene where the bodies were found. Maybe there would be a discrepancy at that time, but from the time he got a confession and a report as to where he could go find a weapon, I would expect consistency from that point forward in the description.
So once you had the weapon, that would be over.
Once you had the weapon or you had a description and a confession that you found to be reliable, you would expect it to be described reliably over the course of time. So when I look to the issue of internal consistency, these descriptions are concerning and quite frankly alarming. The other thing you look towards in confessions is when they confess in a custodial setting, do they maintain the same statements outside of that custodial confession? Through the interviews I conducted, specifically with, we can advance to the next slide, specifically with Johnny Hunter, who was 17 years old and the cellmate of George Stinney when George was detained in the Sumter jail. Johnny described to me that George consistently interrupted him and asked questions pertaining to, I want to reference my notes so I don't change what he told me. Johnny described that when they would be doing whatever, whether it was looking at comic books or eating candy or just sitting, sometimes they would be laughing. Outside of that context, George would just shift in his demeanor, change his expression. He would say, Johnny, why would they want to electrocute me on something I didn't do? And this was a thought that George had constantly on his mind. And Johnny acknowledged that he had no explanation for it, and it would just be a moment where they would sit and pause because George was very much aware of the gravity of the situation. I specifically asked Johnny whether or not he believed George to understand the meaning of execution, because I felt that in analyzing the word electrocution, it was important to know that the words that George were using were things that he truly had an understanding of. And I wouldn't have expected him to have known that word outside the context of the circumstances in which he was in. And Johnny made it very clear that George was certainly aware that execution meant the death that was given to him for the conviction of the charge that was brought against him, and that he knew he was going to die via electrocution, or at least through execution, and that this was so distressing for George that even in the context of having a moment where they were having a positive interaction, George would shift in his affect and change his thoughts. The other place where I found that George had denied having anything to do with this was a statement in the interview with Amy in which she acknowledged the family having received information, a written letter from George that no longer exists, and he denied it there as well.
Can we move past that?
And the solicitor stood up, obviously, that is,
That is what we talked about
okay.
outside of the
Okay.
record. Your
And
Honor.
again, she didn't testify to that yesterday, so.
We're going to, with your permission, could we move past that? Judge? Is that-
Absolutely.
Thank you. All right.
I apologize. My computer is in, I don't know what it's doing, but it's coming back where it needs to be. So that resolves the information I have in terms of looking for internal consistency. And this brings us to the third question, which is what is the characterization of the interrogator-suspect interaction, which really means what are the psychological factors and how do they apply in the context of how an interrogation is conducted. We look to two issues pertaining to suggestibility and compliance, and that's what the two arrows represent. To the left on a low scale, to the right on a high scale. And this is perceived as a continuum. This is not black and white, which is probably most of y'all in this court are familiar with. We live in a gray world when we practice mental health and psychiatry, and so we speak in terms of continuums. Perhaps that makes our practice of medicine a little bit more difficult, but this is going to be discussed in terms of a continuum from low to high. And the factors that we're going to look at are suggestibility and compliance. When you move up into the high areas of high suggestibility and high compliance as seen on the next slide, this is where you have an increased likelihood of dealing with a false confession. So if you have low suggestibility or low compliance, then you are dealing with something that's more likely to be reliable. So looking at suggestibility, next slide. By age alone, 14 years of age, outside having an adult available to him in the context of how an interview would have been conducted or an interrogation would have been conducted, by age alone you would note that George would be more suggestible, especially when you pair that with adult males that are 2 to 1 present in the context of the interrogation. And so just accepting the fact that our brains are not developed at 14, which is supported by the literature because myelination is continuing until you're in your mid-20s, that is going to influence him to become more suggestible than if you had somebody who was being in the same situation and by age alone being the only difference they were an adult.
So he would be more suggestible then to giving a statement.
Yes.
That might not be true.
Yes.
All right, continue, please.
I gathered some information pertaining to the cultural perspectives that George may have influenced him. We all grow up in families that have their own unique cultures and values, and I needed to understand exactly what those cultures and values would have been. And from the information of the affidavits that were provided in the interviews with his sisters, what I learned is that there was certainly a family culture that black people were separate from white people. They did not commingle, they did not interact together, and that there was a reservation that came over them as individuals when they did find an opportunity to be in the presence of a white person. There was a level of respect that they automatically would give, whether that would be to not speak or to speak and maintain their distance. So in identifying that as the family's culture, I had to figure out, does this apply to George? And the information from Johnny strongly supports that it did apply to George. And what he described is he was present, Johnny was present when George came into the detention center, and he described him coming in with white uniformed officers and appeared to be very frightened. Frightened is Johnny's word, that is not my word. He also said that when the white men left, the officers had left the premise, that George's demeanor shifted and changed.
Was this a segregated holding area?
the jails were segregated. Johnny laughed at me when I asked whether or not there might have been any white people detained in the same detention center. So it was clearly segregated, and to the point that he found it humorous that I wouldn't have inherently held that knowledge. So in that one incident, perhaps one might question, is that enough information? What I found is that in the time that George was there, he had no other contact with white people because white people were not part of his daily environment. And the next time he had direct contact was when he was being picked up from the detention center and being taken to his execution in Columbia. And Johnny said that he had his demeanor change drastically, not in the context of knowing that that might have been the day that he was going to Columbia for his execution, but in the moment when the white men came back into proximity. So when I take those factors into play, it appears to me that the family culture was certainly a cultural, personal identity that George had adopted.
Dr. Salas, I don't mean to interrupt you, but can you tell me when you did these interviews with the sisters and Mr. Hunter?
I interviewed Mr. Hunter on the telephone. Today is Wednesday, Tuesday. On Monday afternoon of this week. And I interviewed Catherine yesterday afternoon from 2 to 3. And I interviewed Amy from approximately 3 until 3:45.
So you never had an opportunity or didn't use the opportunity to interview these people when you were doing your dissertation, when your investigation of this? And the reason why I asked that is it would be helpful if someone had interviewed Johnny Green, the brother who was also taken by the police, and again, we don't know that, but presumably interrogated as well to understand what had occurred. So you didn't have the opportunity or didn't take the opportunity when you did your dissertation to speak with these people?
I didn't even know that Johnny was interviewed and detained with George at the time I did my dissertation. But what I did learn in the interview with the sisters is that as a result of the arrest and interrogation of Johnny, that his affect and behavior surrounding the interrogation changed him such that he was not even able to discuss it at all from that point forward with the family when they would try to make inquiry with him, which points to an acute stress that he carried with him for a remainder of his life. But I can't say specifically how that would have impacted Johnny because I do not have the luxury of being able to interview him. So when we combine age, cultural considerations that we can now apply to George, what we are left with is a power differential that is inherently present in a custodial interrogation setting. I am not here to say that just because somebody is interrogated in a custodial setting that it's a false confession. So please do not think that that is my message. But aside from those inherent factors, we have two more very significant factors that increase that gap in that power differential, being the cultural dynamics and the age.
You're not suggesting any criticism of the police behavior in conducting these interviews, are you?
I have no information about how the interviews were conducted to render any kind of opinion on that matter.
All right, please continue.
That finishes suggestibility, so now we move on to compliance. And we're looking again at the element of compliance as it applies to the interaction when the interrogation was going on. When we look to the compliance, I'm looking at patterns of behavior.
Let me interrupt you just a second.
Certainly.
Could you tell us what compliance means as far as this individual or an individual who may be undergoing interrogation?
I can answer your question with a question, I believe. Compliance pertains to the question of how likely is this person going to cooperate with giving a statement that may be untrue because they are feeling pressure to produce that statement. So how compliant is an individual when they feel, whether it is present or almost as if it's just an inherent feeling that the person being interrogated feels, if they take it on to feel as if there's an element of coercion or pressure put on them in order to comply with whatever the dynamics are going on. So we're looking to see how likely would one be to conform their behaviors to fit what the pressure source is putting onto them.
So one could supply coercion without being, as we know, coercive, without being forceful, just by their presence, demeanor, race, position, etc. Is that what you're saying?
Absolutely. Absolutely. It's kind of like I can feel like someone has sexually violated me in some way if I walk down the street and someone whistles at me, and I take that to mean one thing, and that meaning has nothing to do with anything other than someone was whistling. It has nothing to do with me. It's the same concept, that what I perceive will influence my thoughts and my behaviors, even though the other person who's a party of that interaction has no intent of me perceiving it in that way.
Okay. Can you continue, please, ma'am?
Yes. So what I learned about George is that outside of the interrogation, he was the person who was described by Johnny when in the jail. He complied with all the rules. He was not aggressive with other people. He was not confrontational with other people. He did not own or possess contraband. He had times where he had candy. He looked at comic books. However, he never approached violation of the rules. Specifically, I asked pertaining to, he knew he was going to die. What did he have to lose in trying to escape? And Johnny said that wasn't his nature. He never contemplated that. He never put forth any behaviors that would suggest that that was something he was thinking about. That George was there interacting and behaving in a way that was cooperative in what would be expected of the rules that had been put on him. I also got a similar story and report from both sisters who acknowledged that their parents were strict and that behavior was not a problem in trying to get George to comply with rules that were put forth in the home environment. And as I already noted in terms of the previous slides, that Johnny's term was that George appeared, quote, frightened when he was in the presence of the uniformed white men.
And your conclusion from that?
That he found that there was a power differential and he was on the weaker end.
Continue, please, ma'am.
The brevity of the interview was, as I understand, approximately 1 hour in which this context was going on and the confession being made. I would love to have had a transcript of some sort, a document, a recording, somebody's notes to be able to review. But that 1 hour was significant enough that it impacted Johnny's life, even though he was released and he was never brought forth on charges pertaining to the crime against these two girls. It suggests to me that perhaps there was an element of coercion that was present, even if it was owned only by George or by Johnny, that would make it very likely for one of them to quote-unquote cave in and to comply with what they perceived to be the desired behavior in the context of what was going on.
So when these interviews were taken, if we assume that one of the interviewing officers had been called to the scene of this murder, that he had been at the scene, that he had observed the bodies, that he had observed the injury to the bodies, at least superficially observed them, and that subsequently he had taken George and Johnny into custody. Is there a element of suggestibility in the fact that this was not just a, yes, I did it and I'm telling you what happened, versus the officers knowing what happened before the confession was given?
I believe I followed your question. What I can say is that this appeared to have been a horrific scene where these bodies were found. I can tell that it not only impacted Johnny, but it also impacted Reverend Francis Batson. And when I say Johnny, I mean Johnny, George's brother, as opposed to Johnny Hunter, the cellmate. I would have expected there to have been a lot of questions. And I don't know that unless you were talking at a very fast pace, that you would be able to have all of your questions asked and answered and leave no stone unturned with the brevity in which this interview was conducted.
Having covered all of these areas, the underlying basis for your opinion, and I think we've covered them all now, have we not?
I'm sorry, but we haven't.
Oh, I'm sorry. I only have part of this slideshow, so please continue.
Okay. To the next slide. This one is short. So when I look at the context of what factors George Stinney may have brought into the interaction, I determined in my analysis and methodology that he was likely suggestible and possibly highly suggestible. I had a hard time moving likely into highly because of the fact that there is no recording, and I feel that that's a void of information that is not present that is very helpful for narrowing that down. But I found him to be highly compliant.
With those, and so based on that, do you have a conclusion as to the reliability of this confession?
Can we go over one more point pertaining to the psychological makeup
Sure.
of the confessor? The age and family culture are the things that I turn to when I'm looking at how the confessor, what psychological components they have that contribute to whether or not this is more or less likely to move into a false confession, or if it's available to be a reliable confession. And by age alone, I want to reiterate that this is an adolescent, a young adolescent brain that has not had opportunity to have 10 more years of development to refine himself with his psychological background and constitution. He doesn't have the ability to have higher order executive thinking and processes to be able to organize himself as meticulously or as rapidly as an adult would. That needs to be considered when you are putting him in the context of two adults interviewing one adolescent. And again, I want to reiterate that the family culture and how it applied to George personally was something that gives consideration to where his personal psychological makeup would contribute to impacting an assessment of whether or not the statement given would be more or less likely to be false.
Are there different types of personalities or findings as to false confessions in the literature?
There are some things that I did not find evidence of that are in the literature that you would look to as well. And you can advance to the next slide, please. I was looking at educational deficits or having any evidence of George having had a low IQ, perhaps whether or not he would have had mental illness present at the time when he gave this confession. And I found no evidence to suggest that he was of a lower intelligence or lower educational background that would have been impacting this. nor did I find any evidence or information that he had had a chronic debilitating mental illness that would have made him more vulnerable at the time. And again, I cannot talk about things which I have no information, which relates to whether or not police misconduct or appropriate conduct would have had a role to play in the dynamics of this evaluation. So on the next slide, this is how I answered these questions. Does the confession fit the evidence? No. Is the confession internally consistent? No. Was the characterization of the interrogator-suspect interaction, I characterize it as coercive? And what is the psychological makeup of George, who was the confessor? He was vulnerable. And that is how I draw my conclusion.
And your conclusion is?
It is my professional opinion, to a reasonable degree of medical certainty, that the confession given by George Stinney Jr. on or about March 24, 1944, is best characterized as a coerced, compliant, false confession. It is not reliable.
Thank you. Can I ask you then that there has been an issue raised about why this is so long coming, why this issue, the report, the family involvement has been so delayed all of these years. Do you have an opinion that might suggest a reason for that based on your interviews of the two women?
I would take the question. I don't think this witness has any technical training to support a conclusion about why this case has been brought this year rather than 20 years ago.
I don't think that's the question. I think the question that Mr. Chandler is trying to ask, that I have a question of, is at what point in forensic psychology do we start studying the reliability of confessions, and specifically reliability of children's confessions? Obviously, this is a science that's been developing. Was it something that was considered or studied back in 1944, and where was its genesis, and when did it start? I think she can answer that question. At least I hope she can, based on her training.
I found information that dated back to the 1860s that false confessions and psychological factors that need to come into evaluating whether or not there is a psychological basis that would influence the likelihood of generating a false confession, which tells me that by the time 1944 has arrived, it has had, is that 84 years to be in existence, if my math is correct? And certainly at that time, you may not have come up with the same conclusion as being a coerced, compliant false confession. Those words developed into the literature in 1985 to the mid-80s. But whether or not in 1944 what that opinion would have been a false confession, or is it a reliable confession? That would have been the question. The qualifiers that I am able to give it today would not have been
new, but
right.
But it was a science that was studied, and certainly we know that officers and law enforcement have been trained, and I don't know how long, but have been trained in how to induce confessions and obviously get confessions in cases.
Absolutely.
Okay.
And returning to my other question, Judge, subject to the objection, based upon your training as an adolescent child psychiatrist and as a general psychiatrist, in the circumstances that the delay of the sister's brother in reporting this or following through, is there a study, professional study, or an underlying basis that you can give an opinion as to why this delay is likely or why it may have occurred?
I understand what your objection is, Solicitor Finney. What he's calling for is a bit speculative. If there is a psychological basis of why you believe a family would not say anything, part of the concern in this case, and what's made it very difficult for me in reviewing the case, is the passage of time, simply. And the question I think everyone is begging and wants to know is, why didn't they come forward, in 1954 when we had Brown versus the Board of Education, throughout the Civil Rights era? It's kind of a why now? Why is it taking so long? I don't know if you have the basis or the background to be able to tell us that
I can
answer.
shed some light on it that may help an understanding develop.
And Solicitor, I will go ahead, and I understand your objection. Certainly when I hear the answer, whether or not I think it's appropriate, I can consider it or not consider it. That's part of the beauty we have, that she's testifying to me and not a jury. I can certainly know what is reliable and what I can accept and consider as to what is not. So I understand your objection. I am taking it into consideration, and again, and based on her answer, I can accept or reject it. So,
Subject to your ruling, Your Honor.
thank you, sir.
Would you please then, based on your interviews, et cetera, if you have an opinion, please address the court regarding that.
Your Honor, the impact of having two brothers removed and not having had parents there to protect any of the children at the time when that happened is something that the other children have carried with them for their life. Johnny, what I have learned, could not talk about this. It is possible that somebody who, if anyone had conducted an interview, could have investigated whether or not there was an anxiety component or problem that came about, almost as if PTSD could have been a model that would have fit his reluctance and his inability to discuss this. So would Johnny have come forth? He couldn't talk about it with his family. What is going to make him able to talk about it with anybody else outside the safety of his family is one of the concerns that I would have, that would say Johnny was less likely to bring this forth. The family moved in the middle of the night, and their lives changed significantly. And their father took on the setting the stage for, we are moving forward, we have nothing we can do to impact this, and we are going to carry on with our lives.
Doctor, can I interrupt you with something? These were, when you were interviewing these adults, they were adolescents or children at the time.
At the time when this happened, I believe Amy would have been 6 and Catherine would have been around 9.
Okay. Is there a stages of development scale that science has recognized that could be applied with certainty to this circumstance?
There is, and that's what I'm getting at, is that the family culture is going to influence the stages. So if you go to the last slide, I've actually outlined Eric Erickson's, keep going, I'm sorry. The next one. Thank you. Eric Erickson has studied the psychological development and applied it across the lifespan. That is what is unique, is that other models fit adolescence, or they fit childhood, or they fit the first 5 years of life, and then things change. Eric Erickson has applied how across all of our years, from birth until death, we all go through a development of change as it relates to the development of your psychological being in the context of your social circumstances. The events as they happened from the Stinney family's perspective with their brother George is certainly a social influence over their psychological development. The cultural tone that was set by George Stinney Sr. was, we are not looking back, we have nothing that we can do, and we are all moving forward. And that is how the family has fallen through and advanced from one stage of development to the next. Of all of those stages that are listed, and I've outlined them from infancy into adulthood, so you have to complete trust versus mistrust before you can move into autonomy versus shame and doubt. Once you have resolution of stage 2, then you can move into trying to resolve stage 3. All of those except for the last one pertain to how you navigate, perceive, and understand your psychosocial development in the present moment? How do you figure out when you're 16 years old whether you want to be emo or goth, or you want to be somebody who looks different from that group? That has to be resolved before you move into intimacy and figuring out what are your roles in closeness of relationships. Or when you move into generativity versus stagnation, and how do you parent what you have around you, that your work ethic, your children, what's left that is there for you to give information to and share. It's in the present moment. It is not until this last phase of life that you enter into ego integrity and you try to look back in a retrospective manner and you try to assign a sense of fulfillment. And it's looking for that sense of fulfillment that if you end up feeling fulfilled, that would have been a healthy resolution for the ego integrity versus despair. Can you maintain your ego, or do you live in the despair? And so this is the first stage that becomes retrospective. Everything else is present. So from a psychological perspective, this is the time, according to Erickson's model, when you have advanced in age, usually hit retirement, or 65 is about the age that references American textbooks.
You can move up from 65.
And that's true. That's true. So someone who continues their path of their career, or they are raising more children, a grandparent raising grandchildren, may stay in generativity versus stagnation because the circumstances of their life haven't moved them into that point of entering the ego integrity versus despair. And again, just like most everything else that we have in psychiatry, all of this is going to fall along a continuum. The movement from one to the next of these developmental stages, it's not going to be black and white, and it's going to fall along a continuum, and it's going to be something that is most likely going to be outside the realm of consciousness.
In this case, then addressing specifically the Stinney family, were you advised as a result of your interviews that there was other impediments to them coming forward, financial, cultural, other things?
Absolutely. Both Catherine and Amy identified that there were financial hurdles. There was a maintained concern that they had learned a sense of helplessness, and that if they couldn't spare getting George an opportunity to retain an attorney at the time he was going up on a charge of murder, there was a learned helplessness that we talk about in psychiatry as well, that told them, for their uniqueness of circumstances and the events that they had happen in their life, no one was going to hear them, no one was going to listen. It was not going to be something that anybody would be willing to look at.
Did they attempt then to go elsewhere outside of the judicial system to be heard?
I can't tell you where they went to be heard specifically, but I know that the family has made contacts with various media avenues. There have been times where people have approached them looking for opportunity to gather information, and hurdles have been brought before them each time they have either indulged somebody's inquiry or they have gone and tried to bring attention to this particular case itself.
In your interview with Mr. Hunter, did he give you any indication that he had attempted to come forward any sooner than 2 or 3 months ago?
He did. In fact, he referenced at least 2 previous times that he had attempted to take his knowledge and share it with someone, and he went through the media as well. Twice he called 2 major news networks, and twice he did not get a return phone call. And it wasn't until this 3rd attempt that somebody called him back and brought his name forward.
Did you find his your conversation with him, your interview, and his affidavit added any greater weight to your opinion than other things?
I find that the information that he presented added a balancing act. He has not known or had contact with the Stinney family prior to meeting George in the Sumter County Jail. He has not maintained contact with the family. The family doesn't know who he is. If you say the name Johnny Hunter until yesterday when I said, well, let me tell you who he is, neither sister had a knowledge of who Johnny Hunter would have been.
Thank you so much.
Mr. Finney?
Thank you, Your Honor. Good morning, Dr. Salas.
Good morning.
I don't think I'm going to be very long. I certainly don't feel like I'm as smart as you are on this subject.
I don't have a presentation that goes with your questions either.
That may benefit us both. In the field of law, we generally talk about issues in terms of proof and the weight of proof, a preponderance, beyond a reasonable doubt. And if you take the scale of justice as a symbol, we tend to try to talk to people, witnesses, judges, about tipping the scale and putting things on one side to make our point for our client. As a doctor, you talked about a continuum, but you've come to an opinion. And that opinion, I believe, is based on evidence, facts, study that tends to tip your scale, so that you believed at the end of your testimony that the confession of George Stinney was coerced and unreliable.
Only to a degree of reasonable medical certainty.
All right. Would it not be true that the scale that you use to come to that opinion would be affected by the fact that you did not talk to any of the family members of the deceased girls?
Would that scale be affected by the fact that I didn't have information from the victims' family members?
Yes.
If they had served as a witness and could say, I saw X, Y, and Z, if they had added some factual information, then that would be helpful.
All right. And so, and I apologize, I should have started out by saying, as a part of your investigation of this case, did you talk to any members of the family of the two girls?
No, nobody identified themselves as a member, and I was not.
All right. And is it my understanding that you began the real digging work this week on this case?
In terms of being contacted about this case, I was contacted about it this past Saturday.
All right. And today is Wednesday. So it's been 5 days, 6 days? 5 days.
Yes, sir.
That
5
you've been
days.
actively working on the case?
Yes, sir.
All right. And so prior to last Saturday, you've not talked to any of the victims' families, members?
No, sir.
All right. Did you have a chance, either under your dissertation stage, which I assume was 5 or 6 years ago?
2010.
Let's say 3 years ago. Either at that stage in your career or now, as the last 5 days as a working clinician, you have not read any newspaper articles from 1944 about the case?
I didn't have any newspaper articles pertaining to the information that I have used in order to formulate my opinion.
All right. And so you're not aware that over the last 70 years, newspapers in the area, even newspapers as far away as New York, have covered the Stinney case and given different accounts from people who knew the family of the girls and knew George Stinney and his family?
I don't know what is available in the media pertaining to this. I know that there's a book that is written. I understand that there's a movie, but as far as the breadth or depth of how far print material goes, I don't have knowledge about that.
All right. So, in the last 5 days, you found out from George's sisters and his brother, Charles, and the interviews that you did and the materials they submitted about George and his makeup as a 14-year-old.
Correct. I have learned from the interviews and the sources of information, and also from Johnny, who was his cellmate, Johnny Hunter.
Johnny Hunter, who spent how many days with him?
I don't know the extent of time that he was over at the Sumter County Jail specifically, but it was following conclusion of the trial, and it was approximately a day or two before he was leaving to be executed.
All right. Do you know what Johnny Hunter's age was when he met George Stinney?
He told me he was 17.
So, in the last 5 days, you have not been able to determine, I should ask you, have you been able to determine anything about the police investigation of the case from the standpoint of anything outside of what the family members of George told you? For example, you've been given the handwritten notes of Mr. Newman.
Correct.
Mr. Newman was a special investigator sent by the governor. I don't know if you knew that. He did not work in Clarendon County.
I did not have that knowledge.
And I'm sorry, that's incorrect. Mr. Newman was a deputy sheriff assigned to duties in Clarendon County. He was the one that wrote the report.
Mr. Newman wrote the report.
Okay.
I don't know his official title.
And I thought I heard you say that when George was interviewed, it was 2 against 1.
That was my understanding.
Where did you get that from, that understanding?
Excuse me, and he asked one question at a time.
I'd be glad to. I'm sorry. I apologize. Going back to your testimony, you relied on the fact that George was in the room with 2 officers giving his quote-unquote confession.
I can't remember if that was something that was in a discussion that I had, but in terms of factual, did I have reference from another detective? There was no other detective statement that would be able to uphold that reference of being 2.
All right. So as far as you know, based on the information that was submitted, George gave a statement confessing to the crime to an officer of the law.
He certainly had at least one officer of the law that was there.
And as far as you know, that's the only one that was there.
As far as I have documentation, yes, sir.
So you don't have anything to support the fact that there were 2 officers interviewing George at the time he gave his alleged confession?
I can't think of a document that would support that at this point, no, sir.
I also heard you say that the brevity of the interview in Johnny's statements to the police officers caused you to be concerned. And then you, in your testimony,
record? Yes. Apologize, Your Honor.
and your testimony was that it was about an hour in length.
Yes.
Where did you get that information from?
I believe that was something that was shared with me verbally from consultation with the defense. I
The
don't
lawyers
recall.
told you that?
Correct.
All right. You didn't see any place in the written materials that you reviewed that Johnny had an interview with the police officers that lasted an hour?
Let me look for just a moment, if you don't mind, because
Yes,
the
ma'am.
one question that I want to clarify is whether or not that was part of the stipulation of facts. Thank you, sir. That is not part of the stipulation of facts. The times that were referenced, we're referencing numbers 12 and 13. So I don't know that that would have been something that there is a document to support, and I would be willing to acknowledge that that would be able to be removed from the analysis, but it would not change my opinion.
Okay. And I guess I'll go back to my earlier theory that if you did not, let me ask you this question, I apologize. Did you have any school records of George Stinney to review?
I don't have documentation of school records, no, sir.
Did you have any health records, medical records or mental health records to review?
No, sir.
And would you consider those to be important sources of information for making a finding about the competency of a child?
They are very helpful, and they are certainly things that when we are able to access a broader source of information, we certainly pursue getting both educational records as well as the medical and mental health records.
I made a note on the outline that you were using, and I marked it as number 15. It says on that slide, there is no evidence found to support educational deficits. But the truth is there were no records reviewed. Is that true?
In terms of records, there was, let me get to that side, please. In terms of records versus evidence, I don't have written records from a school that produced a grade performance or something, but I did make inquiry with the interviews with both sisters, as well as, like I was discussing, the understanding of the word execute. And from that piece of information, the limited can be applied to determine, should I have a concern about whether or not this is a cognitively delayed individual or not. I've also learned that George was the secretary for his mother, and he would scribe and do all of her writings, which gives me an idea that, yes, when you put that into play, he had an ability to negate whether or not a deficit in education would have been a factor. So when I look at whether or not education or IQ or mental illness is present, I did, for what was available to me, an investigation to see if there was something that should say we need to be concerned about his education. The results of my inquiry and what I was looking for says that education did not come into play. Having a normal stage of education does not protect against moving you back down into a lower level of suggestibility. So because you have an age factor that can move you up the scale, just because you have normal education or normal IQ does not move you back down the scale. It just does not move you higher up the scale.
And so basically you're saying that you did not review any school records, no health records, and that you relied on the interviews with the family's sisters who were 6 and 9 at the time to make your assessment of George.
As well as information from Johnny
Hunter.
Johnny Hunter,
who
correct.
You don't know how many days he spent with George in the Sumter detention center.
I can tell you that George was literate. I don't know how many days that he was there, but he was literate and he was able to read. And I'll reference whether or not the wording is a reflection.
And if that's a slide in your presentation?
It's not a slide.
Okay.
No, sir. What this does, it moves George up the scale of what you would expect from being a concrete thinker into an abstract thinker. Abstract thinking is actually something that is a higher order of thinking. in the general population, it's estimated about 30% of people achieve abstract level of thinking. This is an adolescent moving into an abstract level of thinking that's higher order. Johnny had a magazine, and in the back of the magazine was an article, and he was paused on that page, and the page said, "Prepare yourself for the future." And he said, while he was on that page, and Johnny had no meaning of, like, there was no note as to why this would have been significant until he heard George's voice over his shoulder, and he said, "Gee, I don't have a future." What that indicates to me, from a psychological standpoint and understanding where George's brain might have been at that time, is that he can not only read, but he is reading words that are larger than 1 or 2 syllables. Future, yourself. Maybe they're 2 syllables. And he is able to apply it to himself, and he's able to look in terms of a future orientation. And at 14, when you should be at a stage where you're invincible, he had developed a sense of brevity and understanding the imminence of his death.
How much of a factor would you have contributed to the information you received from Investigator Newman that George took the investigator to the crime scene and recovered an iron pipe which was used to kill the girls?
How much weight would that carry?
Yes, as far as a evaluation of George.
It leads me down more questions, and the results of those questions would be the influence as to how much weight it carries. So for example, if I find that somebody's sharing information with me, and pursuit of that information does not come to fit the evidence, that puts us back in the first question in the slides of, does this fit the evidence that's available? If it fits, it adds weight to being a reliable statement. If it doesn't fit, it moves you into false confession, closer along that continuum in the less reliable. So that information is helpful for generating more questions to look at that continuum and assess it. If you have information that can move me along that, I would be more than happy to review it.
Well, doesn't the fact that a 14-year-old is reported to have been able to take the lead investigator to a point and dig around in some bushes and retrieve an iron rod which he said he used, isn't that supportable information that would give it the continuum of trustworthiness?
Not in and of itself.
Okay.
For example, if I take you to a place at 14 where I graze my cow every day, or I go to church and play with my peers, and I happen to have other information that brought me to leading you to something that would be reasonable to be by a railroad track, then maybe or maybe not, it's going to depend on the context of those other circumstances. And that's the crux of why this is so challenging, is because our information, as you are able to even point out, and what I have tried to accomplish very objectively, it's still something that we are missing components that, had this been done in 1944 and people had followed these kinds of questions and brought information to light, if we had information from someone's pursuit of those questions and it was recorded, we could draw conclusions that might shift one direction or another, and it might take where we are and move it up or move it down. But with the information that we have, we come to the conclusions as I presented them today.
All right.
At least I do, for a professional opinion.
May I ask for a moment? Dr. Salas, I thank you for your answers and your time. Thank you. If you please, the court.
Doctor, you went over for us when you began some time ago the things that you considered in rendering your opinion. Am I correct then that you read the evidence that was stipulated to
Yes,
and the things that were presented to you by agreement of counsel?
that's correct.
Okay. As well as interviews of different individuals, correct?
That's correct.
Did you find anywhere in the stipulation of the evidence or any affidavit from the people sitting in the back?
Mr. Chandler, I think we need to be careful because they have changed the stipulation.
That's correct.
And so you need a final copy of what was the stipulation.
Then let me
There were
move
some
on to that.
inconsistencies.
Let me address these newspaper articles. If we were to tell you, I want you to read the newspaper articles of what happened over the last 70 years. What would your reaction as a professional psychiatrist, forensic psychiatrist, be as to the weight they should be given?
They carry zero weight, and I don't want them as references.
So the reason you have not considered those has to do with your professional opinion, that they carry no weight.
Newspaper articles and information that comes from a media source carries zero weight in determining a professional opinion.
Now let's talk about the question that Solicitor Finney raised concerning his memory that George Stinney Jr. took this chief investigator to the scene and showed him the murder weapon. Is that correct? That's what he asked you about, right?
He asked me about that. That's correct.
Okay. Now, in the stipulations, it appears that the 15-inch iron rod has changed at least 2 other times and was referred to as a spike.
I have seen it referred to as a spike, a 15-inch rod, and I believe it was described as an iron pipe.
And so when you evaluate whether or not George Stinney Jr. actually did that, confessed to that, what do those stipulations, if any, what concern does it cause you?
It raises a concern pertaining to the question of internal consistency. If you have something that a confession sheds light on and you identify a weapon, from that point forward, if that is an accurate, reliable statement, you would expect consistency from that point forward to sustain itself over time. You don't expect the physical evidence of being an iron pipe or a spike to change while it sits in an evidence room or even out under the shrubs or in the brush. You would expect something of that nature, aside from perhaps rusting, to still maintain its physical form and be consistent.
Well, let me take you to the end of this procedure. The Olin Johnson letter that you were provided, that you
Correct.
read, credited the chief investigating officer with telling the governor personally that this girl was raped, was killed and raped. Her dead body was raped, and this man returned to rape her again, but the body was too cold. Do you recall reviewing that?
I did review that. I was just listening to make certain it's consistent with what is written, and as you just articulated it, I believe you captured it quite accurately.
And so the chief investigating officer made an official statement to the governor that this woman had been raped once after she was killed. Does the medical report or the report of Dr. Stevens confirm that that was a true statement?
I'm going to have to object because, as Mr. Chandler well knows, the officer who reported to the governor in that letter was Mr. Pratt. Mr. Pratt is not the officer who wrote the investigative report and was a deputy for the Clarendon County Sheriff's Department by the name of Newman. My questions have been conformed to Mr. Newman's information that was supplied to the witness.
If the court please.
Your objection is sustained. I think you just need to rephrase the question.
What I have is, quite frankly, I have just talked with the officer who made the arrest in this case. And my understanding, that's the Johnson letter, and my understanding the officer who made the arrest in this case was Mr. Newman. I did not intentionally mischaracterize that.
Okay. Well, you just need to ask this witness a question. So let's go forward.
The question is, do you find in your research validity in the statement that was made to Governor Johnson?
I did not find that what Governor Johnson reflected in terms of having a sexual motivation to be supported by the physical evidence as described in the medical examiner's report by Dr. Bazard, nor did I find it to fit the sexual stage of interest that George would have been at based on the interviews that I have conducted.
Do you know the date of the development of that Erik Erikson study?
I don't know the specific date. I believe it came out in the early 1900s. I can't tell you specifically when that came into our literature base.
How long did you work on the George Stinney case in your dissertation?
Ooh, it was several months. I can't quantify time. It felt like I was working all the time, but I know all of that work was not related to that particular case, but it was a rigorous program that I went to.
Do you consider yourself to have sufficient background in the case, notwithstanding the hours you spent now, to render the opinion you have given today?
With the background as it applies to what I am here to be able to provide expert testimony on today, I'm doing my very best to have my testimony and my opinion reflect the facts of the case as known to me from post-call from you. The reason why I am here is because of my previous experience in looking into these matters from 2010. And so, although I cannot recall exactly what I studied and cannot cite for you all of the references and resources that I used to gather the information, I feel that my knowledge is an understanding of the issue as it pertains to evaluating whether or not a statement is reliable or not, whether or not a confession that has been given is more or less likely to be false. I feel that despite the limited information, I have done a sufficient job with the time that I have had to do this and the effort that has gone into trying to contact the family members to be able to make an opinion. Otherwise, I would not make an opinion.
Thank you.
Please, the court. Doctor, I have one final issue. I think we've already covered it, but you brought it back up on recross. It deals with the murder weapon, and you marked it as being fluid over time.
Yes.
Isn't it a fact, doctor, that you would be concerned about the murder weapon being called different things if George Stinney was doing the changing? But in your references, the words iron pipe, 15-inch iron rod, spike were being changed by the solicitor, the investigating officer, other people in the court system, not by George Stinney.
It is true that it was reflected in their statements, which are what we have to look towards understanding the context of what might have gone on in the dialogue. That, what I've tried to reiterate is that we do not have the documentation of the actual words that were exchanged in that interrogation. So I do not have the ability to look at a transcript or a video or another primary source of what that confession entailed. I don't have a written statement that says, I, George Stinney, confess to blah, blah, blah. And so we look around the perimeter, and yes, the people who were very close in investigating this matter are the people that I do look towards their statements in understanding what George Stinney would have communicated in a confession.
But the fact of the matter is that the words that were changed that you call fluid were words by other people, not George Stinney.
That is correct.
Thank you, ma'am. Nothing further.
Anything further?
No, ma'am.
Dr. Siles, you may step down.
May I be excused?
Any objection to Dr.
No
Siles being
objection.
excused from the state or the defense?
We would ask that you be excused.
You may be excused, doctor. Thank you. Ladies and gentlemen, we're going to go ahead and take a very brief recess. By the clock up in the courtroom, it is about 13 after. If we could all come back in about 10 minutes, if we would, let's proceed through to lunch, get as much testimony up as we can, and we'll be back. We'll be at ease for 10 minutes. Thank you. Yes. It's all. Seated.
Come down, please. Oh, that's all right.
Please be seated, ladies and gentlemen. All right, solicitor? Yes, sir.
The state will call Robert Ridgway to the stand.
Come on forward, Mr. Ridgway, to be sworn, sir.
Place your left hand on the Bible, raise your right hand, state your name, please.
Robert Ridgway.
You solemnly swear or affirm your testimony to the court to be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you, sir. Have a seat with you, please. Please state your full name and spell your last name for the record.
Robert L. Ridgway and R-I-D-G-E-W-A-Y.
Mr. Ridgway, where do you live, sir?
Presently,
Now.
Summerton, South Carolina. I have a Summerton address. I live down at the lake.
And Summerton is in Clarendon County?
Yes, sir.
And when were you born, sir, if you don't mind me asking?
February 27, 1931.
All right, sir. And between, were you born in Clarendon County?
No, sir. I was born in Barnwell County.
All right, sir. And tell us what your father did for the better part of his life.
Railroad.
All right. What railroad line did he work for?
Atlantic Coast Line.
All right, sir. And did you ever have the occasion growing up to live in Alcolu, South Carolina?
Yes, I did.
All right. Can you give us a time period? For example, were you in Alcolu in 1944?
Yes, sir.
All right. And based on your age, you were born in 31?
Yes, sir.
All right. And so in 1944, you would have been about 14?
13,
right.
yes.
Did you follow your father into the railroad business?
Yes, I did.
And tell the judge a little bit about your experience. When did you become a railroad man?
March the 3rd, 1950.
And how many years did you serve as a railroad engineer or worker or transport worker?
43 and a half years.
And did most of that time, were you working for the Atlantic Coast Line Railroad?
I worked with Atlantic Coast Line and Seaboard Coast Line, which was submerged line,
Yes, sir.
until from 1950 until 1976.
Yes, sir.
And in March of 76, I went over to Amtrak.
All right. And how many years did you work for Amtrak?
17 and a half.
And then you retired?
I retired, yes.
All right, sir. If somebody had come to you in 1944 and said that they found a piece of iron rod about 12 to 15 inches long, kind of round in shape, what would you say that, as a railroad man, would that pop something into your head?
Well, not necessarily, unless I were to see it, then maybe I could identify it as...
All right. Let me ask you this. To the best of your recollection, in 1944, were the railroads using spikes to tie down their tracks?
Yes, sir.
Were any of those spikes 12 to 15 inches long?
Oh, no, sir.
How long would they have been during that time period?
Probably 4.5 inches. Could have possibly been 5.
All right. If we had a piece of metal that was associated with railroads and tracks and things like that, that was in the neighborhood of 12 to 15 inches long, heavy, made out of iron, what would that have been associated with as far as you're concerned?
I would have to see it.
All right, sir. Let me show you an object. I'm going to put it on the screen right next to you. Can you see this picture? It appears to be an iron laying on some bricks. Can you see that? Is it on your screen?
No, sir.
All right. Maybe we have a moment to cut your screen on.
That's mine.
I might have to approve before it comes on the screen.
You might have to.
Hit approve when it's on.
Thank you.
I'll be good if you tell me.
Got it. You're not talking which one is on. No.
That's it.
It is, okay, yeah. It's,
Can you see that pin, sir?
Yes, sir.
Does that look like a railroad pin to you?
It has appearance of a drift pin.
All right, sir. And it is called a drift pin?
That was the common term that was used. Actually, it would be technically it would be call the name of it, draft pin, I think, to be used a great term.
All right, sir.
It was used in connection with the couplings of the old or antique rail equipment.
All right. And when you say coupling, you mean joining one railroad car to another car?
Yes, sir.
And these pins were used to complete the connection?
Yes, sir.
All right. And does this particular item that's on the screen now, does it look like something that would have been around in 1944?
Yes, sir, on the rail cars, because everything over there were I'd say antique, not antique necessarily, but they used old equipment. The equipment they used on the rail side was not equipment like we used on the Atlantic Coast Line.
Let me show you a different object here. I'm going to try to get a little closer. Can you see that picture, sir?
Yes, sir.
There you go. Go the other way. Okay. Let me zoom in for you. There you go. Now, this is a different type of metal object. Can you tell us what that is?
That has the appearance of a drift pin also.
All right, sir. And would you describe it as you see it on this picture? About how long does it appear to be?
I cannot see the markings on the rule on the scale, but it would be in the vicinity of 12 inches.
All right.
11, 12, 13, somewhere in that neighborhood.
Is it a flat object, or how would you describe it?
No, sir, it's a round object, and as I can recall, those pins were approximately probably an inch and a half, it could be as much as 2 inches in diameter, and 11, 12, 13, 14 inches long, really depending on the size of the receiver.
All right, sir. And the receiver would be something on the railroad car?
Yes, sir.
All right. And were they commonplace, these pins, back in the 1940s for joining the cars together?
They were commonplace on the log cars.
All right, sir. And the log cars would be hauling?
Just hauling, they used them to haul logs in and out of the swamps.
All right. And take them to the sawmills?
Yes, sir.
All right. Did Alcolu have a sawmill in 1944?
Yes, sir.
All right. Do you know who the name of the company?
Yes, sir, Alderman.
All right, sir. Now, did you ever work for the Alderman Company?
No, sir.
All right.
I did a little yard work for Ben Alderman, who was the CEO there, but no, I did not work for the Alderman.
And so, if somebody told you they found a spike, you would have, is it your testimony that the spike is a great deal difference in size and dimension than this article called a drift pin?
Yes, sir. Yes, sir.
Did Atlantic Coastline Railroad run a railroad track through Alcolu in 1944?
Yes, sir.
Was there a depot there?
Yes, sir.
And what was the depot for freight as well as passengers?
Yes, it was. It was a flag stop for the passenger service, primarily freight, local. But we did have a passenger train that ran from Columbia, Sumter, Lane, into Charleston at that time.
All right. I thank you for coming today, sir, and I would ask you to answer any questions that this lawyer might have.
Thank you. Thank you, Your Honor. Pleases the court. Mr. Ridgway, how are you doing today?
Fine, sir.
My name is Steve McKenzie, and I represent the family of George Stinney. You said you were 13, I believe, when you were growing up in Alcolu. Is that correct?
I was 13 while we resided in Alcolu, yes.
So you were 13 when you moved back to Alcolu?
No, we moved to Alcolu in 43, in the early 43.
Okay. So my next question, I'm sorry, you moved there in 1943, is that correct?
Yes, sir.
Okay. So you were there whenever the murders of the Thames girl and the Binnicker girl happened?
Yes,
You were
sir.
living there?
Yes, sir.
And you remember that event quite well, don't you?
Yes, sir.
Okay. And you remember that the community was an outrage over this, is that right?
I wouldn't use that term, I don't think.
People upset?
It was not a common occurrence, put it that way. I can't say that they were upset. I didn't see anyone angry, or they certainly were disturbed.
So two white girls in a small town killed, murdered, their heads were bashed in, and nobody was upset?
I didn't say no one was upset. I did not see any anger displayed.
Okay, nobody was angry over that issue?
I did not see anyone angry.
Okay.
This certainly was not a pleasant situation. Yes, it was sad.
Okay.
The little 8-year-old girl
and no doubt about it was sad. But your testimony today is in a small town such as Alcolu, we have a map here, and we're going to talk about that in a minute. Nobody was angry, they were just sad.
I didn't say no one was. I said I did not see it.
You didn't see it, okay. But you were 13 years old, and you remember the events of what happened on that day well, right?
Yes, sir.
Okay. Now, Alcolu, the lumber mill, did your dad work? He worked with the railroad. Was he in charge of the spur that ran around the lumber company?
No, sir.
All right. Do you remember the spur that ran around the lumber company?
Yes, I guess I'd say yes. I know they had a railroad over there. I saw it. And
how long did you live in Alcolu?
We lived in Alcolu until 45, I believe. 45, maybe 40, 45. Then they eliminated my dad's job in Alcolu and relocated in Manning.
Right.
So they, of course, moved us over to Manning. But
so you lived there 2 years. You raked Ben Alderman's yard. Did you play in the neighborhood?
Sure.
Did you play with the black children?
Yes, sir.
Okay. And you played with the white children?
Yes, sir.
Okay. And do you remember George Stinney?
No, sir.
Okay. You never interacted with him?
No, sir.
Okay. Now, come down here a second. Let's take a look at this board. This is something that's been marked as a exhibit, but not introduced into evidence. Can you locate the railroad spur that would have come off? And you're a railroad man, right?
Yes, sir.
First of all, show us where the railroad, the main railroad line would have come through Alcolu.
Right here.
Okay. And you're pointing from, I guess
from Manning side
to going towards Sumter.
Yes, sir.
Okay. And this is it's delineated by two lines that are going this way. Is that correct?
That's correct. Yes.
Okay. Show us where the spur would have come off of there.
It would have been in this area right here.
Uh-huh.
Come down around the depot.
Right.
And then went off into the mill.
Okay. Is a spur on this map?
I don't see it.
Okay. So this map doesn't accurately reflect the railroad lines at that time, does it?
No, sir, I don't see the spur on here, no, sir.
Okay. Let me ask you this question. You remember the watchtower for the company, right?
No, sir.
You don't remember a watchtower being there?
No, sir.
You don't remember their tower being by the log pond?
No, sir.
At all?
No, sir, I don't remember it.
But you lived there 2 years, right?
Absolutely.
Okay, and you don't remember a watchtower?
No, sir.
Okay, but you remember a spur, right?
Yes, sir, because we live right here.
You live right on the spur?
Yes, sir.
So you live right down here?
Yes, sir, right at this intersection right here.
Okay, and so this map, as far as you're concerned, doesn't accurately reflect the railroad tracks on that day?
It reflects the main line that I don't see the spur on it, no, sir.
Right. Let me ask you this question. This has got Hotel Street running into Plowed Mill Road. Is that accurately reflected on this map? Does Hotel Street run into Plowed Mill Road?
I can't tell you that.
Well, you lived in Manning, do you know that?
I lived in Alcolu also, but I don't know what road it runs into. I never had an occasion to go out that road, to be honest.
Do you see, do you remember Green Lawn Baptist or Green Hill Baptist Church?
Yes, I know where it is.
Do you see it on this map?
No, sir.
Okay. So this map doesn't accurately reflect Alcolu as you remember it?
That map doesn't extend out far enough to include that church, I don't think.
So the church would have been way over here?
Yes, sir.
Is that what you're saying?
Yeah.
Okay. And you lived over here?
I live here.
Right. And so and the spur would have run, tell us where the spur would have run to.
The spur was just a siding.
Right.
From here to just beyond the depot.
Just so, in your remembrance of this, the spur was over here, and so if anything happened over here, it wouldn't have been anywhere close to any railroad tracks. Is that correct? Or any spurs, anything having to do with the railroad company. Is that correct?
I didn't follow. I didn't follow you.
Okay, let me back up. And sometimes I ask poor questions, and I apologize for that. My question being, there were no other railroad-type structures or tracks that you know of beside the main line coming through the middle of Alcolu or the spur which went into the lumber yard?
There was some tracks back behind the mill.
Okay.
I had a brother-in-law that lived down this road.
Right.
And there was a dirt road that broke off to the left that went by his house, and the church was just below his home.
Right.
I don't see it on here. I can't identify it.
So you don't know where, but there were tracks there too?
There was tracks beyond the church, to the left of the church.
Right.
A little yard, little storage tracks.
Right, but wasn't that a part of the lumber yard?
It was all part of the, I guess.
Okay. Well, do you remember the log pond?
Not really, no.
Do you remember this being the lumber yard right here?
Yes, sir.
Okay. So the tracks are not reflected on here. Am I correct on that?
I don't know. I don't know what the track layout was in the mill, because we didn't have an occasion to go to the mill. These tracks in the mill was owned by Alderman, a lumber company. The Atlantic Coast Line of my dad at the time had nothing whatsoever to do with any of this track beyond the spur, side spur, and the connection switch.
But you can tell me that you lived here beside the spur, and that spur is not on that map.
I can tell you that, yes, sir.
Okay. You can have a seat. Mr. Ridgway, you talked about the length of these drift pins. Am I mispronouncing that?
No,
Is drift or
they were commonly known as drift pins, but I think the correct term was draft or link pin.
Draft or link pin. And there were two images that the solicitor showed you. Is that correct?
Yes, sir.
Okay. Now, is it your experience if say you were to walk down a track of railroad that you could find spikes, railroad spikes, about every couple of feet you find one or two?
Not necessarily. You see them in the ties.
Okay.
In the real ties, but you wouldn't
You would see them come loose?
Occasionally, I wouldn't come loose, but
Okay.
it's not a common thing on a piece of railroad.
It's not uncommon on a railroad for the spikes to work themselves loose. Because the train, when it goes through, it's heavy, it's moving the track back and forth. Am I correct on that? And sometimes these spikes work themselves loose.
Yeah, the tie deteriorates, yes.
Okay, great. Now, I would suppose that if a drep pin or a link pin was missing, then two cars would not be connected. Is that correct?
If the drift pin from a particular car was missing, no, sir, it would not stay connected.
Okay. So my question then is, how does someone get their hands on a drep pin or a link pin unless they pull it out between the two cars?
Those pins would not have been on the spur to begin with.
They wouldn't have been where?
They would not have been on the spur track, our track.
Okay, so they wouldn't have been on the spur track.
It would not have been on the coastline spur. No, sir.
Okay, so they would have only been where?
In the mill tracks on the mill railroad.
Okay, and we've already identified on the map that that's that line right here. Is that right? And the one that comes over here?
That is the Atlantic coastline.
Right. So for someone to get one of those pins, they would have had to go and get it off of one of these lines. Is that correct?
Or a car in the storage yard over there.
Okay, or in the storage yard. So they would have had to go into the lumber company itself to get that. Is that correct?
They'd have to go on company property.
Okay. Were you allowed on company property?
Well, I'd never went on company property.
My question was, were you allowed to go on company property? If you went on company property, if someone stopped you and said, hey, what are you doing here? So you can get hurt out here. Did you ever do that?
No, sir.
Okay. Was it understood that you knew you couldn't go on company property?
My dad told me that.
Okay. All right. So the only place that one of these pins that the solicitor has shown us that could have been found would not have been found on the spur. Is that right?
That's correct.
Okay. Now, what would have been found on the spur? Could a spike have been found on the spur?
Sure.
Okay. You have a hammer at your house?
Sure.
Okay. Mm-hmm. I have one too. So, how long is the hammer?
How long is the handle or the hammer?
The hammer is usually connected to the handle, but if you want to qualify those two, that's fine. But let's say it's together.
Okay.
Okay. How long is that hammer?
12 inches.
Okay.
Give or take one.
Right.
Two.
Court's indulgent, Your Honor. No further questions, John.
Thank you, Your Honor. Appreciate you coming, Mr. Ridgway.
Any
Move that
objection?
he be excused.
Any objection?
No objection, John.
You're excused, sir. Thank you.
Call Ms. Frankie Dykes to the stand.
Come on forward, Ms. Dykes.
Place your left hand on the Bible, raise your right hand, state your name, please.
Frankie Daly Dykes.
Solemnly swear or affirm your testimony to the court shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Thank you. Have a seat, Governor. Please state your full name, spell your last name for the record.
Frankie Daly Dykes, D-Y-C-H-E-S.
Good afternoon, Ms. Dykes.
Hello?
You can back up just a little bit for that. I believe you're going to be able to talk loud enough.
I have a loud voice.
Very good. Ms. Dykes, where do you reside?
Goose Creek, South Carolina.
And have you lived there all your life?
Since 1964.
All right. I'm not going to ask you if that's the year you were born. I'm just going to assume it was. Do you know the name Betty June Binnicker?
Yes, I do.
How do you know that name?
That was the 11-year-old baby sister of my mother,
And tell me your mother's name.
Lorene Binnicker Bailey.
And was Miss Lorene, your mother, born in Alcolu, South Carolina?
Yes, as
All right.
far as I know.
And do you know what year she was born in Alcolu?
1922.
1922. And your mother, Lorraine,
Lorene.
pardon me?
Lorene. Lorine.
Lorene.
Yes.
All right. Did she go to school there in Alcolu?
She did, but she ended up graduating her last year in Holly Hill.
Holly Hill. Now, can you tell me if Miss Lorene married?
Yes.
And when she married, where did she and her husband reside?
Well, Dad was in the Army, so she stayed with my grandmama. My brother was born, he was 10 months old when Betty June was killed.
All right.
So they were there. Dad was still in the Army.
All right. So your mom and dad, the firstborn, I was going to get to this next, the firstborn child was a son?
Yes.
And he was 10?
No, he was 10 months.
I'm sorry. I heard you say 10. He was 10 months old
Yes.
at the time of the death of Betty Jean?
Yes.
All right. And after the 10-month-old, were there other children?
Yes, me next.
You next.
Yes.
And then were there other children after you?
I have 2 brothers that are younger than me.
All right. And are some of these people in court with you today?
2 of my brothers.
All right, very good. I asked you to bring photographs of Betty Jean from your family,
Yes.
and did you do that today?
Yes, I did.
All right. Could you tell the judge what's been marked as states number 3, which is a 5x7 color photograph, who appears in the photograph, and tell us a little bit about the history.
This is Betty Jean. I think this was probably taken when she was about 8 or 9. She was the baby of the sisters, of the family. She had 2 older sisters and she had 2 older brothers.
All right, and I want to show you states exhibit number 4.
This we think was taken the summer before she was murdered.
And she would have been about 10 years old when that picture was
Yes,
taken?
her birthday was December the 9th. She was 10 years younger than my mother.
All right. And 10 years younger than your mother?
Yes.
All right. And that's states exhibit number 4. Now, do you know where Betty Jean lived at the time in 1944 when her life was taken?
She lived with my grandmother and my grandfather
And
in
was that
Alcolu.
In Alcolu?
Yes.
Do you know what street that was on?
Hotel Street.
On Hotel Street?
Yes.
And do you know whether or not she had neighbors, other children?
Yes.
Mary
Emma was the next door neighbor.
All right. Mary Emma Thames is the other young lady
Thames,
who lost her
yes,
life.
yes.
All right. And the name is spelled Thames.
It's pronounced Thames.
Thames. And your information is that Miss Thames was a next door neighbor to your family member, Miss Binnicker.
Yes.
Would you tell the judge how this case, having been resolved in terms of the trial, you weren't alive in 1944.
No, I was born 2 years later.
How has this case affected you and your family members in terms of its being resurrected every 10 or 15 or 20 years?
We never dwelled on it daily. We always knew that our aunt was murdered and her friend, and we always knew that it was George Stinney Jr. My grandparents to begin with never recovered. That was their baby daughter. That was my mother and my aunt and my 2 uncles' baby sister. They doted on her, and they never ever recovered from that. And as far as coming up, This has been coming back and forth for as long as I can remember. And we never responded to anybody because we just thought it was another, it'll go away. But when somebody told me that my grandparents had taken money to shut them up and be quiet and that they knew the true murderer, is when I got mad and angry and hurt. How my grandparents were as poor as church mice. They worked in that lumber mill and they picked cotton. And to even suggest that they took money, no, do not tell me that.
Do you think that has it been helpful in resolving some of the feelings that that your family and you harbor to go through this hearing and to have the judge listen to this evidence at this point?
How do I feel about it?
Yes,
or
ma'am.
has it helped me?
Yes,
No, it's not helped me. I've heard stories here that I believe are false. It doesn't change my feelings about what happened.
Do you and your family members who are present today know of people who were alive and saw things and heard things and were part of the community in 1944 that could have been helpful to the judge had this case been brought years ago?
Yes.
And are those
Yes.
people still alive and well now?
Yes, my mother only died 6 months ago. She was 90 and had perfect mind. She could have told them anything they wanted to know. We were told when I called.
What we were told.
Don't go into what you were saying. Let me ask you this. Did you have occasion to meet
No, but I was told that.
You can't talk about what somebody told you. I'm sorry.
Okay, sorry.
We've
Sorry.
been through this. Did you have the occasion to meet a Mr. Pratt who was an investigator on this case in 1944?
Yes, I did.
All right. And do you know when Mr. Pratt died?
Oh, my goodness. Probably 10, 12 years ago.
10 or 12 years ago. And he was still alive as far as you know. When you met him, was it shortly before his death or a long time before his death?
It would have been when Carolina Skeletons came out, which I think was in the early 80s.
All right.
If I might be wrong on that.
So sometimes around, let's just say if it was 20 years ago,
Oh, yeah.
1984.
Oh, sure. Yeah.
You, Mr. Pratt, the investigator, still living in South Carolina.
Yes, Moncks Corner.
Do you go back to Alcolu regularly? Do you have friends or relatives there now?
No.
Has Alcolu changed a lot over
It
the last
looks-
20 years, would you say?
It looks absolutely nothing like I remember the last time I went there. There's nothing. No portions of the mill that I could tell. Most of the houses, all of the houses are gone.
Are you and your family satisfied with the way the system worked in 1944 as far as the trial, as far as you know, since you weren't alive then? Based on what you know, do you have any concerns, or are you requesting this judge to do anything different about the case based on concerns that you have, or are you in favor of keeping the record as it was, as it existed, as a conviction, and keeping the case closed?
I believe that he confessed. He was tried, found guilty by the laws of 1944, which are completely different now. It can't be compared. And I think that it needs to be left as is.
I want to thank you for coming today. I want to
You're
thank your family
welcome.
members for supporting you.
You're
And I want to
welcome.
ask you to answer any questions that the defense may
I
have.
will.
Your Honor, before I sit, I would like to move these two color photographs into evidence in State's Exhibit number 3 and 4.
And we have no objection.
Without objection, they're in evidence.
Oh, sorry.
Ms. Dykes, I think you were not around when was she your great aunt?
My aunt,
Your aunt.
my
she-
sisters,
when she
my
was-
mother's baby sister.
When she was killed, you were not born.
No, not until 2 years later.
Okay. And you believe that George Stinney got a fair trial?
I believe that from what I've learned
Mm-hmm.
and what I was brought up with, I believe that back then, yes, I do.
Okay. So you believe that it's okay that a young black 14-year-old boy was brought into a court of law and prior to that was not allowed to speak with his parents but while he was being interrogated by the police. You think that's okay?
I think that he was 3 months short of being 15, and I think yes.
So you think that's okay?
I think
you have
that
children?
I do.
And would you be okay with your 14-year-old being taken into a police investigation and questioned without you being present?
Knowing my children, yes.
Okay. So you think that's okay?
Yes.
All right. Would you be comfortable with your 14-year-old, if you have a 14-year-old?
I have a 48-year-old.
Okay. When he was 14?
Yes. He
Would
was
you
working.
been okay with your 14-year-old being tried by 12 black men and he was the only white person in the courtroom?
If he had been arrested and they had got and he confessed, yes, I would.
So you have no problem with that?
At 14, 3 months short of being 15, my son would have known better. And he was not mean.
Okay.
No, he would not have, I would think that you live by the sword, you die by the sword.
So my question to you is that your son's facing execution.
It would be hard, but my son would know better at that age.
I'm not asking you whether or not your son would know better. I'm asking you, would you be okay with that question? Would you be okay with
I
that?
would live with it.
I'm sorry?
I would be hurt, I would be very sad, but I would live with it.
Would
I
you
would
like to have
accept
been,
it.
would you like to have been present in the courtroom?
Then?
Okay. And are you?
Oh, you mean this is if my son?
Yes.
I
At
probably
14.
would not have even wanted to have seen it, no.
Okay, so you wouldn't want to see that?
No, I wouldn't.
Okay.
I would accept it.
Okay. And so you're okay with the way this trial procedure was handled?
I don't think that was the only one that was handled that way in 1944. That was, some people didn't even get trials that were accused of this.
Okay.
Okay?
And we just summarily executed and we didn't give them trials?
I didn't know anybody that was executed,
But you just said some people didn't get trials back then.
according to what I've read.
Okay, according to what you read. So,
Yes.
So what the state did, as opposed to giving them a trial, they just, when I say summarily executed, they just didn't even have due
I don't
process.
think maybe the state did it. I think other people did it, their peers.
Oh, their peers. So that was lynching back then? Is that what you're saying?
I think probably maybe walking the plank at one time, lynching at one time,
Walking the
shooting
plank,
in front of a...
So my,
Mackenzie, I've given you a lot of latitude, but we need to bring it back. And again, you're asking her to talk about constitutional and legal issues.
And
She's
I
not
will
a trained
back away.
lawyer.
I'll back
So
away.
we need to wrap this up. I gave both of you a lot of latitude in putting this up here, but I want to make sure what we've got is appropriate.
the only other question, you've discussed the fact that sometimes trials are good and sometimes they're not appropriate, right?
Did I say that?
I think you said that sometimes it's okay not to have a trial. Isn't that what you discussed earlier?
I object to that, Your Honor.
Okay, sustained. That's not what she said.
Okay.
You need to ask her a question.
Do you think it's okay to lynch someone for a crime without a trial?
No, I wouldn't lynch anybody.
Okay. That's all the questions I have.
No, perfect.
All right. Any objection to Ms. Dykes stepping down from anyone?
We request that she be excused.
All right, ma'am, you may be excused if you wish. Thank you.
Thank you.
Your Honor, the final issue, I thought we had taken care of this earlier, because Mr. McKenzie wasn't here, but I did ask the court to allow me to move this map, or copy of the map, into evidence, and you requested that over the lunch break, I get a copy from the copy shop of the map. It's already been marked as exhibit number 1. It hasn't been moved in, but I'm hereby moving this map in for the references that have been used by the witnesses.
Mr. McKenzie, you weren't here when Mr. Chandler agreed to it, and what we talked about in what was testified to by witnesses was there are some differences in the map, and I think we can all agree, and I think all the witnesses were clear and testified that on the larger map it doesn't show the dirt road going by Green Hill Baptist Church, but on the smaller one it did, and I don't think you were here for the benefit of that. So we actually had the combination of the two maps, which were both testified to in this. So Again, what Mr. Finney had asked me was the map is borrowed from someone, and he wanted to return the actual map, and I said only if he is able to get an exact copy of it, same size, everything else, from a blueprint shop or whoever can print that for us. So, subject to that, do you have an objection?
No, ma'am, I don't.
Thank you.
And I think it goes to weight. You heard the testimony.
Clearly, I heard the testimony, I can compare, and I think the witnesses very well stated what was not on that map and what they could and could not remember about Alcolu, and so I think it's clear for the record.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right.
We have no more witnesses.
Okay. Can you see the attorneys? On into the lunch hour, but I am endeavoring to finish up this hearing. I do have other matters to take care of here in Clarendon County beginning at 2 o'clock. And because we do have to have those matters heard today, we do have people being transported. We're going to go ahead and go forward. I'm just going to ask both sides to just make a brief statement or comment in regards to, for the defense of the motion, from the state, their defense of the motion, and I may have a few questions, so forgive me, Mr. Shealy and Solicitor Finney, if I interrupt you, but certainly they are questions that I have, but if you want to go ahead and begin, I am happy to hear. Okay? Mr. Shealy, I may be able to help you or direct you into what I am looking at. This case was originally brought as a Rule 29B after discovered evidence motion, and as you know, the requirements for a Rule 29B require that whatever the after discovered evidence is, it must or be likely or probably to change the outcome of the trial, that it had to be discovered since the trial or after the trial. It could not have been discovered before the trial by the exercise of due diligence, and then obviously it has to be a material issue in the case, and finally it can't be just cumulative or impeaching. Your second subsequent brief that I received, and unfortunately I didn't get it until almost Sunday night or Monday morning for the simple fact that the court's computers were down over the weekend, was the idea of bringing this case on a writ of Carmen Mullen. Which I understand you were the one that provided the brief on that. Obviously, we've done the research. I don't think the solicitor has had quite the opportunity to do it that everyone else has, and I am going to allow him an opportunity to brief that for me. But as you know, the principal function of a coram nobis is to correct an erroneous fact in the record that was not known when the judgment was rendered, which couldn't have been presented by a motion for a new trial, appeal, or other existing statutory proceeding. It can't be an ineffective assistance of counsel. It can't be certain things. Of course, it also doesn't lie for the fact, and it can't be for newly discovered evidence. So my question becomes, what are you relying on at this point? Having heard the testimony, I didn't require you all to elect, and I needed to go forward to hear what, in fact, you all were going to put forward as evidence and testimony in this case. What, in your opinion, is what is your strongest case, or what you propose or are asking me to do?
Excuse me. I think the court can consider the case as a writ for a motion of coram nobis. It is very clear from the case law, and I would like to quote some in just a moment. I'm remiss about doing that in trial court. I know that you can read it, but I want you to be clear about some of the hard black letter law, some of it, that we're relying on for coram nobis. And we think that one way to look at this is a coram nobis. Virtually every issue we've raised or presented evidence for and testified to that we've attached to motions is appropriate by way of coram nobis. And if I may, start just before I get into those details, what I think that Your Honor can hear. We filed this with you. It was sent. The solicitor should have copies. And I had been on this case a little more than a week myself. So nevertheless, we're glad that you may let us brief something after the fact if you think that's appropriate. United States versus Morgan, a 1954 United States Supreme Court case. The United States Supreme Court waxed eloquently about coram nobis in that case and made it very clear that coram nobis still existed under the Federal All Writs Act. And that's not relevant here, the All Writs Act. That's federal law, understand it. But why it is relevant here is because this case, as well as cases we've cited from the South Carolina Supreme Court, make it absolutely clear that coram nobis is part of the common law. There's no question that in South Carolina, unless the common law is changed or altered, as it has been by South Carolina Rule of Civil Procedure 60, which is irrelevant, we still have these motions. And coram nobis in particular, the case is worth reading closely. The problem here in Morgan, and I will just read a couple of bits of language that I think are relevant for the coram nobis and the criminal proceeding generally. The court starts off discussing it, and I believe it's, let me just be clear for the record, I'm quoting from the U.S. Reporter. So the case would be on page 506. The court says, beginning of the paragraph, we think a belated effort to set aside the conviction and sentence in federal criminal case is shown. Notice they say it's a belated effort because coram nobis, that goes to the timeliness. It's belated here. It's late. They realize that. And I'm going to dwell on that a bit more with black letter law. The court can read the whole thing. I won't belabor you, but I just want to be sure we see certain language. Footnote 4 of that same opinion, such a motion, referring to coram nobis, is a step in the criminal case and not like a habeas corpus where relief is sought in a separate case and record, the beginning of a separate civil proceeding. So that's why we're still in the old criminal case as this is, while nobody's alive, very few people, this is the same court actually sitting today that convicted Mr. Stinney. And then lastly, I would point to, and it is found on the end of page 507 in the official reporter, and there's much more language important, but I want to read this into the record and discuss it in detail. The United States Supreme Court said, the writ of coram nobis was available at common law to correct errors of fact. It was allowed without limitation of time for facts that affect the, quote, validity and regularity of the judgment and was used in both civil and criminal cases. While the occasions for its use were infrequent, no one doubts its availability at common law. That's the first quote I want to give you because statute of limitations and timeliness issues, and I will, if I'm allowed, talk much more about that, are not the same for coram nobis, even as they are for habeas and post-conviction relief. I think the court should have, if you don't, I cited it in my memorandum, it's easy to find, Solicitor Finney. I would recommend a good outline of this and discussion of the law is in AmJur. It's a very good work, and generally this is found at, which I've cited in my memorandum in part 18 AmJur under Trials 1. And there are about, under that section, 1 through 46 sections dealing in detail with this issue. And I would like to direct the court's attention, if I may, and again, I regret to have to try to read so much, but this is really the core of the black letter law. Not all of it, but the core. And I look at section 27 of AmJur, which I find, looking at the cases, adequately sets forth the black letter law on this issue. The section heading is time for submitting application of coram nobis. And it says, as a general rule, relief by writ of coram nobis is not governed by any statute of limitations and can be applied for at any time. And it does go on to say subject only to a showing of reasonable diligence. The main considerations that govern the effect of a delay in applying for a writ are whether the judgment complained of is void or merely voidable. I will discuss that in a minute. And 2, the nature of the specific grounds for which the application for the writ is based. And the reason those are important, because for some, timeliness is not an issue. For some, it's only reasonable diligence, and that's the only standard. and we maintain that's a de minimis kind of standard. This discussion goes on to say, if I may, a void judgment gains no validity from the passage of time. Therefore, a prolonged delay in applying for writ of coram nobis to attack such a judgment ordinarily will not bar relief. We have real problems with the actual judgment and how that was obtained in this case that go beyond ineffective assistance or any kind of after-discovered evidence. They go on to say, though, if the judgment is not merely void but is voidable, then reasonable diligence may be required in such cases, and that's different between a voidable and a void judgment. We actually think there are reasons for both in this case, that it is void and voidable. Next, Your Honor, the court here, the section of law here citing many cases in the last paragraph says the particular ground for which a petition of coram nobis relief is based will also often determine whether delay in applying the writ relief will, delay in applying for the writ relief will bar relief. If the petition is based on such grounds as the violation of the petitioner's right to counsel, or the inducement of a plea or of guilty through fraud, deception, mistake, duress, or fear, or the knowing use of perjured testimony, or some other ground showing a clear denial of due process, the petition can usually be made at any time, and they go on to cite thereafter, to be fair with the court and the solicitor, that there is some split on that, although that's the general rule. With that in mind, and without reading any more of this, but not withdrawing what we have said already, I would ask the court to remember that this is a last-ditch remedy at law. It is special, and it is in the nature of equitable relief. Now, if I may start off with what I think the state's contention might be here in terms of timeliness and what is going on there. I think, with all due respect, what we really mean by timeliness is prejudice. What we mean by timeliness is what we refer to in civil court as laches. At least that's the way we pronounce it in this part of the world. It's French, so I'm not sure if that's proper pronunciation. But it's laches. What does that mean? That's what goes on in post-conviction relief. The court has recognized that laches can be a defense there. That's really what I think we're talking about. The importance is the prejudice that is shown. And the solicitor has mentioned the evidence that he does not have. But I must say this before I go on to specific facts we're relying on. As an equitable kind of remedy that slips in through coram nobis into the criminal section, in equity, whenever a party asserts an equitable remedy, it must have clean hands. If you don't have clean hands, you don't get to assert an equitable remedy. That's basic equity from law school. Now, I want to be clear. I want to be absolutely clear. We're not accusing Solicitor Finney of any wrongdoing at all. We're all born well after this. We're not even specifically zeroing in on the trial judge at the time, though I have doubts, or the solicitor at the time, though I think there's some serious doubts. But we're talking about the state of South Carolina as an entity. It's not about individuals. It's how this entity treats criminal defendants. It is the state of South Carolina's responsibility as an entity to maintain due process, to maintain the rule of law, even in 1944, about how things are done, irrespective of any misconduct by any individual. The problem here is that we believe the state as an entity has very unclean hands, and we think we have shown that, at least that, by a preponderance of the evidence, which will be the standard under coram nobis. And if the state has unclean hands, it cannot, just like anybody else in equity or any other kind of remedy, cannot come into court and say, oh, you can't raise that claim against us, it's late, we're prejudiced, we have an issue here, we can't defend about that. If the party claiming that is partly responsible or is at fault for bringing about the problem that led to the claim, you don't have the equitable remedy of laches, of prejudice to argue. We think that's a serious point here that the court has to consider. Now, with respect to that, what precisely am I talking about? Again, going back here to the distinction between a void and avoidable judgment. And there are certain facts that have been stipulated to. That's over. There are certain facts we think we have proven by a preponderance of the evidence in this courtroom in the last 2 days. First, the avoidable judgment. There is a serious issue about the way the coroner's inquest was conducted and the grand jury indictment was reached, and about how that was done. And we believe even in 1944, a proper lawyer doing their job of court should have recognized that indictment probably should have been quashed. Whether or not they could go back and get another one is irrespective. They did, there was serious problems with the constitution of the grand jury, given the coroner's inquest, and that's not disputable before the court. And if that indictment is thrown out, that court did not have jurisdiction in 1944. That judgment is void. And that can squarely be addressed by coram nobis, because that goes to the record before the court at the time, which is still before this court today. That is a tremendous problem. So that's voidable, and we submit under the clear black letter law without exception. Coram nobis would not even require reasonable diligence on that point, because it's still a judgment that's maintained. It's still maintained today. It's as much maintained today as it was in 1944. So those are important considerations before the court. Now, what other kinds of considerations might make this voidable, so that we're clear? And I'm hoping that perhaps the court will hear a bit from Mr. McKinney, Mr. McKenzie, who knows more about the detailed facts than perhaps I do. But a laundry list, and you've already heard it, it's not only what's stipulated to, it's what's before the court. There are serious issues about, even then, the murder occurring so quickly in March, and him being actually executed 81 days later. The fact of there is no, we talk about this record of the trial, we can't even read it, but what we know is there no witnesses called on George Stinney Jr.'s behalf, and there's no cross-examination. I think, right, and that's the third point. And that's probably why the transcript was not transcribed. I do not know how transcripts were maintained in 1944, but,
They were by shorthand.
I would think so. And probably no machinery, and the file would have been destroyed, especially if there's no appeal. It would have never been done. But the notion, even in 1944, that you would not have taken an appeal from a case like this or asked a question or called for a witness really shocks the conscience, and it should. Forget the criminal procedure revolution that took place afterwards. That's all we think is a serious problem that could have, for a habeas, for anything in 1944, or a coram nobis, which yes existed in 1944. The problem then for us is that he is, by June the 17th, he is dead. Now, let's look at due diligence reasonable diligence, as the law says, as it might affect the Stinney family. We have undisputed evidence they had to leave town. And we can debate how serious that was, but they left town and got out quickly for a while, and most of the family broke up. What would one have done from 1944 to the present? Was that family, were they unreasonable in their behavior? Because that's all the standard is. They have to just be reasonable in their behavior. And I think everything they did was reasonable. If you look at the facts before the court and you look at the pleadings, yes, there are some letters for clemency, but they don't articulate a lot of facts. There aren't people that are willing to come forward and be lawyers and defend the case. The Stinney family is poor. Their parents are poor. There were appointed counsel at the trial. They couldn't afford one then, even in 1944.
Mr. Shealy, let me ask you, one of the questions I've had is why the NAACP or the ACLU hasn't become involved in this case.
I cannot speak to that, but I will say this, with all due respect, I think that's entirely irrelevant what other people would do. We've got to focus on the parties, and the only ones that can be here is their family. I don't know when the NAACP came into existence, but certainly in the 1940s and early 50s, its influence was much less. A lot of these organizations, like the Innocence Project and others, exist only relatively recently. And, the problem is here we have a deceased defendant, which we've already discussed and talked about this. In terms of spending money and time, there's nobody to get out of jail to free. That's a problem. But
Clearly, they want to take care of people who actually are currently incarcerated and still living and spend their resources there.
Right.
I understand that argument.
And I don't think it is relevant at all what other people could or could not have done for the Stinney family. We have to look at what they could have done, what they had the power to do. Other people aren't parties. They certainly could not have intervened without them. But there's no basis to think that they behaved unreasonably. The only thing we really have is in the 1980s, and it's the late 80s when that book about skeletons comes out. And that's a novelization. The movie, I think, is out around 93 or 94, so we're already late in the game already. And let's be fair. I don't know what role they had in it. There's been no testimony that the Stinneys made it or made any money out of it. Somebody else did it, and it's a novelization, and a lot of facts aren't in the record. Most of it, I understand, is not true. But that's, in any respect, it was inspired by these events. So I don't know what effect a Hollywood movie presentation that's made for TV and a book that somebody writes really is noticed and constitutes a legal argument. That's the problem. The other thing is that I do know, when Mr. Frierson gets involved in this thing in 2004, that seems to be the first point, other than some spurious newspaper articles, which we've already talked about, are irrelevant. You wouldn't accept them here. We're not complaining about that. We get it. But as far as considering that notice for the Stinney family, the fact that we can't put them in evidence here, and a lot of the facts is perhaps why they didn't signal to the lawyer it was a problem. They dribbled out, and it's not many. It's hearsay. It's all kinds of problems with those. I don't think that's noticed. The only concrete thing that we see is in 2004, thereabouts, Mr. Frierson gets involved. We're seriously going out and questioning people and putting the dots together, and that's where it starts. And then someone has to consider this, and it's not long, I think it's 2009 or 2010, when the case comes to Mr. McKenzie. And, you know, you get a case like this, and you start putting together a 70-year record, worrying about interviewing people and trying to do some legal work. I don't, certainly whatever happened in the 2000s today cannot be counted against the Stinney family. They still haven't retained a lawyer. They still haven't paid an investigator. They still, and they're not in a position to do that, to mount a case like this. I don't think they were unreasonable in what they did, given the history, the circumstances, and what their family faced. And let's remember, none of them are lawyers, none of them are legally trained. And to this day, you know, even though I think the coram nobis applies, when I tell people about what have you done, we've helped file a petition for coram nobis. What? Even among lawyers. And it is rare, and it is unusual. And we have asked the court to exercise some discretion in that regard. But, you know, the bottom line for the Stinney family and most people is when that young man died on June the 16th at age 14, what could we really do other than suffer with it? And I think recently, only in the last, if you will, even 20 years, has the Innocence Project really started winning cases for living people. This is still difficult. It is still expensive. Most defendants can't afford this when they're alive. And so we don't think that there's anything, only the Stinney family can have been reasonable or unreasonable, not other people who don't have any duty to get involved with this. They were not unreasonable in waiting for this evidence to be put together. It's all really fallen in place since the early 2000s, if you really look hard at what's there that somebody's done, and maybe the mid-2000s, and it wasn't in place then. And it's been worked up and developed and reviewed, and witnesses have finally been called and they're presenting themselves to the court. So in terms of setting aside the void part of the judgment, which is we submit of no consequence, and there's serious issues there, but looking at why it's voidable, at the same facts, the way the Stinney family was treated in 1944, there's nobody disputing it was, let's just say, to put it overly mild, very, very poor by the state as an entity. They had no reason to believe for a long time that there's anything they could do to set this aside. And certainly there aren't a lot of cases in South Carolina and not a lot brought. And most of them have brought in more recent times. So we think, Your Honor, we submit that, one, the black letter law is clear, and that timelessness may not even be an issue, is not an issue on some of these standards, because we're setting aside a judgment that's still there. The second thing is, as to those reasons that might make it voidable, which have been testified to and argued, they have only recently been brought to fruition and developed very recently, and reasonably so, in a case of this nature. So the Stinney family is not unreasonable for doing this. I want to, and one other thing, just in summing up, and I'd be glad to take your questions or submit further briefing. Latches, it's not about, certainly about Solicitor Finney. It's not even about the solicitor at the time, though it should be. And it's not even about the judge at the time, though maybe it should be. It is about the state of South Carolina and whether they can really stand on the defense that we have clean hands and we assert an equitable defense to this. And I don't think that they do. And I think we've at least proven by our preponderance of the evidence that the state as an entity does not. And so that's a real problem with using that latches language. One other minor point. Latches and prejudice are the same thing. It's a bit different here. In the normal circumstance, we have a live defendant who can get a new trial. That's a strong case for latches and prejudice. The state's got to put witnesses up there to try this person. And they still have a problem, I understand that. But let's be honest. If you grant the relief we ask and we think you should give us, it's an order vacating the judgment of conviction. We can't even ask you for an order to vacate the sentence because you can't. We can only ask you to vacate the judgment of conviction. I know the Stinney family wants more. You can't order a new trial. That can't happen. So that prejudice is really of calling witnesses for future trial is not before the court. It's about the prejudice, and there is some, and I understand it, that the solicitor suffers in calling witnesses today, but we suffer from a lot of that too, and that's where the clean hands and the distinction between void and voidable judgments comes into play. And to the extent that the standard is there, it's only reasonableness is a de minimis standard, and this family, under their circumstances, about which there's abundant evidence in the record and in testimony, I don't think you can say they've been unreasonable in the way they've proceeded.
Okay.
Thank you.
Thank you. Mr. Finney, I'm going to go ahead and let you respond if you'd like. And
Please, court.
yes, sir.
Your Honor, in the current case, the party withstanding on this matter was George Stinney. And although it may sound harsh, the fact remains that he's the only person possessed with the legal ability to claim standing to challenge the conviction and his right to present evidence. Standing requires that the party bringing the action suffer an adverse impact on their own rights, and that there is no one able to provide that in this current case. We
Continue, Mr. Finney.
In some of the research done preparing for this matter, we came across a case on abatement. And the abatement issue clearly, under South Carolina law, seems to say that once a person has reached their end of their life, the legal standing to request certain relief ends at that point. We thought that this might be an abatement issue as it related to the motion that was filed under 29B, only to be met at the courthouse door with the quorum novus argument. I would say, Your Honor, that the quorum novus argument cannot succeed in this particular instance because it is not a defect in the record caused by some type of judicial or some type of malfeasance. The only reason we have a defect in the record is because the court met its duty, concluded its business, the judgment was carried out, and the passage of time began to march. And some 70 years almost has marched by, which has lost for us the record and the evidence and the formal proceedings, so to speak, that would let us know exactly what kind of trial we had. The state at this time does not concede that we had dirty hands at all, either as a solicitor's office, as a judicial office, or as a state in development, because that's what we were in South Carolina in 1944. I would remind everyone here that only 5 years later, in 1949, members of the same Clarendon County community by the name of Delane and Briggs and Frierson banded together as black citizens and brought a petition that ended up being taken down to the federal district court in Charleston, acted upon by a federal district judge where they won initially. That was appealed to the Fourth Circuit where they lost, and that case was taken by Thurgood Marshall and other lawyers to the United States Supreme Court, ending in a ruling in Brown versus Board of Education. That happened in Briggs versus Elliott in Clarendon County in 1949. I am, as a student of history, very concerned that the Stinney family takes the position that there wasn't any help available to them in 1944. I'm not saying that I was there, and I'm not saying it wouldn't have been difficult. But I am saying that I believe a concerted effort on their part and the part of other friends and family members would have been able to give them what they felt like they didn't have. Now, they did have a lawyer, Your Honor. They did have a judge and a solicitor. They did have a 12-member panel. By all accounts, it wasn't of the same race, but by all accounts, that wasn't a historical anomaly at the time in 1944. We have cases today that Your Honor hears on a routine basis where the defendant elects not to take the stand, where no evidence is presented. This was a double murder of two little girls who were out doing what little girls do on a spring afternoon. It was a horrific crime. It would appear that based on the evidence that we have in the record, the investigation led to George Stinney. We don't exactly know why, but it did. And after that, we are told that there was a confession, which included the finding and turning over of the murder weapon, and that a trial, not the next day or the next week, but 30 days later, a trial occurred in Clarendon County. During that period of time, he was appointed not one, but actually two lawyers. And that even though the trial was very short in duration, it did end with a verdict. And two things that I want the court to remember about this set of facts. Number one, the jury had an opportunity to, my understanding, to return a recommendation of mercy so that the judge could not sentence to death. And I want the court today to realize that the imposition of the death penalty was a critical factor in this trial, but it's not the only factor, and it certainly did not color the trial that preceded it. The fact of the matter is that the judge did what he thought was required under the facts of the case. That shouldn't taint the fact that the trial occurred and it occurred properly. The other thing that I want the judge today, Your Honor, to remember is that apparently the investigators weren't in such a hurry that they ruined two little lives of black men. Johnny was taken into custody, interrogated, and released. By their own witness, he was released an hour later. I'm not sure that's correct. I believe, based on what I know, that it was probably a longer time later. But the fact of the matter is they weren't trying to railroad every black person that was associated with Alcolu and these little girls. They made a determination based on facts that we don't have today that George Stinney should be retained and dealt with by the legal system and that Johnny should be released. Your Honor, reasonable diligence, my co-counsel in his learned effort, he used the word unreasonable, referring to the Stinneys. But the word really is reasonable diligence, and he needs to turn the mirror of his argument around because it wasn't reasonable. As I have said earlier, by 1954, this community would have been able to bring a challenge by the NAACP or some other like group. Certainly by 1974, when we had African Americans serving on the circuit court bench in this circuit alone, we would have had opportunities to have review. The problem is that the prejudice is not to the Stinneys, the prejudice is to the state, because we have to defend the action that took place in 1944, which means we need to have our witnesses. As our testimony took place today, Mr. Pratt was alive and living in South Carolina. He was the governor's special investigator that was sent down here. We don't have testimony as to when Mr. Newman passed away, but certainly these men and other witnesses in the case would have been prepared and able to tell a judge sitting in review what happened and what the missing pieces were. We think that it is a clear denial of our due process to rest on the judgment for them to come forward now and say because a 14-year-old was executed, which is the second phase in my argument of this claim, not the first phase, that his due process was denied. We are still looking at this case through present sense interpretations of law. We're using the rules that we work with today to evaluate a case that happened in 1944. I do not believe that we have clear and convincing evidence of a void judgment. We do have evidence that a man served on a coroner's inquest, and that same man may have had his name as one of the significant number of people who was on the grand jury. We have no evidence that he passed judgment and voted for the indictment. It is clear from his name being struck from the indictment in the records that he did not testify. Well, at least it's clear to me. I'm sure there's an argument about it, that he did not testify at the trial. We don't have any record that he participated in the trial proceedings, and we're certainly clear that he was not one of the 12 petty jurymen who returned a verdict in this case. Your Honor, we would take and appreciate the opportunity to brief this matter so that we can do some more research, but we would contend at this point that there has been a failure of clear evidence to move the quorum nobis argument forward, and we would ask the court to keep the matter as it is now, keep the record closed and the judgment intact. Thank you.
Mr. Shealy, do you want to respond briefly, or are you comfortable to sit?
You know, one moment, please.
Yes, sir.
Just a couple of things, Your Honor.
Yes,
if I
sir.
may, not to belabor the point.
Yes, sir.
I respect Senator Finney's argument, and I respect the very difficult position that he is in today. However, the standard here is, I think, under quorum nobis by preponderance of the evidence. I think that where reasonable diligence does apply, there are only two findings. One was reasonable, or one was unreasonable. I don't know of an in-between, and the court can search Merriam-Webster's, the Oxford English Dictionary if it wishes, but that's it. To find that one was not reasonable is to find that one is unreasonable. I think that's just common usage of words. And I don't think that there's anything unreasonable about how the Stinney family has proceeded over the years, given all the facts and circumstances of this case. And I would just say one last time, you have before you in the record, whether you rule today or rule later, you have before you when things were really done in terms of who did the research and who did the findings. And we think it's clear. Novelizations in TV movies, whatever they're worth as entertainment, are worth nothing in the courtroom. And the only real thing that we see in the record is what Mr. Frierson did as of 2004. And that's when it started, when he first dug up some serious, not completely, but some serious evidence that makes a difference. So for those reasons, unless there are no further questions, we would ask the court to please grant the motion for quorum nobis and vacate the judgment of conviction in this case.
All right. Well, I don't want to prolong this proceeding anymore. We've obviously been going for almost 2 days now. We do have other matters to take up. I do want to give the state an opportunity, though, to brief for me quorum nobis. It was something that was proceeded on late, and I understood that because we did have a term of court, this was not a special term of court, this was just me being assigned here, that we wanted to go forward and have the hearing and present what we could. I think also the state needs an opportunity, if they would like to potentially rebut. You can sit down, Mr. McKenzie, until I'm done. That we will give the state the opportunity, if they would like, to rebut the forensic pathologist statement, Dr. Stevens, and also the forensic psychiatrist, if the state wishes to. Again, that is up for you to determine, Solicitor Finney. Additionally, I would leave the record open for any possible amicus briefs. Obviously, when this gets news media and coverage, other people become interested. It's how you have been able to garner new witnesses, or witnesses come forward. So we would leave it open for a brief opportunity. And again, I think that's important. We need to put a deadline. What kind of deadline, Solicitor, would you like? I know it's...
I don't think that 10 days would, I don't think we couldn't accomplish what we need in 10 days, Your Honor.
Okay. I will go ahead and give you 10 days as far as briefing is concerned as to the quorum nobis issue. If you do feel it necessary to engage, again, a forensic psychiatrist or a pathologist, I'll give you certainly an amount of time to do that with certainly some opportunity to cross-examine, and hopefully that can be done.
Your Honor, please, may I ask, are we now proceeding singly? Has the court ruled on the 29B?
Have you given up your Rule 29B motion, Mr. Shealy?
I would ask the court, since you're holding the record open, like you indicated, there's no reason to rule on that until you have your deadlines met.
Okay.
I would ask you, I don't want to ping pong this back and forth. Could we have 10 days to reply if we see fit? Since we're the moving party, we had to file, they have to respond, and normally one gets a reply, so.
Certainly.
Thank you.
Certainly. Okay. And then again, if you need further time or anything you need, solicitor, you can certainly request it, and I'll consider it. All right. And for the rest of you that have come here, I want to thank you all for being here. I think one of the problems that originally this trial had was whether or not someone felt like they had their opportunity to fairly present the case in court. Whether or not it was or it wasn't, again, right now that's not for me to say, but rather I think everyone has had an opportunity to say their piece, say their feelings, and I appreciate that, and I want to commend certainly the lawyers on behalf of the Stinney family and the solicitor again for representing your parties diligently. And I want to thank everyone for being here and appreciate y'all. For those of you that are here for the afternoon session, we are going to start back up in about 15 or 20 minutes. We do have other matters to take up, ladies and gentlemen. So we will be at ease. My understanding is the deputies have been taken care of as far as lunch is concerned, and we can go ahead and go forward. Is that correct, gentlemen? Yes. All right. Well, thank you. In this matter, we will be adjourned.
Thank you.
Thank you. Sure.
I just want to read to you, Janetta the bailiffs has had a new memory.
Okay, so they need to use.